but they've still not entered appearance. And the matter is item number 147 in the monthly list, if that can be upgraded.
Have you obtained report?
Yes, there is a report.
When the notice was served? When the writ of summons was served?
The writ of summons were served on 5/2/2025, 5th of February 2025. And there was another service which was made on 25th March 2025. Even though that service was not proper, matlab from the bailiff's end only, but the first service has been done. And there is a report also. I have the originals with me here. These are the originals.
Is to be mentioned. Is a commercial?
Commercial.
To be mentioned.
And there is some admission also in the matter.
Admission?
The account statements and everything are there.
Their document.
Documents.
Okay, let it come tomorrow as to be mentioned. I will speak to that.
My lord, may I permit to mention one application for inclusion in the list under heading chamber application?
For what?
Or challenging the execution application.
Challenging the
execution application arising out of from a decree.
Okay.
I was not the party in the suit. That's why I have filed this.
You are appearing for?
I am appearing for a no response is there. Subsequently, it has been admitted.
Notice was served.
Notice was served.
Execution notice is issued upon you.
Yes, my lord.
The commercial matter.
Commercial matter.
Day after tomorrow. Commercial, non-commercial. Suit is dismissed.
I'm grateful.
Commercial, what is item number 1?
Malak. I'm for the plaintiff. Malak.
This court held that the player C, D, and E is barred by section 41B. But with regard to the other, considering the defendant number 1 is directed to receive the amount of 1 crore so and so, being the 1/4 share from the plaintiff within prior 30 days from the date of the judgment, failing with the plaintiff is directed to deposit the said amount with the registrar or the side of this court within 2 weeks. If the plaintiff deposits the said amount, the registrar shall invoice the said amount in the interest-bearing fixed deposit receipt with any nationalized bank and to keep the same in safe custody till the defendant is received the said amount. So it is disposed of. Head.
My lord. This has come at my instance.
My lord, on behalf of Mr. Somnath Gangopadhyay, I'm taking a short partial. He's on the way, he's coming.
Lordship.
Yes.
Lordship,
short partial on behalf of Mr. Somnath Gangopadhyay, he's for the judgment.
Why to be mentioned? Who mentioned the matter?
My lord, this has come at my instance. My
yes.
Lord. This is execution case, my lord. In the when the examination was of the judgment debtor was being conducted, the judgment debtor had undertaken to pay the decretal amount in 6 equal installments, my lord, and he has paid only 1 installment in September. We had mentioned the matter earlier, and it had appeared last sometimes in March, and there was a direction for the matter to appear as for further examination of the judgment data. My lord, now they have paid only 1 installment and there's a specific undertaking on their part. Now, this is the position, my lord.
So what you want?
My lord, I let the judgment data be called for further examination. That's a
Yes, who is appearing?
Mr. Somnath Gangopadhyay for the judgment, but he is coming from that bill.
Huh?
I am praying for short password. He is coming, my lord.
No, it is to be mentioned, so I am fixing. Let the matter appear in the list of execution case. Manutosh, इसको execution case में लिया.
My lord, let it be given some precedence, my lord.
What
Because
precedent? If they violated, they will face the consequences. What precedence? All cases are having a precedence, sir. If he has violated, it will come under the execution case. When the matter will be taken, I'll pass appropriate order. Let the
Number 3.
Or in this matter, my lord, I am appearing for the plaintiff, my lord. A defendant's witness is been carried out, my lord, through commission, my lord.
Lordship has appointed a commissioner. Now, my lord, on 2 occasions, my lord, the defendant came and deposed.
Now, several adjournments has been taken by them, my lord.
you are appearing for whom?
Plaintiff.
Now,
Yes.
my lord, what happened on the first occasion? Chief was done, cross-examination was done. Second occasion, cross-examination was carried out.
Hmm.
Third, my lord, the last date, my lord, the witness could not appear, my lord. My lord, he appeared, my lord, but after some time, the time was fixed at 4:30. He appeared
My
at
lord.
6:30. So the sitting was adjourned. So, my lord, we need a short extension, my lord, of 2 weeks.
My lord, several
When
times.
the matter is fixed at 4:30, if it will come to the 6:30,
Yes, my
I
lord,
have
they have
informed-
taken
I have informed
several
previous-
times, my lord, adjournment they have taken, my lord. These are
Let
the
me complete.
emails.
I have informed the commissioner and the other side, my lord, on the previous day that I have also produced the ticket. The flight rescheduled. So he came 2 hours late, my lord. That is the difficulty. My lord,
My lord, the another
how many witnesses are there?
one witness.
Cross examination is going on.
Yes, my lord.
my lord, only 1 day is required. So
What you want to show?
My lord, several adjournments, my lord, this is an email, my lord. Several times, my lord, date was fixed, my lord, and they got rescheduled, my lord.
my lord,
Defendant
three
does
days
not
that
appear.
I can show these are the trail mails,
7
my lord.
sitting, my lord, 10
There were
sitting.
several trail mails. My lord, 3 dates were fixed: 15th July, 17th July, 22nd July.
Or thereafter, 22nd July got
Where
cancelled.
from your witness is coming?
My lord, from Siliguri.
Siliguri.
My lord, a week's time was given, my lord, so that the witness can stay over and give examination, my
Yes,
lord.
we stay.
15,
And
7,
your witness will be
22nd.
available.
My lord, kindly grants us 2 weeks extension, because what?
No, I am fixing a specific date when your witness will appear. Otherwise, I will close your cross
Yes.
examination.
Then let me take instruction. Let the
What? You are mentioning the matter without taking instruction. Why you are mentioning the matter?
This has come, my lord.
When you are mentioning the matter, you could have been taken all the instruction from your client. When your client will be available, when your client will come before the court, before the commissioner, when the cross examination will be done.
Today, my lord, the direction-
Simply, you are asking the adjournment from extension of time from the court.
Today, my lord, the matter has been fixed, my lord, for submitting of report.
Correct.
My lord, we have to take instruction, my lord. on
Okay,
this.
come tomorrow.
Lord,
Taking a specific time.
I shall
Specific.
talk to the commissioner as well as the witness.
Yes.
Lord,
Okay, take. I will fix a specific date and time.
Lord,
Not today.
Great.
My lord,
plaintiff, my
my lord, may I be permitted to file my report?
Yes.
The examination is complete. I'm also handing over a copy of my report to the plaintiff.
Undefendant.
Undefended.
My lord, we had only one witness. Examination is done. My lord, kindly fix it for hearing of the.
Remuneration paid.
Everything is paid.
London Advocate Commission has filed the report after serving the copy to the London Council for the plaintiff. Let the same be cut with the record. Counsel for the plaintiff submit that he will not adduce any further evidence. Accordingly, evidence on the side of the plaintiff is closed. Full stop. The plaintiff has already paid the remuneration to the London Advocate Commissioner. According, commission is discharged from the instant case. Full stop. Let the matter appear for argument on commercial. Na? 6th August.
Grateful.
And may I be discharged?
Discharge already.
Grateful.
Grateful.
Number 5.
Item 5, Your Lordship, I appear on behalf of the defendant number 2.
My lord,
This is coming up. This is coming up at my instance, Your Lordship.
answer short pass over.
Lordship, not required.
Let me see why he has mentioned the matter.
Your Lordship, the only reason I've mentioned the matter is, Your Lordship will recall I had mentioned, Your Lordship, the Wakalatnama is from a client based in Delhi. The notary, though not required, was of 9th of July. But Your Lordship, my learned advocate on records clerk, while filing the Wakalatnama, the date was blank. He's filled in as 14th of July, which is the date of receipt in Calcutta. Because of which, Your Lordship, the master is not accepting my master.
It was listed on the last occasion.
Lordship, I had mentioned it on Friday. Your Lordship was pleased to direct it to appear today as to be mentioned.
Okay.
Your Lordship, the only problem that I'm facing is because of this, Your Lordship, I'm unable to file my master summons and my written statement. I'm in my additional 30 days, the last 30 days for filing of the written statement. So if the only leave or the direction that I'm seeking is, Your Lordship, the master to accept my Wakalatnama so that I can file this.
When the Wakalatnama was affirmed?
Your Lordship, it was affirmed on 9th of July. Your Lordship, before the notary. Your Lordship,
you have accepted on 14th.
Your Lordship, it was posted and it was received in Calcutta on 14th. My Lord advocate on records clerk, since it was received on 14th, had put the date of 14th. Because of this discrepancy, Your Lordship, I'm unable to file my application. Lordship, the Wakalatnama, though accepted in the directory, Your Lordship, the master is seeking.
Yes. Any objection?
No.
The matter is listed as to be mentioned on the prayer made by the counsel for the defendant. Full list. Counsel for the defendant submitted. The office of the defendant is at Delhi.
Defendant number 2, Your Lordship. Defendant number 2.
Defendant number 2. Defendant number 2 कर देना. Counsel for the defendant number 2. The office of the defendant number 2 is at Delhi, and the defendant number 2 has affirmed
Wakalatnama and competency, Your Lordship.
Affirmed Wakalatnama and affidavit and competency before the notary public on 9th of July 2025 at Delhi. The same was received at Kolkata on 14th of July 2025, and accordingly the learned advocate on record has put the date in the Wakalatnama as well as competency, both.
Lordship, competency, it's okay in the Wakalatnama.
The Wakalatnama as 14th of July 2025, due to which the department has not accepted the said Wakalatnama, and counsel for the defendant number 2 prayed for clarification of the same. In view of the above, this court find that though the Wakalatnama was affirmed and signed by the defendant number 2 before the notary public on 9th of July 2025, but the same was received by the advocate on record at Calcutta on 14 July 2025. Accordingly, the learned advocate on record had put the date on as 14 July 2025. In view of the above, this court find that in view of the above, the court is granted leave to the defendant number 2 to file the Wakalatnama along with the affidavit of competency in the department, and department is directed to accept the same in course of the day.
Grateful, Lordship.
My lord, defendant number 2 has entered appearance, but with regard to defendant number 1 and 3, none has entered appearance, my lord. Service has been effected upon all the defendants. The time to file the written statement has also expired. 30 days time has expired. Now it's the extended time if they apply for. Now, if they don't apply, my lord,
when it was served.
My lord was pleased to record by order dated May 5th, 2020.
I will take up your lordship's order.
It was served on 25th of April.
25th of April.
April.
15th of April. Defendant number 1, 15th of April.
My lord,
15th April. No, so 2 and 3.
2 and 3, 15th.
2 and 3 together has been served.
And what about the 1?
My lord,
1 also served.
1 served, my lord. I have obtained a report from the registry, my lord. They have not yet entered appearance.
When all the 30-day time period has elapsed, my
When
lord.
it was served.
May I hand over a copy of the report, my lord? Appears to be served on 20th of June.
20 June. So there is a time of 120 days. Let it be.
My lord, for 1, but for 3, my lord, it is.
Let it come on then. Let their affidavit. Then matter when the next matter will be appeared. If they will not come, then I'll pass a note.
Grateful, my lord. Grateful. My lord is keeping the matter on.
When the matter is fixed.
My application in any event will come up on the next week.
Well, that can come up with regard to defendant number 2, but with regard to defendant number 1 and 3, my lord, we have to take steps.
Let the matter appear on 12th August.
Grateful, man.
Next.
But 11 to 14, I appear for the plaintiff. But
This matter, I appear for the defendant.
in GF4, my lord, may I file my affidavit in reply? She had extended the time.
11 to 14?
Yes, my lord. There are 2 applications in 2 suits. 11 and 12 are my applications.
And 13 and 14 is my application under Order 7, Rule 11.
And with regard to 1 and 11 and 12?
11 and 12 is my application for interim reliefs. The earlier Lordship had passed an order granting interim protection. Thereafter, we had found out certain other bank accounts on which, and one other immovable property on which, we had sought for protection. Lordship had been pleased to pass directions for affidavit. I have served my reply. May I file the affidavit in reply in those 2 applications, GA4?
My lord, I have already filed my opposition to their GA4, my lord. In my opposition, I have indicated some properties whose value is almost like 1 crore 4 lakhs, and the aggregated amount which the plaintiff are asking from me is 74 lakhs and 20 lakhs, which collectively makes around 96 lakhs. My lord, the only business account which I am running right now is injuncted. So, my lord, if that injunction is not vacated, then, my lord, I have not been able to run the business.
Which property you given the details? Having the 90, what is the total amount you are claiming?
Well, in the suit, I have claimed around 2 crores, but the principal amount is 74 lakhs.
74 lakhs.
74 lakhs
And in the other suit, 20 lakhs. Lordship had considered the principal amount at the stage of the earlier application. Now, my lord, they have disclosed a particular property which they say is not encumbered, not mortgaged to anyone.
Well, under affidavit, I am stating that it is not encumbered and it is a G+3 building.
But the only difficulty, my lord, I'll tell my lord, on the last day, submission was made that the property is not owned, not in the possession of the owner, and there are certain tenants occupying certain flats. But in the report, in the document which they have annexed, that is a valuer's report. It's not an official report, or no circle rate is there. No circle rate of no government valuation.
Where the property situates?
In Jaipur, my
Jaipur.
In Jaipur.
You are not obtained the government valuation?
No, they are supposed to. They have not. But I have only
obtained the government valuation. That all the things are available online now, I think so, nowadays.
But if the property is worth more than my claim in the suit, I have no difficulty. To that extent, Lordship may injunct.
And my business account, because otherwise, if I don't
that's
run
correct.
the
That's
business
correct. No problem. But where is the valuation report? Which page?
2 valuation report. One is the annexure B.
Which GA?
The GF4 Lordship takes up in any of the suits.
GF4?
Yes.
Yes.
And the affidavit opposition filed by the defendant.
Yes.
My lord, if you just see page number 41 to 47.
41 to
47. That is the valuation. I'm just
41 to 47. Engineer Satyadev Pandey. This is
private valuation made. That is the
flat number 409.
Yes, ma'am.
4th floor, plot 6, Kamal Apartment, Jaipur.
The entire land is mine, and in the land there is G+3 building. So the valuation should not be.
Well, valuation is only of the flat, not of the land. It's only of the flat that is given.
My lord, is a registered government valuer. If you come to page number 54, that is annexure D, you see the letterhead. It's written.
So it is 1 crore 2 lakh 16,000.
Correct.
That is only one flat. That is one flat. Flat number 409.
Yes.
Come to the page 43.
My lord, I am talking about annexure D, page number 54, my lord.
No. Your annexure B is the valuation report of the property in question, which you are relying upon. I think so.
My lord,
Yes.
relying upon Annexure D, page number 54.
54.
Yes, my lord. Which is in the name of defendant number 2, Ranjana Karnani.
50 starts from 52.
Starts from
54 is the part 1. It starts from 52, Annexure D.
It's Annexure D, my lord.
No, no.
It is a registered government valuer.
Borrower and the owner, Ranjana Kumari.
Ranjana Karnani. The
Huh?
defendant number
Karnani, sorry.
Yes. Defendant number 2.
This is the defendant number 2.
Yes.
Okay. Commercial shop, 67, 68. Taluka Jaipur, commercial plot, 67 scheme.
But if you come to page part B of the valuation of the building, it's written basement plus ground floor. Page 57.
But perhaps the lordship is looking at the other suit. Well, we'll indicate the page there.
Part A, valuation of the shop. That's a shop room, 10 by 10.
And the part B is the valuation of the building.
Part B, valuation of the building. What is the total value of this land, and this total property belongs to you, or only this shop room belongs
No,
to
my
you?
lord, the land belongs to me.
Where is the landed land's total cost of the land?
My lord, page number 60, the land value is 71,99,280.
60.
Yes, my lord.
60 is photograph.
No, my lord, lordship will take 55. My lord, the valuation of the shop is 71,99,280.
Building's value is
Page 55, lordship takes of the affidavit.
55.
55. The part of the report. Lordship has part A.
71,99,000.
Yes, that is the valuation of the shop. And lordship will see the serial number 2, total extent of shop, 44.44 square
feet.
It's a
Yard.
Nearly 200 or 250 square feet.
That's why I'm asking. If you're telling that it is a total land,
My
so
lord,
where is the
if
land?
you come to
Where
page
is the
number 61, the total valuation is 1 crore 2 lakhs 39 61.
61 is a map, madam.
59. Well, she's referring to the other suit where it will be 59. Well, the same contents.
The fair market value of the property is given, my lord.
But here also it's 58. Lordship is, if your lordship takes 58, abstract of the entire property, land is 71, whereas the land of that was the commercial. This valuation report, well, it can't be relied on. Well, let them bring any the circle rate or the
government
valuation.
registered.
Correct. But it is discrepancy. Kindly come to the page 58. 58, it might be your 61. Correct. The land is 71,99,280 and building is 30,40,000. Correct. Now kindly come to the
55.
$55.
Yes, my lord.
Might be a 53 or 52. Got it?
Estimated value of the shop.
Valuation shop.
Yes.
Kindly come to the estimated value of the shop 71,99,280.
That is the valuation of the shop. That is a commercial space. Now, if you go to valuation of the building.
How it can be? Shop and the building will the same value. How it can be?
Let them bring a government
You do
valuation
one
to their official
thing.
website.
You obtain a report from the government from the website. What is the total market value as on date of the building? Whether the total land is recorded in your name or only the
Total land is
so
recorded
where
in
is
my
that property? Where is that record?
My lord, that deed is in Hindi, my lord. Just give me some time.
No
Government
problem.
records will be evident. They can take out from the official
No,
website.
if it is a deed, but it would have been mutated in your name in the revenue record or
lord.
the municipal record.
I have the deed, but it is in Hindi.
Come when you will come?
I can come at 2 o'clock, my lord, today.
Come tomorrow.
My lord, the only difficulty I am facing
Correct. That's why I'm asking you come tomorrow.
I have not been able to.
You come tomorrow with a supplementary affidavit disclosing the record of rights. you are the recorded owner, and what is the present market value of the total property, land and the shop. Shop you are given this. What is the total property? What is the area of the total land?
44 point.
No,
That is the shop. 44.44 square yard. That is the shop.
No, my lord, that is.
Total extent of shop. Kindly come to the page 55.
My lord, this is the. I have taken specific instruction from the client. 44.44 square yard is the total land, my lord.
On
Can't
250
be.
square feet can't be a land.
It is. It's
44
a shop.
I
It's
also had
a
the
shop.
same doubt, my lord. If you see the plan, in plan also it is written area is of 22.22 square yard. Page number 65.
Kindly come to page 52. Page 52. Your valuation report starts. Plot number, commercial plot number 67 and 68. That is the plot number. And this is the shop number. 44.44 square feet is the shop area.
Commercial area is 44.44 square yard.
Let them come tomorrow
Come
with the
with
official
the total
document.
details. Come tomorrow with the supplementary affidavit as per the prayer made by the counsel for the defendants. All defendants.
All defendants.
Let the matter come tomorrow. Let the matter appear tomorrow. The defendant is directed to file supplementary affidavit disclosing the present market value issued by the government of Rajasthan and who is the recorded owner of the land in question in which the shop is situated.
Grateful.
Malad, the client Malad is in Rajasthan. Perhaps Malad, in one day this may not be possible.
He is telling that 2 p.m. she will give. She told me that
The document can be given, but if it has
only
to...
two things I required. See, you have given this valuation report.
Yes.
That valuation report, one place it is showing that the shop 44.44 yard.
Malad, because Malad, that's the size of the Malad
Shop room. Whether the total land is in your name.
Malad, we'll show the deed.
That's why.
Malad, the deed, Malad, we can show at 2 o'clock, but if it has to come in the form of an
Come in the form of an affidavit. No, valuation, you put take the valuation from the government. What is the government valuation?
Malad, to sign, affirm an affidavit, Malad, because the client is
so when you will
Rajasthan. 2 days.
But we have our injunction, we are suffering injunction.
But can you file an affidavit tomorrow?
There is a power of attorney.
Malad, then my friend is confident, Malad. Kindly keep it tomorrow. Because each day, Malad, is causing a loss. That's
correct. That's why I also.
Very well, Malad. If my friend is confident, a client can come, Malad, then no.
Come tomorrow.
Item number 15.
My lord, in 15, I appear for the defendant petition. My lord, can you allow me to appear virtually in this matter, my lord?
Yes.
There are two GAs appearing, my lord. One is GA number 2, which is for summary judgment, my lord, by the plaintiff petitioner. GA number 3, my application, my lord, by the defendant number 2, my lord. That my prayer is for striking off my name because, my lord, I happen to be director of the defendant number 1 company. It is a case of money lent in advance. Admittedly, my lord, the money has been lent to the first defendant. And I have been made a party only because I happen to be one of the directors of the first defendant company. But my lord will scan, my lord, I have annexed the copy of the plate, my lord. In fact, my lord, there are some annexes which are not legible. My learned friend junior is carrying a hard copy of the plate, my lord. Kindly see, let them indicate any document by which they can show, my lord, that the defendant number 2 has any liability in this matter. It's not a case that I'm a guarantor.
You are appearing for
in this petition, I'm appearing for the second defendant, which is the petitioner.
GA number 2.
GA number 3, my lord. GA number 3.
I thought your application for extension of time was in the list. I thought their application for extension of time to file the written statement was in appearing.
Strike the name.
GA number 3 is my GA for striking off the name of the second defendant from the area of parties.
Yes.
I invite my learned friend to show any document or any averment from the plaintiff from which it can be shown that there is any joint or several liability.
Who is
The
the
loan has not been given to.
You are referring
No, no.
I appear for the plaintiff.
Yes.
Lord, may I file a short
Because
affidavit?
I've signed some documents. But it's a demerit application on the face of the plaintiff. Let him show if there's any allegation against me, or any document from which he can show that I have taken the liability, or I have been given the loan. Only because I happen to be a director, I've been made a party.
Yes. How the defendant number 2 is concerned? Where is the pleading in the plaint, sir? Where is the pleading against the defendant number 2?
Let I'll come to that. Look. There's in paragraph 6, there is there, but on behalf of the defendant number 1.
I've signed on behalf of the defendant number 1. Some letters.
Not even without affidavit, my lord. Lordship will kindly keep it any day, my lord. Tomorrow also, my lord, I'll come back and
Not
add to
ready.
the matter. Lord, this one I was, Lord, I missed this.
Very well, madam.
Okay, come to
The GA2 is there, my lord. That is for their application for extension of time to file their written statement. I'm not objecting.
Both applications.
Both may be heard tomorrow.
Automatically, that will be infractuous. If it is
Yes.
On behalf of defendant number 1. Yes, so that will.
So that's for.
Not today.
No, there is one more matter, connected matter, but it's similar matter, item number 39. That can also be taken up tomorrow in that evening.
39.
I'll just give the number.
33. Item number 33.
33. 33, yes. So both can be made, not today.
Counsel for the defendant submit that. Defendant, both defendant submit that. Item number 33 being CS Com 717 of 2024 with GA Com 5 of 2025. 33 Anuban Finance.
Yes, madam. Yes.
Also connected.
Similar facts, similar application.
Connected with CS Com 7674 of 2024. In view of the above, let both the matter appear tomorrow.
Very well.
Item number 16.
Finally, I'll get to move my application.
Lord, I appear on behalf of the respondent number 1.
My lord, may I, before taking your lordship to the papers, just give your lordship a bird's eye view of the matter. My lord, the application is filed in a suit for delivery and cancellation of a loan agreement. Now, the loan agreement had the digital signatures of the plaintiffs and no physical regular signature. My lord, on the basis of those digital signatures, which were obtained by fraud, and which would be the subject matter of outcome in the suit, my lord, whether we are able to sustain that or not. My lord, those were taken by using the OTP given, and we had pleaded why we used to give OTPs, because my digital signatures were required for a lot of income tax filings and other. On that basis, loan amount was disbursed to the main company. I think possibly for whom my learned friend is appearing. It is not for the main. No, then very well. Now the main loan has been given to that company. I am a minuscule shareholder. I have not derived any benefit, nothing. But I have been shown as a co-borrower. That is one. The second issue is this loan agreement, the amount disbursed has been squared off. Documents have been issued by the concerned financial institution, the defendant number 1, that this loan amount has already been squared off. Despite that, a further remittance was made to the bank account of the principal borrower, for which really we have been hauled up. Well, this issue was already adjudicated by a coordinate bench in a Section 9 application filed by the financer, where they had arrayed as a party also, and the Honorable Court dismissed the Section 9 application, saying that they do not have a cause of action. On these facts, we have come up before your lordship, principally in the interim stage, for one relief which is really affecting my other businesses, which is the reporting by the defendant number 1 with the CIBIL which has really got my CIBIL score down. That's a menace now. So that loan account is being shown as outstanding, which is really taking a major hit to my CIBIL score.
So your contention that there is no loan amount is pending.
There is no loan amount pending.
And they have taken the benefit of this digital signature.
Digital signature. Now, initially, taking the benefit of the digital signature, they had remitted the money. Though I have not taken the benefit, I am a shareholder living elsewhere, but they have remitted the money. That money has been repaid by the company. I shall show from documents that those have been repaid, the interest charges have been waived, that account has been squared off.
So how they are claiming this amount now?
There has been a further remittance where I had nothing to do. No new loan account, no new agreement where I have signed, nothing is there. So even if at the highest,
that further remittance, how they are claiming, when this
to that account of the company, they have once again remitted.
Okay.
But I say that at that point of time, the initial signatures were not with my consent for this purpose. Even if your lordship thinks that, okay, there is a signature, it might so happen. But the second time when that remittance was made, I had nothing to do. And before that, the account has been squared off. So any which ways, my lord, my loan account or my name cannot be said to be a defaulter, and there cannot be a complaint or a reporting with the CIBIL. So today my application is really restricted in a suit which is ultimately for delivery and cancellation of this agreement. But as of now, I only restrict my prayer really to the CIBIL reporting, because that is affecting my overall business. That is the whole issue. Why? May I straight away draw your lordship's attention to the CIBIL report, and thereafter I shall take your lordship back to the. But if your lordship kindly takes a look at page 300, which is the last page of the second volume. But it really should start from 298. I'm sorry, 298.
Yes.
This is plaintiff number 1, your lordship. Kindly sees the CIBIL score, 673.
Yes.
But this is, kindly see the date at the top right, 6th of May 2025.
Yes.
If your lordship kindly turns over to page 300, which is the last page of this volume, your lordship would find the name of the defendant number 1. Kindly sees, on the top left, your lordship would find the defendant number 1's name. Kindly sees the sanctioned amount and the balance.
Where?
Here the top left is defendant number 1 at page 300. Ugro cap, your lordship would find. Has your lordship got it,
Yes.
And your lordship would see there's a table after that where the sanction limit shows 2 crores, current balance shows 199 for 44,000. And kindly sees the third entry or fourth entry from bottom, date reported and certified. It is 15th of April 2025. This is what really hampers me. And I can show for the other defendants also, but I'm just showing as an example to your lordship why I had to come before your lordship.
Yes.
But because otherwise, my lord, they did not get an order in section 9, I was happy. I was sitting idle. I didn't do anything. But I had to come running to the court only for this reason. Now, if your lordship kindly. Now, your lordship would, and this is there for all the plaintiffs. If your lordship so desires, I'll indicate the page numbers, my lord, from the third volume. Your lordship need not, my lord, be troubled, because all the plaintiffs have this Ugro capital as the outstanding which is there. Now, my lord, if your lordship kindly takes a look at the loan document, which really was used against me, kindly sees page 46 of my application, the first volume. This is all these are annexures to their section 9 application. The section 9 application, my lord, starts from page 25. From the section 9, we got to know of this everything. Page 25, the section 9 application starts, my lord. If my lord is pleased to take a look at that, my lord.
Yes.
APCOM number 39 of 2023.
Yes. This was filed by whom?
Filed by Ugro Capital. Kindly sees the name of the petitioner at page 25.
Yes.
Ugro Capital Limited. Your Lordship would kindly turn to page 26. Your Lordship would find the plaintiff number 1 is the respondent number 4 there. And the others are also there, my lord. It goes on to the 6 respondents. Respondent numbers 5 and 6 are the plaintiff numbers 2 and 3. Now, to this, the annexure at page 46 is this sanction letter, where your Lordship would find at the bottom there are certain digital signatures which have been, my lord, which would be evident, my lord. Bottom of every page, my lord, digital signatures are there. Now, since it's a photocopy with the section 9 we got, my lord, so the printouts are like that, my lord. Kindly turns to page 50, your Lordship. Your Lordship would find at the bottom of the page again the digital signatures on each and every page.
But I would take the point of maintainability of the suit. So let him cross that hurdle. He is in the merits of the matter, my lord.
You are raising the
Yes, of
maintainability?
course, my lord.
Why you are not raising the point?
Because, my lord, it's a very short point.
Yes.
If he is raised fraud, my lord, there is an arbitration clause. So fraud is to be, my lord, dealt by the arbitrator. Let him show that this is such kind of fraud that it cannot be dealt by the arbitrator, my lord. Then only comes the on merits. Otherwise, Lordship need not hear on merits, my lord.
Then you were very
Yes, he has raised fraud. So let him show this fraud is of such magnitude, because now the Supreme Court is very clear, my lord, that fraud of a particular category will not go. Otherwise, everything goes. This doesn't fall in that. If he can show, my lord, then, my lord, he crosses the hurdle.
Yes.
My lord, may I deal with that point?
Where is the arbitration clause?
My lord, page 53.
Yes.
My lord, clause 15, your Lordship would see at the bottom of that page.
Yes.
But I would say that we are not at all covered by this, and I shall tell your Lordship why.
Yes.
Now, kindly permit me to place only one thing from this volume, and thereafter I shall take your Lordship to the others. But if your Lordship kindly takes a look at, my lord, this agreement, your Lordship would kindly, you can 2 crores deliver. No. Kindly takes a look at page 74. Now, the facility agreement starts from 75. At 81, your Lordship would find at serial number 6 is the amount of 2 lakhs, 2 crores. At 81. No.
Page?
Page 81, your Lordship.
Yes. Schedule 2.
Schedule 2, yes, my lord. Serial number 6, my lord. Your Lordship would find the loan amount.
Yes.
Kindly see at the top of that page the details of the borrower. Borrower is only Bharat Electricals Accessories Private Limited. The plaintiffs are not borrowers. That is A. B, your Lordship would see serial number 3, details of principal of the borrower, Vedanta Limited. Now, this would have some significance, and I'll tell you, Lordship, why.
Where?
Serial number 3, my lord. Vedanta Limited. Has your Lordship got it, my lord?
Details of the principal.
Details of the principal borrower. My lord, this was really this was a bill discounting facility. The financial assistance was really a bill discounting facility in respect of this Vedanta Limited. So, my lord, your Lordship would see that the principal borrower was Vedanta. The borrower is Bharat Electrical Accessories Limited.
Yes.
So, my lord, here I am not a principal borrower.
Yes.
But kindly sees at the bottom of that page, serial number 14, details for notice or communication where I have been named. So I'm really nobody. Communications I have been stated they
Which-
can
which-
communicate.
which
Well,
address?
serial number 14, Your Lordship. I'm sorry.
Ah.
Serial number 14, Your Lordship would see.
Ah.
Borrower is Bharat Electrical.
Bharat is, yes, Bharat Electrical.
Yes. Then Subhash Chandra Gupta, Sushil Gupta, Sunita Gupta, Rekha Gupta, Manmohan Gupta. These are the persons to whom notices would be communicated. Kindly see serial number 14, details for notice or communication. The borrower is not, my lord, my client, not the plaintiff. Borrower in serial number 1 is Bharat Electricals. Communications may be made to me, may be made to XYZ.
Which address you are relying upon?
No, I am saying that I do not feature in this agreement as the borrower.
Correct.
My name only finds place as a person to whom communications can be.
Where from your
Serial number 14.
Serial number 14. You are Bharat Electrical, not the Bharat.
I am not Bharat.
Then?
But I am Sunita Gupta.
Where is your name?
In bold, just below that. Sunita Gupta, your lordship would find. Just below Bharat Heavy Electricals.
Acha.
Sunita Gupta, Rekha Gupta, Manmohan Gupta. Sunita Gupta, Rekha Gupta, Manmohan Gupta. Plaintiff number 1, 2, 3.
They are also there.
They are also there. So, my lord, kindly sees how my names are appearing. How our names are appearing. These are appearing, your lordship, as the notices for receipt of any communication concerning the loan.
No, but it is the heading borrower.
Yes, but no, but kindly sees what is the heading for. Heading is for details for notice or communication.
Details of communication, correct, no problem. Then any notice communication shall be issued at the below mentioned address unless relevant party sends a notice.
Notice of communication with the change.
Borrower. Then kindly borrower.
So attention is borrower. Then my lord, it's like company care of somebody. So I am not a borrower. So they have named all the directors, other persons, whoever are there, as the persons to whom communications can be made. No problem.
How you are connected with the Bharat Electricals?
I have a shareholding.
In the
minuscule shareholding. I have pleaded that my percentage I shall take
the
care of.
Bharat Electrical, you are having.
Yes, I have a shareholding.
Shareholding.
Yes. But I have not borrowed. I am not a co-borrower.
Okay.
Because your lordship would see serial number 1 in that page, top of the page, your lordship would find the details of the borrower. It's only Bharat Electricals.
Correct.
I am not a co-borrower. So because my name features in the agreement as person with whom communications can be made, but I cannot be hauled up for any liability. But it is like a director of a company being made liable for the loan of the company. But I am not a I am not a co-borrower. Had I been a co-borrower, guarantor, anything, still then they could have had a chance. Not in these facts also I shall submit, but then still they could have had a chance.
Yes.
But your lordship would see from page 81, but I am not a borrower. So, my lord, it's not really an agreement which can bind me.
Yes.
So, therefore, the arbitration clause cannot bind me. That is the first leg of my submission to deal with my learned senior friend's point. The second leg is that this agreement concerns a specific loan. That loan has been squared off. If subsequently other loans are being given, then I am not bound by this agreement. Why I say so, my lord? Your lordship will kindly have a look at the second volume. And these I shall show from their documents. Kindly takes a look at page 218, my lord.
Yes.
Kindly takes a look at page 218. Your lordship would find this is a loan account statement.
Yes.
Concerning the loan. Kindly sees at the top of that page, serial number, the entry at serial number 2 towards the middle of the page, application number. Serial number 2, application number 15800. Has your lordship got it, my lord? Serial number 2. The statement, my lord. In this, this portion. Serial number 2, there are serial numbers.
Application number 158.
158, I'm grateful. Kindly sees the disbursement is 2 crore.
Correct.
This is what they have said that which has been disbursed, 2 crore loan agreement, everything is there.
Correct.
So 2 crore given. Now kindly turns to, my lord, page 222, my lord, 222.
This is the loan account of respondent number 13.
This is the loan account of this company with the defendant number 1. Kindly see serial number 281. About 20 entries from bottom, serial number 281.
Waived interest.
Waived interest penal 15800. Then, my lord, credit is 36,10133.64, that is 36 lakhs paid. The next entry is paid against, kindly sees the loan, the numbers, 15800. Everything is against 15800. Again, 25 lakhs paid. So it's 36 plus 25. Then, my lord, serial number 286. Once again, 25 lakhs paid. Then, my lord, serial number 291.
Yes.
24 lakh 50 paid.
Yes.
Now, the waiver of interest happens at 293. 1238 to 12378.
Yes.
Once again, paid is 25 lakhs.
Yes.
And my lord, waiver of penal interest happens at my lord, serial number 298, 29736. And my lord, paid against is 1,50,000 at 299. So all these payments are squaring off the loan account. But kindly do not take my word for that. I shall show the defendant number 1's document, which says it's paid off. Kindly takes a look at page 236.
Yes.
236, your lordship would find there is a heading after my serial numbers 1 to 5, closed tranche. Your lordship would find it is in respect of this 15800.
Page
236, your lordship.
Correct.
Closed tranche. The second row, my lord, this row, my lord, closed tranche. Your lordship would find this loan account number, which is UGD 15800.
Yes.
That is 2 lakhs, 2 crores. Then kindly see everything is zero.
Loan
Principal outstanding 0, interest outstanding 0, penal interest 0, other charges 0. And kindly sees the closing date 31st March 2024.
Yes.
Your lordship would find that in respect of this company, there may be other loan accounts,
Yes.
which are serial numbers 1 to 5. We are not concerned with that, because that agreement also is only for 2 crores. Your lordship has marked that, my lord, the facility. The reporting before CIBIL is also 2 crores outstanding. So, my lord, these other loan amounts are not 2 crores. These are more than that or less than that, whatever it is. Your lordship would find serial numbers 1 to 5 at the top. There are other different amounts, not this 2 crore amount. So other loan, there may be other loan. I am not concerned. They may haul up different number this company. I do not oppose, my lord. Now kindly sees the entries after that, the repayment under the heading repayment. Your lordship would find that all these repayments have been reflected from this also. Kindly sees first is, my lord, the repayments received to 25 lakhs, 2450, then, my lord, 25 lakhs, and lastly 1 crore 50,000. So it's exactly 2 crores repaid, and your lordship has seen the penal interest and the interest have been waived. So, my lord, from this document, my lord, what I can possibly satisfy your lordship is that this loan agreement, which is for 2 crores, has been squared off, paid. Interest, nothing pending. Principal, nothing pending. There may be other outstanding loan accounts of this company. I do not join issues. I do not want any order in respect of that. I'm not concerned. But so far as this agreement where they have hauled me up, this is what is there. So, my lord, in respect of this, there is really no dispute pending. And now kindly sees the
what is their claim? How you came to the court? Why you filed the suit?
Because of that CIBIL report.
Which one?
Well, the one I showed, 298. Kindly sees this volume.
Correct.
They are showing that this 2 crore is outstanding, whereas their own documents say it is squared off.
Page 300.
Page 298. Your lordship would find the name of the plaintiff number 1. Kindly turns to 300. Kindly sees Ugro Capital at the top left at 300. The defendant number 1.
Okay, 2 crore.
Kindly sees the sanctioned amount 2 crore. Then current balance 1 crore 99. This is wrong. There is nothing outstanding. Not a rupee outstanding. So, my lord, they are reporting this to the CIBIL. This is why we have to come. My lord, may I show your lordship with respect to the other petitioners also?
335.
335, my lord, kindly takes a look at.
Plaintiff number 2.
This is plaintiff number 2.
337.
Kindly sees Rekha Vardhan Gupta, that is the plaintiff number 2, my lord. Kindly turns over to my lord page 337.
Page
337, your lordship. Third volume. I'm sorry, I'm really sorry. 337, third volume.
Yes.
Kindly sees 335. That is where it starts. The plaintiff number 2 is there. This is her CIBIL report.
This is plaintiff number 1.
Plaintiff number 2. This is Rekha Vardhan Gupta, is plaintiff number 2. The one I showed at 298 is plaintiff number 1. Now, my lord will kindly turn to page 337. Kindly sees the name of the defendant number 1 appearing.
Yes. Page
337, your lordship.
Yes.
Ugro cap, your lordship would find. Kindly sees the sanctioned amount, current balance. Identical. Same.
Now 356.
Now 355, my lord. I'm sorry, 356 is, my lord, the plaintiff number 3.
Relevant page 360.
Yes. Page
356, my lord. This is plaintiff number 3. Your lordship would find at the left hand side top Manmohan Gupta, plaintiff number 3. Now kindly sees page 356. Your lordship would has seen Manmohan Gupta. Kindly turns over to 360.
Yes.
Your lordship would find Ugro Capital Limited. Then again, amount, disbursed amount, current balance. Identical figures on the right hand side. 360 minute. This here minute. Amount disbursed is 2 crore. Current balance 199,400. Identical.
Where is it?
Well, here on the right hand side. 360 minute. Minute here. 360.
Amount is shown. Acha, Ugro Capital.
Ugro Capital. Yes. Identical amount.
Yes.
2 crore 199.
Yes.
Now kindly takes a look at, my lord, the coordinate bench order, my lord, which my lord will find, my lord, at page 253 of the second volume. I'm really sorry, my lord, I am having to take your lordship to the different volumes. 252, 253, my lord.
Yes.
There's a final order by which the section 9 was dismissed.
We are not once. The plaintiffs are represented by.
Yes.
And your lordship would see in the appearance of the parties, the respond numbers 2 and 6 have been had appeared. Who are the plaintiff numbers 1, 2, and 3, my lord? But kindly, may I take your lordship to this order, my lord? There is a section 9 application. And there's an application of section 9 of the Arbitration Conciliation Act for an injunction in terms of period D of the application. Period D is quoted. Injunction restricting respondents, the men agents from assigns and representatives from withdrawing any money from the bank accounts more fully mentioned in annexure such and such without keeping aside a sum of rupees such.
257 page.
Mr. Such and such, learned advocate for the petitioner, draws the attention of the court to the loan sanction letter dated July 25, 2023 and submits that a facility amount of rupees 2 crores having a tenure of 12 months with a tenure of 90 days for each tranche was sanctioned in favor of the petitioner. Page 32 of the application contains the schedule of terms. Reliance has been placed on the said terms. It is submitted that irrespective of the fact that Vedanta Limited was the principal of the borrower, the respondents were treated to be the borrowers all along and were liable to repay the amount as per the schedule. The loan recall notice has been placed in detail to show that an amount of rupees such and such was due and payable by the respondents against loan account number such and such. It is contended that The term of the facility ended in July 2024, but the amount remained outstanding. Reliance has been placed on the accounts of the petitioner as furnished by the respondent number 1 in the affidavit in opposition. Mr. Banerjee submits that the documents show that the loan transaction was in the nature of a current continuing account or bill discount account, and as soon as the payment was received from the respondent number 1, disbursement was made on the basis of the invoices raised by the respondent number 1 of almost an equivalent sum by keeping a margin of interest for the finance. According to Mr. Banerjee, the documents appearing at pages such and such of the affidavit in opposition could not in any way establish that the total outstandings of rupees such and such has been repaid by the respondents. It is further submitted that queries were made with the petitioner as to whether they were in a position to establish the issue of repayment supported by bank statements, but they were not responded to. Reference has been made to an email dated such and such by which the petitioner has sought for an opportunity to regularize the account, which was running in multiple tranches involving payment of 25 lakhs each. According to Mr. Banerjee, had the petitioner paid back the entire amount, there would have been no reason as to why the prayer for regularization of the account would be made. Mr. Banerjee further contends that the amount payable as per the first recall notice remains outstanding. As and when the payments were received, disbursements were made, the amount had not been repaid. Thus, this question of liquidation of the principal amount did not arise, and the cause of action survived against the respondents. It is contended that in view of the unpaid dues for over a period of 6 months and after the term for repayment has ended, there is a legitimate apprehension that the respondents would not be in a position to repay the amount. My lord, may I trouble your lordship with page 256, the contentions of the principal borrower?
Yes.
Mr. Such and such learned advocate appearing for the respondent number 1, who is the principal borrower, that company, draws the attention of the court at page 9 of the affidavit in opposition. The same is an email dated such and such. The email was written by a representative of the lender in respect of the loan account being number such and such. Mr. Saha's contention is that the email clearly indicates that the principal amount was no longer due, but only interest of such and such was due and payable. The principal amount was shown as INR 0. Reference was further made to the document at page 10, which shows that the loan details, that is sanction of rupees 2 crores against application number 15800 disbursed on August 1, 2023. Pages 14 and 15 have been relied upon to show that against the application number 15800, payments to the tune of rupees 25, this should be 25 lakhs, not crores, 25 lakhs on 3 occasions, rupees 2450 on 1 occasion, and finally, this should be 1 crore 50,000 on the last occasion was made. Mr. Such and such further refers to the disbursement made by the lender upon receipt of such payment and submits that those disbursements were in relation to other agreements and or transactions. The money was sent to the account of the respondent number 1 directly and not through Vedanta. They were not part of the loan agreement, which is the subject matter of the proceedings. Those were separate loan facilities and not the subject matter of the arbitration agreement. Reference has also been made to page number 15 of the opposition to show the statement and monthly interest status. The loan status against application number 15800 depicted the same as closed, indicating that neither any interest nor any principal was payable. The closure was dated 31st March 2024. These documents relied upon by the respondent number 1 belong to the lender. They were annexed to the opposition to establish how the transactions were going on and further establish that the amount disbursed by the lender on August 1, 2023, pursuant to the invoice of Vedanta Limited, which was the subject matter of the loan recall notice, had been paid back. It is the contention of the respondent number 1 that the subsequent payment by the bank was on account of restructurization and not part of the agreement, out of which the dispute has arisen. Then kindly sees the contention of the advocates representing the plaintiff's area. Mr. Avasti, learned advocate for the respondent numbers 2 to 6, submits that the signatures which are appearing in the documents relied upon by Mr. Banerjee were not consented to. The learned advocate denies that the loan amount had benefited the respondent numbers 2 to 6. They had no opportunity to use the facility given by lender. They were not beneficiaries. Reference has been made to page 32 of the application to indicate that only the respondent number 1 was mentioned as the borrower in the document. Even if the respondent numbers 2 to 6 were co-applicants, no duty was cast upon the co-applicants to repay the money. He further submits that the names of the respondent numbers 2 to 6 were mentioned as persons to whom notices or communications were to be sent, but they were never mentioned as borrowers. Anywhere in the loan agreement, reliance has also been placed on the promissory. Then kindly see the findings of the court. The question is whether the injunction as prayed for in this application should be allowed. From the affidavit in reply filed by the litigation manager of the petitioner, it appears there is an admission with regard to payment claimed to have been made by the respondent number 1. The averments narrate that during the pendency of the application under Section 9, the petitioner was approached by the respondents for reschedulement of the account by an email dated such and such. This is the email on which Mr. Banerjee has placed reliance upon. In view of the request, the account of the respondents were restructured by the petitioner. Reference has also been made in this regard to the document at page 9 of the affidavit in reply. The same is an email dated such and such written by the lender to the borrower indicating that only the interest amount of rupees 22,373 was due. The documents at pages such and such were statements annexed to the said email which indicated restructuring. It has also been admitted by the deponent that the amount of 2 crores, which was paid on August 2023 and is the subject matter of the arbitration agreement, as also the recall notice, had been restructured. Paragraphs 3 and 4 of the affidavit in reply clearly indicate so. It has been stated in paragraph 5 that after restructuring, further financial assistance was given to the respondents and fresh tranches were created in terms of restructuring requested by the respondents. The disbursement dates have been mentioned at page 5. The loan account number is the same. The invoices have been mentioned along with the disbursement dates, which tally with the documents annexed by the respondent number 1 in the affidavit in opposition. Thus, the respondent number 1 has made out a case of restructuring of the loan account, if not a case of payment of the entire outstanding. There is a clear admission of such restructuring by the petitioner's officer. The restructuring took place admittedly after the application under Section 9 had been filed. Fresh payments or disbursements were made by the lender on such and such. The contention of Mr. Banerjee that the tenure for repayment of the loan amount of rupees such and such had expired in July 2024 and the respondents were sitting tight over the matter without payment of a single farthing has not been established. The arguments advanced by Mr. Banerjee are questions of trial before the learned arbitrator. At the time of consideration of prima facie case, balance of convenience and inconvenience, and irreparable loss and injury, a mini trial is not required to be held by the court. Whether the money disbursed on the above dates after the restructuring have been repaid or not is not an issue before this court. The lender may also proceed according to law against such outstandings. As of now, the prayer for injunction has to be restricted to the subject matter of the agreement which has been annexed to the application. From the records and the admissions made by the lender that the restructuring was done at the request of the respondent number 1, the court does not deem it fit or necessary to grant an injunction in terms of prayer D. The subsequent events have to be taken into account. The pleadings are not in consonance with the latest developments. This court does not make any observation with regard to the steps that the respondent may take in respect of the subsequent dues. In this proceedings, the petitioner has failed to prima facie establish that there are grounds for passing of orders of injunction restraining the response from withdrawing the amount. Accordingly, the prayer is refused, then this application is disposed.
Yes.
So, what really emerges from these facts are 3-4 things. A, the principal borrower was Vedanta Limited, whose bill discounting facility was the concerned loan.
What about the restructuring?
But I have never been part of any restructuring. A. B, I am not the borrower. So it may happen, and I am not denying whether or admitting whether the restructuring has taken place or not. They may choose to proceed against the company. I do not have any objection.
Okay.
But all I seek is because of this outstanding claim, that this lying outstanding, which admittedly has been paid off from their documents, my CIBIL score is getting affected.
Okay.
So, here I have made the CIBIL a party, where I have prayed orders that they should report accordingly to the CIBIL, which should be really reversed.
Yes.
And that is why, and I also say that arbitration clause is not binding. But I really should have, it should have possibly, in my humble understanding, a declaration that the agreement is not binding on me should have sufficed. I need not have prayed for a delivery upon cancellation. Only a declaration possibly would have sufficed. Because your lordship has seen I am not the borrower.
Okay.
So this arbitration clause really doesn't bind. Those are my submissions.
Yes. Come tomorrow.
Lordship wants to come.
11:30.
Unfortunate. Every matter, my lord, he'll fix, my lord. Tomorrow at 11:30, my lord. Then.
Come. I will take the.
But may it retain its position, my lord.
It will remain in the district.
Or may it, my lord, be day after tomorrow in that case.
No. Day after tomorrow.
We are praying for an interim order for this. The 4th time we are coming before a
There is no
lordship.
scope for any order, but then my lord,
I pray kori.
Counsel for the
পাবো না
plaintiff
পাবো।
there is no
has
scope.
concluded his arguments for grant of identity model. Full stop. But due to paucity of time, hearing could not become the defendant. Counsel for the defendant could not argue the matter. Accordingly, case is adjourned. Let the matter appear
Tomorrow, my lord, kindly.
30th July. 30.
Not kindly tomorrow, my lord, if it's possible.
Come, 30.
One day nothing will happen.
Next.
My lord, before the fixed matter is called, my lord, item number 17, my lord, there was a direction to file affidavits. My lord,
Okay,
they have
that's
filed.
very well called. Let the
The other side is already there.
Let the fixed matter call. Item number?
Raja achish. Wait, please.
Yes.
Yes, it's right. লিখি দে রাজার সামনে কোনদিন হয়েছে সাক্ষী এই যে সাক্ষী Lord, no part of the evidence, Lord, up till now has before your lordship, Lord. So, Lord, your lordship is now with the duty to, Lord, pass a decree when all evidence is over. So it is at an argument stage. Generally, if the court has the occasion to hear the witness, then
it will differ.
Yes, reflect. So, Lord, I will have to, Lord, praise the pleadings to and take the court's time to show what is the issue, what is the written statement, then the
Total, from 0 to
0 to 8. Now, Millard, in a nutshell, Millard, this is a suit, Millard, for recovery of mean profit, occupation charges in the alternative mean profits and other monetary claims on account of reimbursement. Kindly, Millard, come to Millard page 10 of the plaint.
So you are for the plaintiff?
I am for the plaintiff.
Yes. Both the party adduce evidence?
Yes, both parties have adduced evidence and cross-examination. Millard, evidence exhibit সব আছে তো? Millard, page 10, Millard. I'll just give you lordship, Millard. Is the claim, Millard, your lordship will find A is a money claim. Thereafter, there has been an amendment. BA, BB, and BC are also in the nature of money claim, mean profits, in respect of the same property, interim reliefs, and such and such. Now, Millard, this money claim arises out of essentially occupation charges in respect, Millard, of a portion of the property on Park Street.
Yes.
The defendant, Millard, admittedly, I say admittedly, was in possession and was running a business from the first floor. Thereafter, it came down to the ground floor of the same building, continued it under an agreement in writing, which agreement in writing came to an end ultimately in 2007. After 2007, the parties negotiated for the purpose of enhancement of rent. According to my client, the plaintiff, they had agreed to a particular rent, and that agreed rent, Millard, was not paid. According to the defendant, there was no concluded contract as regards the rent. Therefore, what they did is, Millard, they surreptitiously, Millard, transferred a sum of money at the old rate of 2007 into my bank account, as if it was a prolongation of that agreement, continued for another 3 years till 2010, and thereafter vacated the property.
31st December, they
So 2007, 2010, they are vacated.
So 31st December 2010, they have vacated. So Miller, essentially Miller, this claim would be on account of rent or not rent, it should be occupation charges, alternatively mean profits. That's the reason, Miller, why your lordship will find, because the reason the prayer, the basis is this, Miller. If I succeed in showing that there was an agreed amount on account of rent, then, Miller, I am entitled to that amount for that period with interest. But it is nobody's case that from 2007 to 2010, there was an extension of that tenancy or it was a month on the same terms and conditions. Nobody's case. It expired. If I don't succeed, Miller, in showing that there was an agreement to pay a particular quantum as occupation charges, then the fact remains that the defendant was in possession from my property from 2007 to 10. If he doesn't agree to the rent, Miller, then obviously he is in wrongful possession. If he is in wrongful possession, then my learned friend will have to show that he is entitled to pay the old rate and not mean profits. But the quantum, which I say is, which is Miller 55 rupees per square feet, in my respectful submission and as it appears from the exhibits, Miller, is an admitted amount, though not paid. Now, this is, Miller, the crux of the suit. Miller, if I may just invite your lordship, Miller, to some of the paragraphs in the plaint, Miller.
Yes.
Not much of Miller, evidence was led by the defendant. Miller, paragraph 1 is the plaintiff, the defendant. I'm very hurriedly taking your lordship through the plaint, Miller. Miller, there is an agreement between the parties which is at 22nd January 1992, which your lordship will find that referred it as paragraph 2 of the plaint. This agreement has been marked as exhibit at the judge's brief of document. Yes. DD1 is exhibit D. Exhibit D. B for D. D for D. Exhibit D at page 33, Millard, if I'm not wrong. Okay. Millard, this is the
Exhibit D is the notice.
No.
Exhibit
D. Is it a letter?
Exhibit C. It's Exhibit C. Judge's brief of document, page 4. JBD, page 4.
Yes, this is Exhibit D.
That is the notice.
No, Millard, this is the agreement.
So, what is then C?
Exhibit C, Millard, conveys between the plaintiffs, Millard. It has nothing to do. The name of the plaintiff was changed, and that's the reason, Millard, that's proved. I don't think that is disputed. Millard, this was the agreement of 1992.
Yes.
Millard, this name has changed from ARM Group Enterprises Limited to CLP Business LLP. So, Millard, it's the same, not in dispute. Now, Millard, with reference to the above and discussions we had with you in the above connection on different occasions, we have the pleasure to let you know that the competent authority of the bank has agreed to modify the terms of tenancy in respect of the first floor space at Park Center and also to engage alternative ground floor space at Development House in lieu of the said existing first floor space on the following terms and conditions. Rent may be increased from rupees 250 per square feet to rupees 5 per square feet with effect from 1st August 84 to remain valid for 3 years, that is on 31st of March 87. This is one. Rent may be further increased to rupees 10 per square feet with effect from 1st August 87 to remain valid for 3 years. 3 years, that is up to 31st of July 1990. Rent may be further increased to 11.50 per square feet with effect from 1st August 1990. Service charges will be paid at rupees 50 per square feet. Corporation tax, this will be important. The corporation.
So, first, second, it's okay. Third, rent may be further increased at the rate of so with effect from to up till which date?
This is up till accept. This your lordship will find your lordship's page 2.
This is the main term.
Page 2, your lordship is at page 2. Kindly may not read clause 3 with D.
10 years.
Yes. So 92. So the lease shall be renewed for a further period of 10 years with effect from 1st August 87 with an option on the part of the bank to continue the tenancy for another 10 years subject to revision of rent at the rate of 15% per annum after every block of 3 years. So after every 3 years, my lord, the rent would be enhanced. So my lord, 87 to 97, from 97 till 2007 is 10 years. So my lord, my lord, as regards the corporation tax, my lord, I may also place it. Corporation tax may be paid as follows: 50% of the consolidated tax to be tax for the portion in occupation of the bank as per the first valuation made subsequent to occupation. Incremental tax, if any, in respect of the bank's occupied portion payable on the basis of subsequent assessments, instead of reimbursement of tax on the basis of paid bills as being done at present. The bank may henceforth pay tax on the basis of the valuation of the bank's occupied portion. The amount claimed by you in this regard will, however, be required to be certified by the firm of chartered accountants. So, my lord, parties agreed that instead of following the process under section 230 of the Corporation Act, that landlord pays being the person responsible, they can directly pay. Because at that point of time, my lord, it might come back to your lordship, there was a concept of owner's share and occupier's share. So, my lord, if I have let it out on rent, the occupier has an obligation to pay. Then, my lord, special conditions may not be read. So, my lord, in 2007, this is the document which will fall for interpretation. Kindly, my lord, come to a minutes of the meeting of 25th June 2007, which is exhibit. Main 25th June minutes.
Minutes exhibit
E.
25th and 26th both together.
Exhibit E. আর কি দেখাতে চাইছিলি এখানে? Yes, my lord, I am obliged to my junior my lord. Kindly, my lord, come back to exhibit D once more. Kindly make a note of, my lord, page 3, clause D. I told you, lordship, my lord, they were initially in the first floor, thereafter they came to the ground floor. So the parties had agreed that the same terms and conditions will also apply to the ground floor also. That agreement I forgot to, my lord, mention. And I don't think this is an issue as I take your lordship, my lord, through the. Now, my lord, this 26th of June 2007 minutes had fallen for consideration. And permit me to place the entirety because this records a very important intention of the parties. Minutes of the meeting held on 25th June 2007 at so-and-so Kolkata for renewal of lease agreement and revision of rent of Park Street branch premises at 24 Park Street. Bank was represented, my lord, by the general manager, chief manager, senior manager and the manager. and the respondents are there. Details of the premises, area such and such. Present rent is 82,883.00. That is below in terms of the previous agreement. And KMC tax is rupees 888.20 lump sum per month. The lease agreement of Park Street branch at 24 Park Street will expire on 31st of July 2007. Owner of the premises has invited for discussion and settlement of the issue on 25th of June 2007. Mr. Bhalotia came to the regional office on the same day and initiated discussion with the chief manager marketing such and such. At the beginning of the meeting, Mr. Bhalotia placed his demand in an unsigned paper and told that all the four partners had authorized him to negotiate with the bank on their behalf. Precisely the demand are, although the bank is in possession of 3,600 square feet area, the renewal is to be considered on super built up area of 4,426 square feet. Proposed rent is 110 per square feet. Maintenance charges 250, corporation tax 50% at actual, security deposit equivalent to 6 months rent, interest free, renewal 3 years, 3 years, 3 years, with provision for increment of rent by 20% on last paid rent every 3 years. Legal rent agreement should be registered, jurisdiction Calcutta High Court. So these were Milatable. The discussion began in a cordial environment, which the Bhalotia agreed to most of the issues and expressed that other issues could be settled mutually. But he stuck to his point on the enhancement of rent and calculation on the basis of super built up area. Initially, our offer was rupees 30 per square feet, inclusive of service charges and maintenance charges. As Mr. Bhalotia reacted sharply, revised offer was given at 35 per square feet, but Mr. Bhalotia did not agree to the revised proposal. Finally, Mr. Bhalotia sat with the general manager. The issue of super built up area was not accepted by the general manager. He specifically mentioned that the bank always considered rent for the carpet area occupied and the demand for super built up area could not be considered. Mr. Bhalotia ultimately agreed to this point. On further negotiation, at the instance of the general manager, Mr. Bhalotia was ready to accept a reduced rent of rupees 80 per square feet, taking into account the prevailing rate of rent normally paid by other nationalized banks in this locality. We revised our offer to rupees 40 per square feet. So, negotiations are going on. But Mr. Bhalotia stuck to the earlier rate of rupees 80. At this stage, the general manager requested Mr. Bhalotia to consider a lower rent, keeping in view his long association with United Bank of India. Observations of the RO. Regional office, yes. The bank can consider rent at the rate of 40 per square feet, inclusive of all service and maintenance charges. Area, the concept of super built up area is not accepted. Rent will be calculated on the basis of existing floor area, that is 36,000. KMC tax 50% of the occupier share will be considered on submission of KMC bills. Lease for a minimum period of 3 years with effect from 9 years with effect from 1st August 2007, with an option on the part of the banker to continue the lease for the further term of 3 years under the same terms and conditions. Enhancement at an interval of 3 years at the rate of 15%. So, my lord, your lordship, if your lordship now sees the offer and the counter offer, there are differences on 3 aspects. One is rent 40. They are saying 40. We will pay 40.
You are 80.
I am 80.
Then
3600 square feet is agreed, more or less agreed. KMC tax, I say KMC tax would be on actuals. He said no, 50% of the occupier share will be considered on submission of KMC bill. So he is not ready to pay his occupier share. He say you pay it, give me the bill, I'll reimburse you. So there is no dispute as to the obligation to pay. The manner of payment was in dispute. And 9 years is agreed. Only thing is, Millard, I had said 9 years, 3 plus 3 plus 3 with an enhancement of 20%. And he has said 3 plus 3 plus 3, instead of 3 plus 3 plus 3, 15% enhance every 3 years. That makes the same thing. Now, as no specific settlement could be arrived at the meeting, it was unanimously decided to sit again on the convenient date of both to resolve the issue, tentatively in the first week of July 2007, since Mr. Bhalotia will be away. Another sitting was organized on 17th of June 2007, but subsequently it had to be postponed due to preoccupation of the general manager with an understanding to sit on a suitable date in near future. In this backdrop, we invited Mr. Bhalotia for discussion on 17th of August 2007. Then, my lord, minutes of the meeting held on 17th of August 2007 at Calcutta Regional Office for a new agreement and revision of rent. Same persons were present. After a long discussion, the bank offered rent, kindly my lord, bank offered rent at 50 rupees per square feet. So from 40, the bank has now gone up to 50. Leaving other conditions unaltered. So 50 rupees per square feet with other conditions, meaning observations in the previous meeting. Finally, Mr. Bhalotia,
Conditions of the previous meeting, not the agreement.
Millard, it will appear, Millard, that what had happened is, Millard, this ultimate agreement came into being on 17th of August. That is the reason, Millard, why the parties sat and discussed what started from the first meeting and the second meeting in one meeting.
Okay.
So 2 meetings were
Taken into
consideration and 1 minute was drawn, indicating that there are 2 minutes. After long discussion, the bank offered rent at 50 living. Finally, Mr. Bhalotia came down to rupees 61 per square feet. General manager then narrated the overall situations and requested Mr. Bhalotia to consider the additional burden on the branch, and finally offered rupees 55 per square feet. Kindly, Millard, mark this.
So now 5 rupees difference here.
5 rupees difference. So bank from 50 has gone up to 55. And that's the final offer from the general manager. Total rent on the basis of this enhancement amounted to 1,98,000 per month, excluding KMC taxes, 50% of the occupier share, full commercial surcharge. He requested Mr. Bhalotia to accept the proposal, considering his long-standing relation with the United Bank of India. Thereafter, Mr. Bhalotia requested the general manager to consider a total rent of 2,01,000. So 1,98,000 was the bank's last offer per month, and Mr. Bhalotia's offer was 2,01,000 per month, including maintenance charges, which eventually comes to 55,803.83 per square feet. This rent
ultimately accepted by the bank.
So what happened is the bank's final offer was rupees 55 per square feet. This did not include the other service charges. So with service charges, it goes up to 55.83. This rent was ultimately accepted by the bank and finally settled at rupees such and such per month. That is such and such 5883, subject to approval of the competent authority. Following terms and conditions as agreed to in principle, final lease agreement will be executed and registered. Then, my lord, kindly see the parties have, my lord,
conditions.
Given the final conditions that this is what we agreed. Area was 3,600. So it was on the actual area, not on the super built up. Tenancy would be for 9 years, with an option on the part of the lessee to continue the lease for the further period of 3 years with existing terms and conditions. And the bank has the further option for a further period of 3 years, relinquish the lease on completion. Rent 2,01,000 per month, including maintenance charges. This 2,01,000 per month calculates to rupees 55.83 per square feet, which is recorded just above. Review of revision. Revision of rent will be at the rate of 15%. So bank's condition was accepted. 15% on the previous rent on completion of every block of 3 years. KMC tax, the bank shall separately bear by way of reimbursement 50% of the municipal taxes and the entire commercial surcharge in respect of the portion under the bank's occupation. Bank will apply for separate meter and owner will issue no objection. These deed will be registered at the bank's cost. Landed prayer for advance of 6 months to rent to be liquidated on 36 monthly installments. However, no commitment from our side, service tax. Then, since the amount involved is under the discretionary power of CMD ED, ED টা কি enforcement directorate? এই ED টা কি রে? The proposal for enhancement of rent of Park Street branch premises will be forwarded to headquarters for their approval. So, Millard, 3-4 things are very important. One is bank records that to the level of the general manager, they have the power and they have agreed to certain something. Now, Millard, what the defendant is now saying and contending is that yes, we had agreed to 55. But this 55, I had sent it for approval.
Subject to approval.
Subject to approval. The approval has not come. Now, Millard, with respect, there are subsequent correspondences which I'll show. If your Lordship Millard vis-a-vis this takes exhibit 2 once, Millard, that would corroborate what I am saying. Exhibit 2 টা দিন না 18 অগস্ট 2007 পেজ 10
page 10. Yes.
Millard,
Exhibit 2.
yes, Millard, your Lordship has a letter of the United Bank of India head office 16
Dated 18th August.
18th August. This is after the meeting.
Yes.
Yes, it's in your judge's wish.
Yes.
It is your disclosure. Tenancy agreement. Page 10. In connection with the above and subsequent to discussions held at your chamber on 17 July 2007 and 17th August 2007 for renewal of tenancy agreement of the branch with the owners. In terms of the broad understanding reached and minuted for construction continuation of the leased agreement, the branch recommends the proposed rent of rupees 55 per square feet carpet area. Since other nationalized bank in the peer locality have entered into lease agreement with similar or higher rent. So this is the bank's letter. Bank has disclosed it. The owner will have to resolve the problem of sanitation, such and such maintenance. That's not relevant. Now, Millard, 2 things are very important. One is this, Millard, it's an admission of the fact that this 55 rupees, which was agreed in 2007, Millard, holds good. And in the event now, my learned friend is contending that 55 was not agreed upon, and the question of mean profits come in, there is a clear admission of the fact that 55 is the rent, if not more, which is prevailing in the area. So, Millard, if your Lordship is ultimately, Millard, inclined to hold that there was no agreement to pay 55 rupees, the occupation charges is at least 55 that is what is coming out from that agreement itself.
Because leaving aside the 55, they have stated that the similar or higher rent is available in the market.
In the market. So that is enough evidence to calculate mean profits. Next.
Yes.
No, next no, bank chiti. And তারপর no, not এত মানে এই রেন্ট নিয়ে তারপর কি হলো নাও মিলন এরপর আর কোনো চিঠি নেই তো now মিলন vis-a-vis this মিলন now kindly take the written statement আসছি written statement টা দিন না
Yes.
Milan, kindly see Milan paragraph 6. He says that no concluded agreement was arrived at between the plaintiff and the defendant in August 2007. Hey, ওইটা বার করো যেখানে আমার টাকা ওই পুরনো রেটে আমরা ব্যাংকে টাকা দিই ওই চিঠি দিল The minutes of the meeting clearly indicates that he is harping on this. Following at
Paragraph 6.
Paragraph 6 of the written statement.
No concluded. Yes.
And he is quoted the lines on which he is relying upon.
Yes.
And thereafter he says, in paragraph 7, the defendant agreed to the enhanced rent of 53 per square feet. I don't know where he's getting it. Only if the expired lease agreement was renewed. The defendant did not agree to the enhanced rent of 53 per square foot, even if the defendant had to vacate the premises in question. The plaintiff, by letters dated 14 July 2008 and 12 November, did not agree to accept rent at 53 per square feet, but on the contrary, in the letter of such and such being annexure E to the plaintiff states inter alia as follows. Sir, either implement the newly agreed lease rent of 2,01,000 as agreed in the meeting of 25th June or vacate the premises forthwith. The statement made in the letter of 12th June 2008 that the agreed rent was 2 lakh was absolutely wrong and baseless. And thereafter, Milord, he goes on to deny the entirety of the agreement.
They have stick on 53.
Now he is on 53. Now, Milord, your Lordship will find. Lordship gives me a moment. This 53 is something which I could not, with utmost respect, Milord, could not find in anywhere in discussion in the minutes. So from 40 it went to 50. From 50 it went to 55 straight away. 53. Now, Milord, two things. My learned friend's sole and whole defense is there was no concluded agreement between the parties so far as the minutes of 25th are concerned. With respect, Milord, I beg to differ and I'll give my reasons why. A, during negotiations, when the parties agreed to a particular amount, that agreement had become a concluded contract so far as I am concerned because he is promised 55. Now, whatever it takes for the bank to get an approval on 55 is not my obligation.
Of the bank.
It's of the bank. My learned friend, from this date till the date the suit was filed, not even in his written statement, has made one single statement that we have applied because this would be the in-house procedure of the bank, how they apply. Nor have they disclosed any document that they have actually taken any steps to apply or the approval had not come or they had indicated, look, sir, the approval is not coming. So therefore, please see it, please revise. He is continuing to occupy your property. He says that very well, I'll pay you 55 subject to approval of my higher authorities. If the higher authorities do not approve, then what is the income? So therefore, my lord, your lordship has to be satisfied that this 55 which was agreed upon, he doesn't come in the written statement to say that the persons who had agreed to 55 did not have the authority to agree to 55.
What was the answer to this minutes during cross?
There's nothing.
Because there are these two documents are the vital now. That is with regard to the minutes and the letter dated 18th August.
Yes.
These
And
are the two.
These are the two documents. And in none of these two documents, my lord, your lordship will find, not even in the written statement, my learned friend has taken this point that the general manager, the junior manager, whoever those persons were there who had agreed to 55, did not have the authority to agree to 55. So if a person has an authority and you are not denying it, then whether your in-house management does not, my lord, if you do not take any steps to get that approval, because then you will have to come and say that, because it's a bank, it's a nationalized bank. You will have to come and show before the court that, look, my lord, on the basis of this 55, I had put in this request, this was meant higher up, and ultimately they had said no, therefore I can't say no. Until this exercise is, my lord, shown to your lordship by way of evidence, then 55 remains the rent. A. Alternative argument would be, my lord, as I said, that even if 55 is not the agreed rent, this would be the minimum occupation charges for the property for this period, because that is what has been admitted. And there is no statement in this entire written statement trying to explain or justify that admission. Admission cannot be taken away. It can be explained. But there is no statement, Miller, my learned friend will correct me if I am wrong, that, and because that is his disclosure. That letter is disclosure of the defendant in this proceedings. He only proceeds on the basis that there was no concluded contract because parties had agreed there will be approval, and that's it. Ever more. Lordship gives me a moment. Yes. Now, Miller, exhibit bolo. Miller, these are the exhibits, Miller, which is the follow-up to the minutes. It's all from my side. Decision will depend on those two letters. But, Miller, what had happened subsequently, Miller, because these are exhibits in the proceedings, G, H, and I.
Give the GH and I.
Well, exhibit G is a letter of 14th of July 2008.
Yes.
Then, Miller, I write to inform you myself that so our owner, that is not very relevant. As the earlier lease on the basis of which the bank branch was situated in the premises are already expired on 31st July 2007. Please note that the bank is in possession since 84 running Park Street branch. In this connection of purchase said property in the premises by us, the undersigned and other owners had informed partners, then this is not relevant. With regard to the renewal lease further period, we had forwarded proposal and rate transfer on several locations. Meetings were held in the branch. The general manager, regional manager, senior manager, and manager P&D as to fixation of leave day with effect from 1st August. And in relation to the same, meeting was held on 25th June at your regional office for renewal of lease agreement and revision of rent of Park Street branch. When the rate was finally fixed and the minutes of the meeting was recorded, a copy of the minutes of 25th is sent herewith for your information and record. In the said meeting, it was finally decided that the area of space will be considered at 3600. Lease will be period of 9 years with effect from August 2007, with an option on the part of the bank to continue the lease for a further period of 3 years with existing terms and conditions that the bank will have further option to relinquish the lease after completion of 3 years. We pay rent at 2,01,000 per month. This is what is recorded. Maintenance
Now, they have come to the 53. Kindly come to the page 2. 1, 2, 3, fourth line, fourth paragraph.
1, 2, 3, 4. Thereafter, on 4 to Mr. Goyal called upon us and discussed the issue wherein we requested to reduce 53, which was not agreed upon.
Correct.
Yes.
So now they have come this rent.
This is on 4th they are coming and saying this.
Yes.
The lease deed has not prepared till date, such and such. We therefore again request to call upon.
So you are stick on the 25th of July.
And what do we do, my lord? My lord, kindly, my lord, come to annexure I. The reason why I wanted to show this is kindly, my lord, see, it's a letter of lawyer's letter from my client's side, 7th May 2009, which records. Rest is not, my lord, the repetition. I am not wasting the court's time. Kindly come to paragraph 6 of that letter. This will be exhibit I. I'm sorry, my lord, that instead of complying with the terms and conditions arrived at the meeting of 17th of August 2007, your bank has been paying the monthly rent to my client at the old rate. Suddenly on 18/4/2009, my client have got a statement of account from your bank, thereby intimating that your bank has released enhanced rate of rent at the rate of 15% of the previous rent since August 2007 to 2009 and credited the same in their bank account. So what has happened is this, my lord. When I have been persisting on payment of rent, what my learned friends clients do is they put in some money in my bank. Now, to avoid admission of either of 53 or 55 or whatever 2 lakh one, what they do, they fall back upon the expired lease. And kindly will not come to now exhibit D page 34. It might come back to your lordship. Lordship need not be bothered. The tenancy agreement says that there would be an enhancement of 15%. So what they did when the lease came to an end in 2007, they went on paying the amount
Old rate.
at the old rate. This right extinguishes with this document.
No, but if kindly come to the paragraph 6
of
which you just exhibit I.
Yes.
Paragraph 6.
Yes.
That instant complying the terms and conditions arrived at the meeting 7. What is this meeting?
Millet exhibit.
Because they are relying upon 53. That is as per the
Millet, kindly come back to that. Kindly come back to that minute. Exhibit E, Miller.
Yes.
Kindly come to the second page.
Yes.
Miller, 2 minutes are here. First minute was of 25th June.
Correct.
And the second minute was of 17th of August 2007.
No, 17/7.
7th.
Acha, 17th August.
Your lordship has the original, I mean. Original ka nahi?
No, not the
Not,
yes.
Not the original.
17th August.
This 17th August is what is referred to here.
So this, acha, you are referring. Okay.
So 17th August is what the final agreement. And so 2 meetings were held.
Yes.
Both of them have been collectively
Yes.
So, Millard, 2 meetings, as I told your lordship, Millard, it is all part of one annexure. One is recording the minutes of 25th June 2000
August.
and August.
It
And August was
on,
the final.
Yes,
August
it was fixed on July. It was not held.
No.
Then August.
August was the final date where, Millard, this thing had happened.
Correct.
So, Millard, this attempt by Millard, by learned friends clients to put in 15% in terms of the old agreement, Millard, does not lie because that right or that agreement came to an end with that. Now, Millard, if your lordship turns over the page, in the above facts and circumstances, I, on behalf of my above named clients, request you to look into the matter carefully and take necessary steps to implement the terms and conditions arrived at by and between the officers and authorities of your bank and my clients in the meeting held on 25th June 2007 and 17th August 2007. Within a period of 2 days after receiving this letter, if you fail to implement the above terms of the meeting of 25th June and 17th August, within the stip, it shall be presumed that your bank has deliberately willfully delaying the matter, causing serious prejudice and loss to my clients, and shall have no other alternative but to seek remedy. This is, beloved, all that the suit is about. আমি আসছি, আমি আপনার argument শেষ করিনি. So this is, Millard, in a nutshell, or Millard, as I say, so Millard. Yeah, so what will fall for consideration, as I take your lordship through the evidence on the next day, Millard, your lordship will find how the parties have interpreted that. But Millard, as I say, if it's a document in writing signed by the parties, so your lordship can only look at, if at all necessary, at the evidence subsequent to this document, if there is any ambiguity in this. I don't see any ambiguity with respect to any of the clauses of the 17th August 2007. It was express and expressed to the T. Rate, rent, square feet, tax, everything. Now, it is for my learned friend to come and show, and I'll show, I have put questions to him in cross-examination, for him to come and show that why he could not keep up to that, because as I told you, lordship, at the cost of repetition, he doesn't.
What is the reply of the CMD
of
this exhibit I?
Exhibit I এর কোনো reply আছে দেখো তো? Exhibit and exhibit J. কোনটা রে? এইটা তো 21st July. We acknowledge, well, your lordship has got it. It's a letter of United Bank of India, Calcutta South Region branch, dated 21st July 2009.
So they are not.
No, what he says is that this rent was paid under a tacit understanding. So he will have to show.
That's why I want to, whether they are denying with regard to this minutes of.
No, not at all, nowhere. Not even in the written statement.
Okay.
So,
yes,
the minutes have never been denied. May I come back, because I have only 2 minutes left. I can't, no point going into the evidence.
counsel for the plaintiff has argued at length, but due to paucity of time, hearing could not be completed. कल है क्या नहीं ना? This is the matter.
Except for Wednesday. বুধবারটা দেবেন না খালি।
August, 29th August.
Oh, August.
29.
29th August. I can't even say yes or no. I don't even know whether I'll survive till then. Very well, Millard. I'll come back.
29th August.
Obliged.
What?
Time?
11:30.
11:30. 29th August. 29th. Obliged, Millard.
Obliged. Interim order extend করিয়েছিল যে notice দেয় আমরা ছিলাম তোর ছিলিস তুই বলবি না
Yes. And 12:30 fixed time for the respondent by 11 HDFC Bank.
Okay.
My only thing, Manu, on the last day when Mr. Arindam Banerjee had probably mentioned the matter for extension of the interim order, we are the main affected party. We did not get any notice for either extension or for fixation of this date of hearing. We are the affected party against whom the order is operating, and also against Mr. Jishnu Chaudhary client. I'm not aware of Mr. Jishnu Chaudhary. At least we did not get any notice. Yeah, my admin record is Mr. Anuna Basu of Ketan and Company.
Okay, it is fixed today for especially fixed, yes.
But in future, Mr. Banerjee puts us on notice, man, it is better, man.
Huh?
We were not given notice of the extension of interim order also when it was mentioned and the date was fixed.
The 16th July, it was they all are appeared.
No, my lord.
No, we were not appear. It was mentioned. It was not called on that day. I probably, if I'm not wrong, Mr. Banerjee, maybe.
Extended. If you want agreeably, you go and challenge this, sir.
Lord, interim order has been there for some time.
Correct.
But I would expect, my lord, that they would inform us when they mention for extension.
That's why, because in my cause list, I already mentioned interim order will be extended at the time of rising of the court.
Then we should be here at the time of rising.
Because
On
should
the
be
last
here.
day. Yes.
Because in the cause list, if any interim order is going to be extended, it will be taken at.
Absolutely. I totally agree. I don't see the cause list because I
We
get.
were not aware, man. If we had been, we would have definitely come.
Maybe pray for vacating of the order, my lord.
I have fixed the matter, especially let the matter be argued on merit, or you want to vacating, whatever it may be. It has to be heard on merit.
Lord, would your lordship permit us to start? I think Mr. Mukherjee is on his legs.
Okay.
So, Lord, I can give your lordship the background. Lord, plaintiff is not, they will continue to and
But
not.
we are all talking interim orders now. But let them start off the matter somewhere.
That's
I do not, Lord, because
I was suggesting instead of Mr. Chaudhary, who wants to hijack their proceedings.
No, Lord, I'll tell your lordship what has happened is plaintiff has a reason to be aggrieved by the defendant number one, the company, my lord, BRH Wealth Creators. But, my lord, the order which he has obtained, I humbly submit he is not entitled to the order. But even if he is entitled to some order, it's against a company. Not what he has done is he has frozen the personal bank accounts of all the directors, which, my lord, your lordships do not. Otherwise, what's the point in doing business in a company? Your lordships may say, my lord, that on the basis of fraud, I have, Lord, your lordships feel that something can be done. But there is nothing, my lord, not one paper which he has brought to justify, my lord, freezing of my personal bank accounts.
But, and I am
And
an
he's got-
ex-director who had left long
And he's
before
got,
this.
and that's
got,
true.
my lord, wide
And he's
injunction.
got this order, my lord, without, do believe, my lord, when your lordship was passing this order, your lordship was not told that these are the directors, these are the ex-directors, and there is no cause of action which he has against them personally.
Okay, let you continue.
Yes. I take Mr. Bachawat's advice and keep quiet.
No, otherwise, my lord, will never finish.
Correct.
Someone has to start and say.
Okay, you
So that,
continue.
because it's urgent, I can't operate my bank account.
Sir Jishnu Chaudhary, my lord, is taking over, my lord.
Okay, no problem. But
Your
let
lordship
podium.
signed issues, you are
Okay,
never
let
to be found in this matter. Please proceed with
Please,
the
please stop creating prejudice.
Okay,
you are
okay.
senior enough. Please sit down. Let me
Yes,
face
yes,
my
I
case.
want to.
Yes. Please stop creating prejudice. Open up a paper. Look at a paper for a change.
Okay, continue.
You've been ranting for the last 10 minutes. We could have proceeded. And interim orders were extended with oral notice to the advocates on record who were there. They heavily objected, but since the matter was there in the list, it was thought prudent that it should be extended and not vacated as a walkover.
Okay,
I don't think that is unknown.
Continue on the merit.
Take his lordship, Lord.
My lord, kindly have a look, my lord, at the ad interim order, my lord, which my lord had made on the 8th of November 2024. That would, my lord, perhaps, my lord, serve as a good guide, my lord, to the facts that were placed. This is, as the level of opposition coming suggests, this is one of the most glaring instances, my lord, of financial fraud to hit the market. There were two such instances. One is Carby and the other is BRH. BRH presents a unique set of circumstances, which I'll show, my lord, from the materials on record. May I, my lord, first show your lordship, my lord, just take your lordship briefly into, my lord, the cause title first to make your lordship, my lord. The PRH Wealth Creators Limited is, my lord, the defendant number 1.
Yes.
These are the persons who are the stockbrokers who trade on my behalf in respect of shares and securities, my lord, owned by me. Shiv Kumar Damani and Anubhav Bhattar, my lord, these are the directors.
They are still the directors.
They are still directors. 2 and 3 are still directors.
Okay.
4 is also a director. 5, Avinash Agarwal and Sudhanshu Agarwal are ex-directors, but I have materials on record, especially from the affidavits that are from the other side, to show that, my lord, that they may not get scot-free from this transaction. 7, my lord, Murgesh Devashrai, my lord, is a present director. 8 is a group company. Now, my lord, so 1 and 8 are essentially, my lord, of the same group. Now, if your lordship comes into 9, 10, 11, they are, my lord, the persons who lent money to 1 and 8. Bajaj Finance Limited, HDFC Bank Limited, and JM Financial Products Limited. 9, 10, and 11 are the lenders who had lent money to 1 and 8 inter alia on the basis of, my lord, the security of those shares. Of my shares, which have been allegedly pledged to them. Now, my lord, thereafter, my lord, will find SEBI, NSE, PSE. These 3, my lord, are the regulators. 15, 16, and 17 are again group companies of 1 and 8. Then there is the CDSL and the NSDL, which two are also CDSL and NSDL, my lord, are also depository service regulators. And 20, my lord, is the Axis Bank Limited, which is one of the lenders. Now, my lord, the facts which were placed before your lordship, my lord, for the ad interim order, my lord, may I just place 8th of January 2024? Then very briefly, my lord, I shall go into, sorry, 8th of November 2024, my lord. May I just, my lord, place those facts, my lord, in brief. The plaintiffs have filed this present application for grant of interim relief. The plaintiff numbers 1 to 4 are the investors in shares and stocks through registered brokers authorized by the defendant number 12, that is SEBI. The defendant number 1 is a share and stock broker registered with the defendant number 12, SEBI. The defendant numbers 5, 6, and 7 are erstwhile directors of the defendant number 1. The defendant number 1 still is in control, is controlled and managed by the family of the defendant number 5. The defendant numbers 8, 15, 16, and 17 are group of companies of the defendant number 1 and part of the BMA group of companies. The defendant numbers 9 and 10 are non-banking financial corporations, and defendant numbers 11 and 12 are banking companies. 11 and 20, I'm sorry, are banking companies. The defendant numbers 13 and 14 are the registered stock exchanges. Defendant numbers 18 and 19 are two securities depositories. Number paragraph 2, the plaintiffs are investors in stock and shares listed with the defendant numbers 13 and 14, that is NSE and BSE. 1, Ratnabali Capital Markets Limited, a broker registered with the defendant number 12, SEBI, used to act as the broker of the plaintiffs till the time it closed its retail broking business in the year 2017. In the month of October 2017, the plaintiffs entered into a client broker arrangement with the defendant number 1 upon compliance of all formalities, which included filling in and submission of induction documents. The plaintiffs transferred their entire holding of equity shares and stocks into dematerialized accounts maintained by the defendant number 1. The defendant number 1 used to issue electronic monthly holding statements, MHS, in respect of the account of the plaintiffs. The last monthly holding statements was shared by the defendant number 1 with details of stocks held by each of the plaintiffs as on 30th of August 2019. The plaintiffs had carried on trading in the month of September 2019 through the defendant number 1, but the defendant number 1 did not supply to the plaintiffs any monthly holding statement of the said month. All of a sudden, on 1st October 2019, the brokering account of the defendant number 1 was frozen by the defendant number 12. By an email dated 1st November 2019, the defendant number 13, that is NAC, informed the plaintiff number 2 that by circular dated 30th of September 2019, the defendant number 13 had suspended the defendant number 1 with effect from 1st October 2019 for non-compliance of various regulatory provisions. The defendant number 1 was declared as a defaulter and expelled by the defendant numbers 13 on 13th February 2020. Similarly, is expelled by the NSE. The plaintiffs also came to know that certain adverse proceedings had been initiated against the defendant number 1 by the defendant numbers 12, and on 7th October 2019, interim order also been passed by the defendant number 12, SEBI, under sections 11(4), 11(b) and 11(d) of the Securities and Exchange Board of India Act 1992, read with Regulation 35 of the Securities and Exchange Board of India Intermediaries Regulations 2008 against the defendant number 1, its directors, and other sister concerns. On 21st of January 2021, the defendant number 12 passed a final order, this is SEBI's order, with regard to the acts and activities of the defendant number 11, that is HDFC Bank, in connection with the affairs of the defendant number 1. Being aggrieved with the said order, the defendant number 11 has filed an appeal before the Learned Securities Appellate Tribunal, and by an order dated 18th February 2022, the Learned Tribunal quashed the order dated 21st January 2021. Being aggrieved with the order of the Learned Tribunal, the defendant numbers 12 and 13 have filed a special leave petition, and the same is pending before the Honorable Supreme Court for adjudication. The defendant number 13, and this is important, my lord, conducted a forensic audit into the affairs of the defendant number 1 through Ernst & Young, and it was found that client securities of rupees 116.62 crores having nil debit balance was pledged by the defendant number 1 and illegally invoked by the defendant number 11, that's HDFC Bank Limited. The plaintiffs have no manner of ascertaining the fate of their securities that have been illegally pledged by the defendant number 1. The plaintiffs are not aware whether their securities are lying with any of the defendant numbers 9, 10, 11 or 20, or whether they already dealt with the pledgee. On 11th of January 2023, the defendant number 13, that is NAC, National Stock Exchange, passed an order. Lord, it will actually be defendant number 12, SEBI. It is 13 has come by mistake. On 11th of January 2023, the defendant number 12 passed an order under sections 11.1, 11.4, 11b, 1, b2 and 11d, read with section 15HA of the Securities and Exchange Board of India Act 1992 and sections 12A1 and 12A2, read with section 23B of the Securities Contracts Regulation Act 1956. The defendant numbers 5 and 6 were kept out of the array of notices despite the defendant number 12, that's the SEBI, having directed an inquiry to be lodged into their roles by its order dated 2nd of January 2020. Mr. So-and-so learned advocate representing the plaintiffs submits that the allegations of involvement of the defendant numbers 5 and 6 based on the examination of materials available on record, but the defendant number 12 decided not to proceed against the defendant numbers 5 and 6, and they were not made notices in the proceedings. He submits that no step has been taken by the defendant number 12 against the defendant numbers 5 and 6, who were very much instrumental in commencing and establishing the practice of misutilization of client securities in the defendant number 1, particularly the defendant number 5, who was the director of the defendant number 1. 5 is one of the kingpins, Lord Avinash Agarwala. Mr. So-and-so submits that the defendants are in collusion and conspiracy with each other, having committed fraud on the investors of the defendant number 1. He submits that not only the defendant numbers 1 to 8 and 15 to 17 have committed fraud in collusion with each other, but also the banks and financial institutions, market regulators, stock exchanges and depositories, including the defendant numbers 9 to 14 and 18 to 20, that is CDSL, NSDL and Axis, have contributed to such malfeasance by systemic or specific negligence of their respective continuing duties and failed to detect, flag and eliminate such malfeasance at its initial stage. Mr. So-and-so submits that the defendant numbers 13 and 18 never objected to the creation of the concerned pledges. On the contrary, permitted the defendant number 1 to create pledges over securities available in its demat account even as late as 27 September 2019, that is much after publication of the SEBI circular dated 20th of June 2019. He submits that the defendant number 18 even allowed the defendant number 11, that is HDFC, to sell the pledged securities even after the interim order dated 7th October 2019. He submits that the defendant number 11, that's HDFC, had invoked the pledge on 15th of October 2019 and sold most of the securities and appropriated the sale proceeds towards the outstanding of the defendant number 1. The defendant number 18, which is the CDSL, curiously never objected to such sale, though the pledge was itself clearly illegal, wrongful and void, and thus the sale was also illegal, wrongful and void. Mr. So-and-so submits that the plaintiff numbers 1, 2 and 3 lodged their claims with the defendant number 14, that's the BAC, in respect of the fraudulent acts and actions of the defendant number 1. The defendant number 14 has intimated the plaintiff number 1 that the IPF trustees, IPF here being Investor Protection Fund trustees, have approved payment of a compensation for a sum of rupees 9,99,248 against the claimed amount of rupees 10,248. As regard the plaintiff number 2's claimed amount of 11,24,364, payment of compensation of 10,58,230 was approved, and against the plaintiff number 3's claimed amount of rupees 13,59,933, payment of compensation of 12,99,716 was approved. He submits that the plaintiffs are jointly entitled to a further sum of rupees 29 crores 65 lakhs 95,549. The remaining, my lord, with the NSE. Mr. Banerjee submits that the defendant numbers 1 to 8 are in connivance with the defendant numbers 9 to 11 and 20 committed fraud upon the investors of the defendant number 1. He submits that the defendant numbers 1 to 8 are interested in evading all liabilities towards the investors of the defendant number 1, and the defendant numbers 5 and 6 were also the masterminds behind the commission of fraud, having resigned from the board of the defendant number 1. He submits that there is reasonably apprehension that the defendants, particularly the defendant numbers 1 to 8, are interested to deal with their assets and properties in order to render the suit filed by the plaintiffs infructuous. He submits that the defendant numbers 1 to 8 are seeking to evade the plaintiffs as well as their liabilities in respect of the financial fraud committed by them in collusion and connivance with each other. Now, my lord, the main nub of the dispute. The plaintiff number 1 has made a claim of rupees. This is, my lord, the NAC. My lord has seen, my lord, before that the BAC.
Yes,
BAC is more or less a small amount was with them, and they have more or less said we'll give you compensation. Now, my lord, the nub of the dispute. The plaintiff number 1 has made a claim of 9 crores 90 lakhs 74,089 rupees, and the defendant number 13, that is NAC, admitted the claim of the plaintiff to the plaintiff number 1 to the tune of 9 crores 21 lakhs 21,162. So, my lord, it almost 85 to 90% of the claims admitted after examination. The claim of plaintiff number 2 is 74 lakhs 49,580.62, out of which the defendant number 13 admitted the claim of 65 lakhs 37,718.12. The claim of plaintiff number 3 was 1 crore 54 lakhs 94,567.18, out of which the defendant number 13 admitted an amount of rupees 1 crore 36 lakhs 41,207. The claim of the plaintiff number 4 was 34 lakhs 6,170.21, out of which the defendant number 3 has, it will be 13, has admitted the claim or rupees 31,61,515.41. The defendant number 13, without assigning any reason, decided not to proceed with the defendant numbers 5 and 6, but it is found that the defendant numbers 5 and 6 are also equally liable along with other defendants. The defendant number 13, it will be 12, my lord, which is SEBI. The defendant number 12 restrained the defendant numbers 1 to 3 and 7 to 11 from accessing the securities market, and also prohibited from buying, selling, or otherwise dealing in securities either directly or indirectly, or with associated with the securities market in any manner whatsoever for a period of 7 years and 5 years respectively. Considering the above, this court finds that the claims of the plaintiffs are admitted by the defendant number 13, and the defendant number 13 has passed restraint order against the defendant numbers 1 to 3 and 7 to 11. The plaintiffs have categorically made out a case that the defendants are interested to dealing with their assets and properties in order to render the suit infructuous, and the plaintiffs will not be able to catch hold the assets and properties. The plaintiffs have made out a prima facie case and balance of convenience in their favor. The defendants, having collusion and connivance with each other, have committed fraud upon the plaintiffs. In view of the above, the defendant numbers 1 to 8 are restrained for dealing with, disposing of, alienating and transferring or encumbering their assets and properties, and from withdrawing any amount, keeping aside a sum of rupees 29 crores 65 lakhs 95,549. And the defendant numbers 9 to 11 and 20 are also restrained from dealing with, transferring, alienating, or encumbering the securities available with them, if any, save and except for the purpose of returning them to the plaintiffs till 6th December 2024. Lord, then, Lord, there is a direction for service of corpus.
Yes.
I must show your lordship, Lord, that while my lord had made limited interim orders, and one such order came up for extension before my Lord Justice Ravi Krishan Kapoor. This is, my Lord, the order. It was mentioned on ground of urgency because the order would have otherwise been vacated. Justice Kapoor, my Lord, had passed, my Lord, the following order. একটা জজ সাহেবের কাছে copy আছে, জজ সাহেবের copy নেই?
Order dated
20th of May 2025.
Yes.
This is a clarification which Justice Kapoor has made. Matter has been mentioned on behalf of the petitioners. In view of the urgency pleaded, the interim order dated 8th of November 2024 is due to expire. By consent of the parties, the matter was taken up for hearing. It is submitted on behalf of the HDFC Bank that there are dues against the respondent number 1 in excess of rupees 120 crores. Admittedly, none of the defendants, whether private or statutory or financial institutions, have preferred any appeal against the interim order dated 8th of November 2024. After hearing all the parties and in order to obviate or negate any possibility of fraud, collusion or conspiracy, it is clarified that pendency of this suit and the orders passed therein shall not impede nor act as an embargo in the initiation of any steps for recovery by any of the statutory authorities or any financial institutions or banks insofar as the assets and properties which forms part of the subject matter of this suit. Such clarification is not opposed by any of the parties, whether the petitioners or the respondents. With the above clarification, the order of 8th November 2024 stands extended till 16th of June 2025. Therefore, my Lord, if any statutory proceedings are to be initiated, they can be initiated. However, the injunction remains.
Yeah.
Now, my Lord, while on this, my Lord, please have a look, my Lord, at the injunction application and the prayers that have been made therein. The injunction application, kindly come to, my Lord, page 68, my Lord, for the prayers.
Yes.
Please see, my Lord, the first prayer. Order be made directing the respondent numbers 9 to 11 and 20 to forthwith return the securities available with them, if any, in favor of the petitioners, and to take such steps in this regard as may be required till the disposal of the suit. B, an order be made restraining the respondent numbers 9 to 11, that's the financial lenders, and 20 from in any manner whatsoever dealing with, transferring, alienating or encumbering the securities available with them, if any, save and except for the purpose of returning them to the petitioners till the disposal of the suit. C, the respondent numbers 1 to 8 be directed to show cause as to why they should not be directed to furnish security to the tune of rupees 29 crores 65 lakhs 95,549, and if the respondents fail to show cause or show insufficient cause, the assets and properties of the respondent numbers 1 to 8 and the amounts lying in their bank accounts be attached before judgment. D, injunction restraining the respondent numbers 1 to 8 from dealing with and or disposing of and or alienating and or transferring and or encumbering their assets and properties and from withdrawing any amount from their bank accounts without first keeping apart a sum of rupees 29 crores 65 lakhs 95,549 towards the dues of the petitioners. And finally, my Lord, E, which is of pivotal importance, which has been disclosed in a Bombay court, but somehow not disclosed before this honorable court. The respondent numbers 12 and 13, that's the SEBI and the NSE, be directed to make over a copy of the report of the forensic audit undertaken by Ernst & Young into the affairs of the respondent number 1 to the petitioners forthwith. Lord, these Lord, were the array of prayers.
Yes.
B and D, my Lord, were granted, and B and D are ones that that have been extended from time to time, subject to the clarification I've shown your lordships. And we would be pressing, my Lord, for all the prayers. Pivotally important is also prayer E, which has been the document itself, its existence and filing in court have been admitted in affidavits. And my Lord, however, my Lord, they have not been placed on record here. We would also be requesting that orders be made, directing the same to be placed on record, because from there, my lord, the entire modus operandi of D1 would be absolutely clear. Now, my lord, what are we faced here? I'll try and, my lord, underline the dispute and the volume of fraud. My lord, in the earlier days, we used to have physical shares. Physical shares had distinctive numbers. They had share certificates which were issued. Those share certificates were held by the person who purchased the shares. They could endorse and sell those shares to any other person or persons through any of the two exchanges which are ordinarily operating. In the era of dematerialization of shares, DMAT, there is now no physical certificates of shares. You just have a number of shares which you hold. That number of shares remains in electronic form in the common pool of the broker. It doesn't come to me because trading happens almost every day, depending on ups and downs of the market. The broker, therefore, is a bailee of the shares, because apart from taking steps under my instructions for sale or purchase of the shares, the broker has the duty of ensuring that the shares are properly kept. They are all in electronic form. Had they been manual, I could have kept them in my bank. I could have kept them in my bank locker, etc. These all are DMAT. These are not manual at all. So there's no question of my having any control over them. The control of those shares are with the broker. But the broker is my agent who takes part in trade as per my instructions. Title to the shares.
So it will not be informed to you?
Yes, yes.
For 1 minute. No, just 1 minute.
Well, I would request Mr. Chaudhary.
Just 1 minute, Lord, to put it in the correct perspective. Lord, I am a stockbroker. I'll tell your lordship in 1 minute what is the problem in the matter. Lord. I am not taking sides. I am a stockbroker. So what happens is that I have, my lord, clients. Now clients, my lord, purchase shares. I do the purchase for them.
Correct.
It's not T+2. Within 48 hours, my lord, the payment has to be made and the share, my lord, has to go into the client's DMAT account. It can't stay in my general pool account. It can stay in my general pool account for 48 hours. Now, all the stockbrokers used to take, my lord, a loan from a bank. In this case, it was HDFC Bank, some 300 crores. The money comes to me. Now, my client tells me that buy 5 L&T shares, 5 ITC shares for me. So I use that money to buy the shares and I keep the shares in my general pool account. I don't send it to my customer's account, DMAT account. So he has no custody over the shares. His shares are, my lord, with me and I take a general pledge undertaking. So, my lord, I have control over these shares. And that pledge undertaking, I, my lord, give to HDFC Bank. So HDFC lends me 300 crores. All my customers' shares are pledged with HDFC Bank. Stock exchange, my lord, all Carvey consultants, me, everybody was doing this. Stock exchange, one day, my lord, SEBI decided enough is enough. SEBI said, if you have a customer's share, it should go into his DMAT account within such and such date. Whole business collapsed. HDFC, so I'm going to give the shares to my customer. So HDFC, my lord, got nervous because he's now got a 300 crore exposure to me without security. So HDFC sold off all the shares because his pledge is, my lord, given to HDFC. It went, a whole 300 crore shares, my lord, sold off. Now, today, if you want to buy shares after this debacle, client, my lord, has to get his shares in the DMAT account within 48 hours. Client also has to pay for it within that time. So I can't, my lord, I was giving him a service of giving him the benefit of HDFC's money, and, my lord, correspondingly, my lord, these shares were pledged. So when this happened, I went after HDFC because all the shares have been sold. HDFC says no money payable. I went after HDFC with a damages suit. All the stock exchanges on behalf of my constituents and, my lord, some constituents like the plaintiffs here have also proceeded against me. I have done large repayment. They have also got some money from Investors Protection Fund, etc. This is the background of the matter.
Okay. May I continue? Well, I'm grateful to my learned friend Milord for giving a bird's eye view. It was a bird's eye view, but there were certain blind spots. May I fill them up?
Okay.
Insofar as Milord, the general narration is concerned, Milord, that's perfect. But there are certain important elements in these transactions. The title to the shares belongs to me, the investor. At no point of time, and this is absolutely settled law, Contract Act, Beyond Contract Act, India, England, wherever you go, at no point of time does the broker have any title to the shares. When I order the broker to purchase a particular number of shares, it is squared off on the basis of my payments which are made within a given period. It has to be squared off.
Correct.
That amount of money which the broker in the meantime has to incur, entire thing is secured, Milord, with the stock exchanges. That is when you can become a broker, by furnishing large, huge securities. So, in lieu of those securities, which has nothing to do with the client's shares, you are allowed to function as a broker. You upfront book the shares in the market, you freeze it at a point of time, you buy it for your client, send the client an invoice, the client immediately makes payment of that amount electronically, and then the situation is squared off. There is a power of attorney granted in favor of every broker. This power of attorney is specific. It doesn't entitle any broker to pledge or pawn the shares belonging to the client to any third party or agency. Power of attorney simply says, in the event during this continuous circular transaction, the squaring up is not done by me, by the client, and there is a debit balance in my account, which means money I have to pay. To that extent, they can deal with the shares, not otherwise. This is the uniform scenario. Nothing changed.
Okay.
Garvey and BRH really laid down the road for a massive fraud only on this account. My lord, we'll see how. When these amounts, my lord, when these shares were held by BRH as the stockbroker, not only of mine, but of tens of other investors, these shares were pledged with the HDFC for the purpose of certain financial advantages taken by D1 and D8. Please see, my lord, D8 is BRH Commodities Private Limited. D1 is BRH Wealth Creators Limited. My lord, kindly seize. Therefore, my lord, kindly fill up the blind spots now and the entire scenario will be clear. So, BRH Wealth Creators Limited, which is the broker, it has pledged my shares without my consent to the HDFC Bank and the JM Financial, that's 9, Bajaj, that's 10, HDFC Bank, that's 11. It's been pledged with them. That pledge is a security for financial advances made to D1 and D8, having nothing to do with the transaction of shares. This is absolutely clear from the materials on record. I can show.
How the D1 and D2 is connected?
D1 and D8 are, my lord, they are group companies.
D1 and D2.
D8. Kindly see BRH Commodities. D1 is BRH Wealth Creators. They are all the BRH group. Lordship will pierce the veil. There are very sharp instruments of piercing there in the records. I will one by one show them. For the time being, let me just put this forward by saying this is one of the crassest and worst frauds that has ever taken place. Now, my lord, so D1 and D8 for their own purpose take financial advances from HDFC, which has nothing to do with the transaction of the shares. Please take it from me, my lord. It is therefore incorrect instructions to Mr. Chaudhary when his client says that this amount taken from HDFC is a usual pattern where I pay for. I means the broker pays for the shares from that amount and it's squared off later. Sorry, that's not the transaction. A broker has to be financially solvent in order to make that payment upfront and then get payment back from the client within 48 hours. And that financial solvency has to be guaranteed by putting in a lump sum money as security with the different stock exchanges. That's how my transactions work.
Correct. That amount can be secured by obtaining loan from the HDFC.
That the amount that has been obtained by them from the HDFC is financial advances from for other purposes, not connected with this at all. And number two, when they have pledged these shares with the HDFC, they have falsely alleged that they are the owners of these shares. This is on record. HDFC has accepted those shares as securities, granted them amounts, and then subsequently, when they have defaulted in the payment of their obligations to HDFC regarding transactions about which I am not concerned,
okay,
the HDFC has invoked the pledges.
Yes. Then
when the HDFC invokes the pledges or starts invoking the pledges, just before that, they are perhaps aware. My lord, I'll give your lordship a detailed list of dates. My lord can just take these milestones. It will be of great help. Because my lord will see a lot of justification, my lord. When financial fraud comes, my lord, justifiers galore arrive, riding on very, very subtle horses. HDFC has invoked the pledge of my shares, illegally pledged to them by D1 without my consent, beyond the scope of the limited power of attorney given to him. The limited power of attorney is only for squaring off of balances. There has not been a single occasion, and I am gone on oath, not disputed, that there has ever been a debit balance in my account. Whenever I purchase shares, I have always paid the amount within the stipulated T plus 48 hours that is allowed or allowable in law. I am told it is almost given the very next day. So there is no gap, no debit creation at all. HDFC has pledged those shares, has invoked the pledge and sold them off. HDFC has recovered monies from them. JM has invoked the pledges and sold them off, recovered monies from them. Bajaj Finance Limited has in the similar manner invoked the pledges, sold them off, recovered money from them. I think a month or so ago, before the HDFC pledges its shares, they write to after they are suspended, their account is suspended by NSE. Because of these irregularities, NSE in the meantime has come to know. I'll show you, lordship, the report. It will shock our combined conscience. Whoever we are appearing for in whichever case, it will shock our conscience. Lord, today my money in the share market, unfortunately, is not safe. Tomorrow I can become a zero balance account holder and no one can do anything about it if these people are to be believed. Now, my lord, this entire transaction, my lord, which has taken place hinges on the fact that my own shares have been given away. When their activities of client shares being given away as pledges to financial institutions came to the knowledge, my lord, of NSE, NSE suspended them and started proceedings.
yes.
When NSE suspends them and starts proceedings against them, that is the point of time when D1 writes to HDFC saying, no, these are our client shares, please give us back. Before that, the positive representation, and there are documents on record to show the level of crass fraud here. The positive representation is these shares are our shares. Our means D1's shares. And they are pledged with you, Mr. HDFC, as security for monies. So the moment the client, the D1 defaults, HDFC goes and invokes. It needs a suspension order and a rap on the knuckles from the NSE for D1 to suddenly wake up, smell the coffee and realize that his fraud will no longer be. So he drops a very nonchalant letter to HDFC saying, these are our client shares. Please don't invoke the pledge. We will give you other collaterals. That letter is on record.
Okay.
HDFC says, bird in hand is worth two in the bush. I have the shares in my hand. Your collaterals might turn out to be as genuine as you are. Therefore, the HDFC says, please keep your collaterals to yourself. I am selling off your shares. You sold them to me saying that you are owners. It was entered in the share depositories as you said that you had entered them as owners. Under such circumstances, we will treat that we have held a valid pledge, we'll sell them off. They are sold off. We are investors, my lord, sitting in our drawing rooms, thinking that our money is earning interest. It is earning rents, issues, and profits for third parties, and it's getting sold and siphoned. We are sitting here, my lord, thinking that it is safe. We come to know of this fraud when? Every month, there is a monthly holding statement which comes, MHS.
Correct.
After August 2019, in September 2019, no MHS. We continue to trade because, my lord, we are traders. We are not fly-by-night operators. We are clients. We continue trade. Subsequently, we come to know that they have been suspended by NSE. That's in November I come to know.
So by this period, what you have done? This 4 months?
Lord, we had in the meantime sought MHS from them. What happens is this: from 2017 onwards, not every month the MHS are coming. Now the MHS has not come. We have approached them. They say that there is some internal problem that we have, some technical glitch or the other, and therefore we are not in a position to give. We'll give you immediately. I'll show their responses. Their responses tell a specific tale that they had been proceeded against in this manner by the NSE, that their operation as a broker had been suspended, are things that are not made known to me. And the worst possible thing is, once therefore, my lord, my shares become someone else's pledge, are invoked and give money to someone else for some other transaction. Now, my lord, against the orders that were made of freezing, the HDFC goes up, my lord, before the SAT. That's the SEBI Appellate Tribunal. HDFC by the SEBI was directed, my lord, by the authority to return all the shares. 158 crores. They went up before the SAT. In the Securities and Appellate Tribunal, they said, we have treated his bona fide as a pledge. Our invocation is right. If anything is wrong, then the pledging was wrong. We are not bothered with that. We will treat that on the face of it, whatever has been the representation, and the SAT allows their appeal and quashes that order. Against that, the matters are pending, my lord, before the Honorable Supreme Court. And the Honorable Supreme Court is taking stock of the situation qua that. Here, my specific attempt to show before your lordship would be from their affidavits that the creation of the pledges were ex facie fraudulent. Ex facie fraudulent. I have scarred the entire law on pledge and right of the pawner and pawnee. I have yet to find a single case in which there is any concept of a kind of an equitable ownership over shares of a broker who's doing business on behalf of his clients. Not at all. Those shares are the client shares from day one. And another thing, my lord, which is extremely important is this part of the transaction of taking monies against the shares of clients, which has been indulged into by Carvey and BRH because they are corrupt, is not a part of the regular services as a broker. If an impression is being sought to be given that a broker regularly undertakes this liability by pledging shares, getting money, and then squaring off before the exchange, it's wrong. There's a SEBI circular of 2016, which is there on record, which will clearly show that that is not the scenario. That was not the scenario. They are not supposed to deal with the shares of the clients. Okay. Now, Lord, this is not a preliminary. I will finish as fast as possible. But this is egregious fraud on the face of it. Therefore, my lord, any day, my lord, hears me, my lord, I am ready to address your lordships.
Yes.
I was appealing for the bank. In fact, it is a fraud upon the bank also, because bank's money has been taken by Mr. Chaudhary's client on the basis of a declaration.
You are supporting the petitioner, or you are alleging?
No, I'm supporting. No, I'm saying I'm bona fide. I have not done any. I was given a declaration by Mr. Chaudhary's client that these are these shares are owned by him and he created pledge.
I don't mind, my lord. If
Which way you are, whether
Yes.
Decide later.
I'm in my own way. I'm saying Mr.
But
Chaudhary
if
can
he's,
come to me and pledge his shares.
But if he's supporting the petitioner, then I'll.
No, I'm not supporting the petitioner. In fact, it is the case of Mr. Arindam.
money to him.
My lord, it is the case of Mr. Arindam Banerjee that I am in collusion with Mr. Chaudhary. I'm not siding with anyone. It's a bank. I'm doing what was my duty.
PRH, which is there in this honorable court, I'll get an immediate decree.
Lord, school level diligence.
But the
My lord,
question is,
Mr. Chaudhary has forgotten those days.
in
Yes, Mr.
45
Chaudhary.
minutes,
No, he's
the
forgotten.
best document was only one document was shown.
Yes, so now
that is the ad interim order.
Now Mr. Chaudhary
Apart from that, he has nothing else to show your
My
lordship.
lord, these commentaries, interim commentaries which he is making, which part of the civil procedure code or the original side rules does this attract? Is he becoming
Lack of-
amicus curiae or
lack of-
amicus advocate?
My lord, because my client's bank
What are
account
these
is
commentaries?
attached.
What are the commentaries? Your clients are egregious fraudsters. Their bank account should be attached.
But due to paucity of time, hearing could not be completed in connection with GA 1 of 2025. Full stop. GA 1 of 2025. GA Com 1 of 2024.
My lord, he does have a case against BRH. I'm not for once saying no. I would not completely understand an injunction.
What is he?
But on all the directors,
Amicus?
my lord, their
Amicus.
personal
I
bank
will
account,
show all the
that-
Lord.
unless he can show a document to show
Yes,
that they have
that's
received
it.
something.
The-
Lordship will kindly
The
consider.
piercing of the veil concept
And
has
when he
gone
moved-
so far
And
that
he moved ex parte.
that wherever they have kept the money, that will be
Year all
yes.
the person
Wherever
with the
they have
date.
kept the money, that will be taken out.
क्या है?
The long arms of the law will reach wherever the money is.
At 31st
Lost
July, 3 p.m. 31st July at 3 p.m.
Then on that day,
Grateful, Lordship.
he will conclude.
Cut short, cut short.
Yes, unless Lord, he stops me from concluding.
I didn't disturb you,
If he-
except to assist you with the main
If
transaction.
he doesn't assist me, Lord, I'll conclude. Lord, the
I'll
interim order is
remember
only till 31st. Kindly let it be extended for limited period.
31st.
Yes,
Yeah.
otherwise, Lord,
Let it come on the
Lord,
31st.
I'll tell you, Lordship, no difficulty.
No, let it come on the 31st.
Please give notice of mentioning to all, Mr. Banerjee.
There on
Please give a
31st is there. Matter is on 30th.
no
31st.
31st.
Any difficulties if your Lordship doesn't remain, Lord, I have to
Interim
mention
order
someone will
continue
make a
till
clarification.
31st.
Yes.
Lordship is here only.
31st July.
Yes, yes.
Oh.
Grateful.
My lord, I am for the plaintiff, my lord.
Yes.
We have also filed one application which is also appearing as GS7, my lord.
What is the application?
My lord, this is for disclosure of some 4 documents, my lord.
Have you saw the copy?
Yes, yes.
Yes, you have you received?
Yes, we have received on Friday. My lord, they're seeking, the suit was filed in 2014. And order for discovery of an inspection was passed, my lord. And it was completed on December 17, 2024.
Correct.
And issues have already been framed. Now they want to disclose some documents.
My lord,
Could have known at the beginning, my lord, that
how you can justify?
I am, my lord.
Yes.
Since my learned friend was submitting, I didn't interfere, my lord. If your lordships kindly allows me, a short thing is, I sent a consignment of Pan Supari by a truck. In Meghalaya, it met with an accident and the entire truck went into the gorge, my lord.
Correct.
So there was a loss of the entire consignment.
Correct.
And that was covered by an insurance policy.
Correct.
So there was a claim and the claim was repudiated. This is the short thing, my lord. I have supported my earlier documents, and it was filed earlier by a different lawyer also, and it was a civil suit. Then it was converted sometimes in March 2023, and thereafter it was renumbered in 2024. My lord was very specific today for taking the evidence, my lord, but at the time of writing of the evidence, we have filed the judge's brief of document also. We find that they have inspection in their report, survey report, they have even disregarded the accident itself. My lord, your lordships kindly sees that the defendant number 2 is the owner of the truck. My lord, I received some documents from the owner of the truck that for the loss of that truck, they have received insurance money. And the insurance money was given to the owner of the truck, that is the defendant number 2, for the purpose that the truck was lost. So therefore, that documents was in the custody of defendant number 2, what we managed to get right now. And it was now the Xerox copy is with us and the original is with them. Now, another thing is, my lord, that we have sent the consignment to the consignee. So the no due certificate from the consignee, that is also required to prove that the loss suffered by plaintiff. I sent the entire consignment. So there was a payment, and thereafter that the payment was refunded back because there is a no due certificate. That is the documents. Kindly let me submit.
Yes, yes.
So that is the first document. That is the copy of the no due certificate, my lord. That is the first document. Then there was a letter of the officer in charge of that regional transport office, my lord. I am reading out page 4 of my application. Dakhin Dinajpur Balurghat, issued by the owner of the pertinent truck which met with the accident causing loss of the consignment, Sheikh Sirazul Islam, who is the defendant number 2 here, my lord. With the report of the said regional transport office providing report of the vehicle in accident, that the accident was caused and there was a total loss of the vehicle. Okay. And then a copy of the account pay check, my lord, that I was referring to, it was paid by the insurer to the owner of the truck. That there is a total loss and for which Sirajul Islam, that the defendant number 2 has received the payment. That is that is the document number 3, that is C. And then the copy of the tax invoice, come excise invoice dated 29th December, showing the packets of super is sent to the consignee, my lord. That was with the consignee. He's a third party. And finally, my lord, there has been a reference, although I'm not pressing in that way. There is another document that the revenue there is a custom, because pan supari is a custom product, because there is a custom imposition is always there, like tobacco products or likewise. So whenever there is a loss and all, then we got the refund. That was also under challenge by the insurance company in their written statement. But if your lordships kindly allows me, in their written statement, in paragraph number 8, my lord, under subparagraph C, D, H, J, they have categorically, K, they have denied even the accident. They have said that there was a geographical, there is an anomaly in the picture taken and this and that. So therefore, there was no accident and they failed to substantiate. Now, the substantiation of claim, the substantiation of proof of the accident, that has been denied by them. So therefore, what is as to the prudence of the plaintiff, that these documents are required for substantiation of this.
Where from you got this document?
Yes, that I have stated, my lord. First is, I have stated in, kindly see, paragraph 8, my lord, that those documents were previously not in the custody of the plaintiff. My lord gets it at page 4 at the bottom. Plaintiff, but it was obtained from the consignee. Consignee means to whom it was sent, being Messrs. Vishal Distributors, documents number A and D, my lord. And the documents referred to in B and C, being the letter of the owner of the truck, namely Sirazul Islam, is the defendant number 2. And the copy of the account pay check was lately obtained from the owner of the truck, that is defendant number 2. A and B was from the consignee, and the B and C was from the defendant number 2, my lord. That was not in our custody.
So where you got it?
Yes.
Where from you got this?
I got from the Vishal Distributor, who is a third party.
When you got this?
I got it just as I am instructed, my lord.
That is not mentioned in the application.
Is that I will, if your lordship says, I will tell that thing also.
No. On the advice of the court will not allow you.
My lord, this
as per the act, it is not permissible.
I understand, my lord, but this is for the substantiation, my lord.
But the court says,
yes.
If the document is up before the date of the filing of the case, how you have to justify? We are not justified.
Because it was not with me, your lordship.
Justified.
We then see the documents, and while writing the evidence, my lord, we find these documents are necessary. Then we contacted the parties, my lord, and accordingly that they have supplied this, my lord. That I have said in my affidavit, my lord.
You have said an affidavit, but where, how, which date you got this document? You are not stated. There is no corresponding that yes, you are returned to the.
My lord, I do have the correspondence also. If your lord,
is that?
I will submit.
No,
that I will submit.
Sorry, this is a lacuna. I am rejecting this application. We proceed with the suit.
My lord, then my lord kindly gives me a date, my lord.
Then I put the cost to you.
My lord, as your lord.
But 1 hour, what the court will do?
No, my lord, this I thought this would.
This could have been filed earlier. You could have mentioned.
Yes, my lord. No, this was filed, my lord. In
not only that,
in the June, my lord.
Is a party. He could have given a notice to produce.
My lord,
this kindly pass a formal
no, that is, my lord, this is a third party. I'm submitting, my lord.
Whatever it is
Vishal
not your defense. It is not your defense in the plaint. You got the written statement in 2014. You got the written statement 2014. Subsequently, discordant inspection was carried out. Then you also you have carried out the discordant inspection of both the parties. You have not filed an application. This court has specially fixed today for evidence.
Yes, my lord.
This was affirmed when it was affirmed 9th of July, just last day, just 2 days before 9th of July, it is filed. Know that the case is fixed today for evidence. Okay, you file affidavit in opposition. I am adjourning. Put the cost of 50,000 to the state.
My lord, kindly please don't put that much of cost, my lord.
That is required. That is required.
My lord, I am not here for delaying, my lord.
Lordship,
my lord,
dismiss it on the point of law itself.
No, you file. I am giving the chance.
My lord, kindly do not.
And for the defendant number 2, my lord, kindly grant me opportunity also, my lord, to file a petition.
The matter is specially fixed today for witness action by an order dated 5th of May 2025. Full stop. When the matter is taken up today at 2 p.m. for witness action, comma, Learned counsel for the plaintiff has submits that the plaintiff has filed an application being GA Form 7 of 2025, praying for leave to produce additional document. Full stop. Counsel for the defendant submitted the said application was served upon you when it was served.
Friday.
Only on Friday, that is on 25th of July 2025. 25th of July 2025. This court, the plaintiff had the knowledge that the matter is fixed, is especially fixed at 2 p.m. for witness action, and the date was fixed in the month on 5th of May 2025. The plaintiff has waited whole 2 months for filing this application only to get the adjournment of the stage of witness action. Accordingly, full stop. The counsel for the defendants prays for time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply, if any, there to be filed within a week thereafter. The case is adjourned, subject to payment of cost of ₹50,000 with the state legal, with the High Court Legal Service Authority. It is made clear that this cost has been imposed upon the defendant, upon the plaintiff, as due to the reason that by an order dated 5th May 2025, this court has especially fixed today for witness action, and the plaintiff had the knowledge that the matter is fixed today for a witness action, but only to avoid to examine the witness, the plaintiff has filed the present application. Let the matter appear on 27th of August 2025.
My lord, although tell anything, but can it be reduced a bit, my lord?
Later 50, I am giving on cases 1 lakh rupees.
No, my lord.
I am giving 1 lakh. If you tell, I will put the 1
No,
lakh.
I will.
Because this is 1 hour. What the court will do?
I'm sorry. I so apologize, my lord. But
yes, call the matter.
Grateful.
Item number 17.
my lord, can it be on the 1st of September?
Okay, 3rd September.
3rd September.
My lord, item number 17, my lord, I am for the plaintiff.
Yes.
Lordship, I am for the defendant, respondent bank.
But what has happened, my lord, there was direction for filing affidavits, my lord. They have filed their opposition to us, but there are certain documents that has to be obtained from the Supreme Court. Certified copies have already been applied, my lord. I'm kindly grant me 7 days time to file my reply and fix a date for hearing, my lord.
Counsel for the plaintiff. Where is your affidavit?
It is ready. We are filing it
They have
today.
served us. They have served upon us.
Defendant has filed affidavit in opposition in connection with GA1 of 2025 after serving the copy to the learned counsel for the plaintiff. Let the same be cut with record. Full stop. Counsel for the plaintiff prays for 2 weeks time to file reply. Let affidavit reply be filed within 2 weeks. Please the matter.
Lordship, one indulgence. There is an NCLT proceeding ongoing.
Huh?
There is an NCLT proceeding ongoing between the same parties. Let there been an express recording in your order, Lordship.
There is on the previous occasion also, my lord. He has paid for that.
Finish first. There should be kindly record direction in your Lordship, in your order, Lordship. Extremely sorry that this proceeding should not debar the progress of that
But
proceeding.
it has already been on the last occasion. It was said, my lord has not granted that prayer on the previous occasion.
Let me
Yes.
Yes, my lord. But that direction.
Act itself says the court cannot pass any interim order regarding the NCLT.
And we are not seeking any stay, my lord. We have not asked for any
Yes,
stay.
my lord. I am simply seeking time for.
Lordship,
We are
the
on
affidavit
12th
of service is filed along with our affidavit in opposition.
12th August.
Extremely
Yes,
grateful, my lord. Lord, we appear for the plaintiffs, my lord.
Service.
Extremely grateful.
Affidavit of service is also filed with the AO.
Affidavit of service filed by the plaintiff be kept with the record. Defendant be kept with. What affidavit of service?
Lordship, the service we have.
Opposition, my lord. Opposition.
But I am already admitting that I have received the opposition, my lord.
It's a mere technicality.
Yes, next.
Your Lordship has kept, my Lord. Your Lordship, kindly.
Next. 12th August, 12th August.
Extremely grateful, my Lord. Extremely grateful.
18, my lord, I appear for the plaintiff. Right here, my lord, on the earlier occasion, my lordship had passed an ad interim order, my lord, upon service, my lord, they were on notice. And my lord, the lordship had restrained them from operating their bank accounts, all bank accounts connected with their PAN. Now, my lord, on the last day, my lord, interim order was extended and the defendant had sought for extension of time to file affidavit in opposition, which your lordship has extended. Now, my lord, I had made a prayer to keep the matter in the list so that, my lord, I can press for further interim release. My lord, lordship had already, if your lordship takes up my notice of motion, lordship has granted prayer B.
Yes.
Lordship had granted prayer B. My lord, I'll be praying for prayer C and E today because, my lord, the subsequent development is this. My lord, may I hand up a newspaper publication? My lord, the defendant is presently in custody. Subsequent to the filing of the suit, the defendant was, this is a, if your lordship sees, my lord, the newspaper, the 26 crore scam that he has committed, and he has been, this lordship will find the name of the defendant which is highlighted, Madhusudhan Ajit Saria. But he's the one who has been, well, taken in custody. Well, I've been led by Mr. Bose.
Yes.
I was only saying that, since he has been taken in custody, well, there is no, and he's an individual. Assets are owned by him. Now, my lord, there is nobody who would, nobody that we know of, that who is now handling the assets of the respondent. He may siphon it off, and in view of the extent of scam involved, well, they can even, well, dispose of their properties, immovable properties, which is covered by prayer E. Now, in those circumstances, well, I am praying, my lord, that if your lordship grants an order in terms of prayer C and E, because the claim is completely admitted, my lord, if your lordship recalls, when if your lordship sees your lordship's order, the ad interim order of injunction, my lord, Mr. Bose, my lord, placed those facts that, my lord, he gave a bank guarantee to satisfy my claim. He had, well, I had supplied goods to him, he was supposed to pay. He did not pay, he assured that he would pay, and thereafter he furnished a bank guarantee to secure the payment. That bank guarantee turned out to be a fraudulent document. Because after he furnished it, he silently went to the bank and discharged the bank guarantee. He never gave us the original.
Yes.
But Lordship will kindly grant me leave to allow Mr. Bose to speak.
But naturally, a person like this should be where he is today. What he has done, can your lordship recollects? It's there recorded in the order. Bank guarantee, the guarantee that he is given, he has made two originals. One to me and the other to the bank. Well, this is the extent, my lord. And my lord, naturally, he is not appearing.
I have done one criminal matter in the contract that bank guarantees over. The authority has given a letter, please get it extended. He get it extended of his own and submitted to the department.
This is, my lord, this is a situation, there is no fear of law. When a person crosses that limit, so he is not scared of whether he is in jail, because when they are doing things like this, they are aware. And my lord, the best thing is that he is my distributor. He was basically working under me as my agent. Where your lordship has recorded already balance confirmation, reminders. Now, my lord, everything.
Who is for the defendant?
No, they had appeared.
Yes, on the first day they had appeared.
Asked for time to file opposition. Now they are not appearing. Lord, if would it be your lordship pleasure to consider prayer C for the time being?
प्लेंटिफ का
C.
अपेयर है, कौन सा मैं प्लेस पर टाइम नाम नहीं, कौन लिखा,
কি লেখা আছে?
कौन है, एसडी है, डिपेंडेंट का नाम है. Can you issue serve the notice, come tomorrow?
No, no, serve notice upon the advocate. Yes, we'll serve. We'll serve. Very well.
Come tomorrow.
Very well. We'll serve and come tomorrow.
Counsel for the plaintiff has brought to the notice of this court to the paper publication wherein it is paper publication and submits that the defendant has been arrested by the police.
Now, it appears that the defendant has been arrested.
क्या बोला? And
The
submits
media
that
reports
from
are
the said
equally
paper publication. From this said
deceiving.
publication, it appears that the defendant is arrested by the police.
Allegation of a blank
The
bank
allegation
fraud.
on the allegation of committing fraud.
Forged documents.
Committing fraud for a sum of rupees 26.80 crores.
Complainant উপরে নয় তো?
Crore. Counsel for the plaintiff submitted there is a change of circumstances, and as such, he prays for further interim order in terms of prayer C and D. C and D. This could find that by an order dated 18th July 2024, this court has directed the defendant to file affidavit in opposition, but today none appears on behalf of the defendant. Accordingly, the plaintiff is directed to serve notice upon the advocate on record of the defendant, informing that the matter will be appear on 30th.
30th. 30th. Very well. 30th. 30th. Great.
Let the matter appear on 30th July.
Grateful. Great.
Look, item number 19, I am in GA1, I am for respondent numbers 1 to 4.
Yes.
And GA2 is mine.
Yes.
That's an application filed by respondent number 1, that is defendant number 1,
Yes.
for Millard stay of proceedings, because Millard the dispensation under Rule 12A has been obtained, Millard, without no urgency.
You have filed?
I filed.
For revocation?
For revocation, Millard, which has been, I believe, Millard, now there is also a judgment by your lordship that it can be revoked. And apart from that, I want to rely on the recent judgment of Supreme Court of Justice Partiwala, presided in Dhanbad Fuels, Millard, which is saying that basically it is a mandatory requirement. If it is a pre-Patil case, then it has to be mandatorily stayed and referred to arbitration. If it's a mediation, and if it's post-Patil, then there is no option but to dismiss, provided it appears from the statements contained in the plaint. That is the only exception from what I could understand is that, yes, but if you deliberately suppress something which is cannot be there, then it's another additional ground. But I will try to show from the averments contained in the plaint, from the documents relied upon the plaint, there is no urgency. And
yes, so
Lordship, I am appearing on behalf of the petitioners. Lordship, I am being led by Mr. Devnath Ghosh. Lordship, he is on his leg. Devnath Ghosh, Lordship. Lordship, he is on his legs before court number 9. Lordship, I am praying for not today.
Affidavit completed?
No, my lord. Apparently the suit was filed sometime after taking this leave, way back in
19th June leave was
19th June leave was taken. But my lord, we didn't know about this. My lord, a summons was served subsequently. From the summons, it appears, and they have also filed an interlocutory application, which they didn't care to move until this date. But I can only come in after I get the summons.
Okay, let the affidavit file, then the final.
Well,
I have one humble submission to make. I am appearing on behalf of the defendants number 5 to 15. My lord, I have been served with a copy of the plaint along with the writ of summons and the documents annexed with the plaint. But my lord, I have not been favored with the general application 1, which I presume would be of the plaint.
I have been served of GA1.
Might be not against you.
No, my lord, the
Friends in the plaint are indicated that they may be
Yes.
asking for reliefs against me.
Okay. Yes.
And my lord, also if GA
By injunction application is not served upon the defendant number 5 to 15.
My lord, if I also make some submission, my lord, I am for defendant number 21 to 25. Lordship, I have also not been served with copy of the interlocutory application. My lord, since my lord is passing directions for affidavit in the GA2 of Mr. Bose, if similar direction could be passed in GA1 also, the copy can be served upon them. We can file our exchange our affidavits.
Lordship, we will serve upon the.
Have you taken instruction?
Lordships, let the matter remain in the list tomorrow, Lordships. And
No,
my
with
senior.
regard to you got the copy of GA2?
Lordship, we have.
GA2 you have to file. You will file affidavit or without affidavit
Lordship.
you will argue the matter?
Lordship, we'll file affidavit.
You will file affidavit. And with regard to the GA1,
I appear on behalf of respondents 16 to 18. Similarly, we have also not been filed with GA.
so you serve the copy to all.
Very
So I am passing on direction in both the application for affidavit. Yes, Mr.
Yes, my lord, I cannot ask for stay, immediately without you giving an opportunity. My lord, that's not also my prayer.
The plaintiff has filed an application being GA1 of GA Form 1 of 2025, praying for interim order. Defendant number?
The application is by defendant number 1 only.
Defendant number 1 has filed an application being GA2 of 2025, praying for revocation of the leave. Revocation of the dispensation granted under Section 12 capital A of the Commercial Code Act. Full stop. Counsel for the defendant number 5 to 15, 16 to 18,
21 to 25.
and 21 to 25 submits that they have not received the copy of the interim application, a copy of the application being GA1 of 2025 along with documents. Full stop. The plaintiff is directed to serve the copy of the GA1 of 2025 along with the document to the learned counsel for the defendants number 5 to 15, 16 to 21 and jo bhi hai na. By tomorrow?
Lordships.
By tomorrow you will serve? By tomorrow, that is 29 of July 2025. Full stop. Parties are directed to file their affidavit in opposition in connection with both application within 3 weeks.
4 weeks, my lord. My lord, I won't be available from 7 to 24. That's
11 volumes. Kindly.
The plaint is 11 volumes.
Within 4 weeks, reply if any there to be filed within 2 weeks thereafter. Please the matter.
Well, in both applications.
Both. Please the matter on 11th of September 2025.
11 September.
September.
Now, you have not served the copy of the injunction application to the other defendants.
Yes, I'll serve it, my lord.
That's why it's served. Then they
11 September, lordship.
now affidavits they will file.
I'll be pressing for
And Mr. Defendant number 1 has filed an application for
Lordship, hears that out.
revocation of leave.
Yes, lordship, hears that out.
You will not file affidavit.
Milord, so far as Milord 12A is concerned, I have already got a leave. It's a question, Milord. Today I have a leave. It's a question of revocation. That I move, Milord, my injunction.
Correct.
Milord, I move my injunction. It's, Milord, whether Lordship gives me, Milord, an interim relief or doesn't give me an interim relief. That's all.
No, they filed a revocation.
Yes, Lordship will hear me on revocation.
Okay, if you not file the affidavit in opposition, then I will hear.
Revocation. It's not necessary, Milord.
Not necessary.
Not necessary.
And what about the
I'll serve it.
what about the interim application?
I'll move it. I'll press for an ad interim or I'll serve them a copy. Let them give the particulars, I'll serve a copy.
Then without a
kindly say
it's only the plaint. I survive on my plaint or I fall on the plaint.
Did I say something wrong? That's also what I submitted. It's just that an opportunity was given. If they do not want to file, then I will be pressing for my stay application, my lord, without affidavit. That also your lordship records, and you will hear. I'm not shying away from anything.
ऊपर को ही रहेगा. Full stop. Counsel for the plaintiff submitted. He will not use any affidavit in connection with GA Comp 2 of 2025, and he will argue the matter on merit. Counsel for the plaintiff also submitted. He also prayed for ad interim order, ad interim injunction. Full stop. In view of the above, the plaintiff is directed to serve the copy of GA application GA1 of 2025 along with the documents to the learned counsel for the 5 to 15 21 to so by tomorrow.
By tomorrow we'll serve. Let them give the particulars.
By
to him
20
to serve.
by
I know
by
Mr.
30th July
The advocate and records on my other side.
2025. List the matter on 6th of August 2025 for hearing of both applications.
Hearing of both the applications.
Both, yeah. Let him press 12A first. I respond to it.
6th August.
Well, your lordship has recorded. He doesn't want.
I recorded. That's why
on the basis of the claim.
And with regard to the interim, the ad interim.
I'll press for it. It's
Then
whether I get it or not get it.
Okay.
I think that by Mr. Mukherjee is not available. 6 to be kept on 7.
Keeps it before, keeps it on 4th.
Okay, 7.
Do I have happened?
Yes, next.
Very grateful.
We got 20 minutes. Lordship will kindly take it up day after tomorrow.
Why?
The counsel will in some medical emergency in the family. He has not come to court. That's what I'm told. There's an execution application.
As per prayer made by the counsel for the decree holder, he said, John, let the matter appear on 31st.
31st. Grateful.
Yes, next.
21 is my application for execution of a decree, my lord, wherein lordship had been pleased to appoint a receiver for attachment of a property of the government of Madhya Pradesh, Chief Conservative Officer, Forest. Not a receiver.
The report is ready.
Yes. You are appearing for?
My lord, I am appearing for judgment debtor 1, State Bank of India.
State Bank of
State
India.
Bank of India.
No claim against him.
I have instructions to appear, my lord, and on last occasion, 26/2025, I had appeared, but my appearance was not noted, and my submission is that I have already cancelled the bank guarantees.
No prayer against him.
Kindly
I will
record.
record.
কপি আছে?
I'll help you.
Nobody's appearing for the Maharashtra. This is Madhya Pradesh.
No, the last occasion, last order passed by lordship, they appeared. They argued. Lordship would remember they were asking for.
So today?
So now the receiver, I am told that I have been instructed that he has taken possession. My lord. Symbolic possession is with the receiver. But may a copy of this report be served upon us?
Circulate copies to the party.
Okay,
appearing.
take the copy.
I'll
come up to.
But probably that will take steps ahead. If they don't.
If they will not come, then you have to take a preparation step for option, whatever.
Absolutely.
Those
prayers are there. That
counsel for the special officer. Special officer or receiver?
Receiver.
The receiver is present and filed report. After serving the copy to the learned counsel for the decree holder, let the report be cut with the request. Learned counsel for the. So, what is the good name?
Obhirup Rai Sannal. I am being led by Mr. Devashish Shah. He is
appearing for the State Bank of India.
Yes, my lord.
State Bank of India submits that. Yes, what is your submission?
My submission is that I had previously complied with the order and cancelled the bank guarantee.
Submits that he has complied with the order judgment passed by this court and order passed by this court and cancel the bank guarantee.
Yes, my lord. It is even recorded in Justice Patnaik's order
And
dated
cancel
3rd
the
of
bank
May
guarantee.
2020.
Cool. Counsel for the decree holder. Press for time to go through the report submitted by the receiver. Cool. Let the matter appear on 5th August.
Your Lordship kindly record that on the next occasion, if they don't defend number doesn't appear, my lord, then prayer D.
Then come on that day.
Very good.
None appears on ऊपर देखिएगा ना. None appears on behalf of the state of Maharashtra. Who is the decree judge?
On the last occasion, my lord, Mr. Shopon Banerjee, Ms. Shushmita
On behalf
Shaw.
of the state of Maharashtra.
Grateful. My
Item number 22.
At 22, my lord, I appear for the decree holder. But the last day, the last two occasions, when our lordship had directed the judgment debtor to file affidavit of assets, and also on the last day, lordship had passed an order of injunction restraining the judgment debtor from transferring or disposing of his assets. My lord, no affidavit of asset has been filed, and we had served, my lord, even my lord, the judgment debtor is not even appearing. But the track record, the track report annexed with the, may I file the affidavit of service? Track report says item dispatched. Well, he can't be found. Well, that is
when it was served.
It was
sent.
attempted to be served on 17th June. Well, till
17th?
now, yes.
Where is the decree or judgment debtor? What is the address?
The judgment debtor's address.
Malda.
Yes, Malda.
Oh.
But if the service could be effected through the court or the jurisdictional police station, because the postal agencies are not being able to serve it on the judgment debtor. Because in the suit also, I am told one similar issue had surfaced.
So through the again the same thing. If you go through the this
to the jurisdictional court, the district court, and implemented through the police station. Or I can make a paper publication, but that I do not know how that will.
Okay, from the file requisites, sufficient requisites in the department, and it will be served through the district judge of the concerned district. Upon the the district judge will file the report.
Yes. Yes.
Learned counsel for the decree holder has filed affidavit of service showing that the notice was sent to the judgment debtor through speed post, but track report shows only the item dispatched, but it is not proved that whether the notice is served upon the judgment debtor or not. Counsel for the decree holder press for service upon service of the notice of the present execution case upon the judgment debtor to the London district judge of Malda district. Malda district. In view of the submission made by the counsel for the decree holder, the decree holder is directed to file the requisite process in the department within a week from date, and the department is directed to serve the notice of this execution case upon the judgment debtor through the London district judge of the concerned district. Let the matter appear on 20th August 2020.
Alright, in the meantime, simultaneously with this direction, would your lordship also direct the judgment debtor to be present before this court? Prayer C.
First service be completed, then
very well. I'll make
if
the
received, it will not come, then automatically consequence will follow.
Grateful.
Next.
Number 20.
Your lordship, I appear on behalf of the judgment debtor.
I appear for the decree holder, my lord.
Lordship, time to file affidavit of assets.
In the meantime, my lord, I will pray for my lord, prayer B.
What?
Lord,
What is
bank
the decree?
accounts. The decree is of 2020, 19th of January 2020. 9th of January.
Amount, recovery of amount.
Yes, my lord.
22 lakhs 46,000.
Such a price on account of goods
Yes,
sold.
but thereafter 12% interest. So as on 31st of
paid.
December 24, it
What,
is around
what, where
51
you,
lakhs.
what you paid for? What you asking for now?
Prayer B, my lord, attachment of their bank accounts, my lord.
Let me come
Let
up
me
with
file,
my
file
affidavit
the
of
first,
assets.
well, let you file.
So in the
Also
meantime,
become-
lord, they will.
No, I will disclose the bank accounts if.
But if you disburse all the amount, what will happen?
You will have the statement. Your lordship can always call for the
return of that money.
if it is siphoned off, if my client does siphon off.
And my lord, or my lord, at least scheduled A property, my lord, that is appearing at page 11.
Under counsel for the judgment debtor prays for time to file affidavit of assets. The counsel for the decree holder prays for interim order in terms of prayer B. Prayer B. Full stop. Consider the submission made by the counsel for the respective parties. The judgment debtor is directed to file their affidavit of assets by
3 weeks. 2 weeks, your lordship.
By 2 weeks. Full stop. In the meantime, the decree holder is restrained. Judgment debtor is restrained from alienating any amount by keeping aside an amount of rupees 51,63,928 in connection with PAN number AAFCP 62278 capital H for 3 weeks. Let the matter appear on 12th August.
Lordship, may I only request one thing, your lordship? Your lordship has restrained me from operating my bank account
Keeping aside that.
Keeping aside, lordship, only humble request, if this amount is including the interest, I have not gone into the calculation.
Okay.
Kindly make it to the principal, that is
Principal,
2246.
Amount
Lord, this is as per the decree.
22,
4652.
46, 524.
Great,
Then
your lordship.
22, 46, 524.
Great, your lordship.
Lord, I am for the decree holder. And on the last occasion, my learned friend was required to take instruction to pay in the installments, my
I have, my lord. I have affirmed an affidavit, my lord, and in the meantime, I have also made payment of 1 lakh rupees.
Total,
That
my lord,
amount
I have received 5
total
lakhs.
amount.
My lord,
Now-
total amount was 36 lakhs 10,000. I have received 5 lakhs, my lord. Now it is 31 lakhs.
5 lakhs.
Only 5 lakhs, my lord. And 31 lakhs 10,000 is due. And my lord, after filing of execution application, 4 months interest is, my lord, about 1,86,000. So total amount comes to 32 lakhs 96,000, my lord. Till today, my lord.
If your lordship takes paragraph 7 of my affidavit,
As a decreed as on June without interest would be approximate 32 lakh 10,000.
that was as on 23rd June. Thereafter, 1 lakh paid, so it is now 31
31 lakh 10,000.
31 lakh 10,000.
Yes.
Remaining decreed 10 equal installment.
Yes. 10 equal monthly installments, if your lordship kindly grants.
10 months.
Let it be, my lord, 6 installments, my lord. Let it. And the last installment should
But
include
he
the
will
interest
default.
of
But
4
he will
months.
default, not be able to pay. But then again, my learned senior friend would
It
have
is without interest.
With interest. With interest.
with interest. This calculation is with interest. But further interest, if your lordship could kindly condone.
4
But
months, my
from
lord,
this
only-
day, my lord, if the interest could be condoned.
Given 6 installment.
He will not be able to pay. My lord, I'll be very, my lord, honest with your lordship. He would be able
So,
to.
okay, in that case, I am fixing every date here.
Yes, ma'am.
Kindly do that.
Kindly, my lord.
I'll fix
Otherwise,
every month the date will be fixed. So you come with the demand, not check.
Demand draft,
Demand,
my lord,
demand
demand
draft. Yes,
demand up or your RTGS slip.
My lord, I shall bring it.
yes, my lord.
Even we will be benefited by that. Every month will come.
Other and my lord,
Oh.
further G application to avoid
Then-
further G application, my lord.
Correct.
Yes, my
That's
lord.
why. To further any
I mean, the last 4 months, 4 months interest is, my lord, 1 lakh.
I will record if you one installment he
If in default of even one installment, when necessary orders, my lord, will follow.
So what is the total amount? 3610. 36 lakh 10.
Yes, 3610, out of which 5 lakhs paid
So 31 is remaining.
31
31 10.
And my lord, further 4 months interest after execution.
He's being
After execution
paying the
application is
principal.
filed,
The
my lord.
interest could be condoned, my lord.
That's why in default I will pay. I will say.
Let
In
him make
default,
payment.
he will default. He has to pay the compound interest.
My
also.
lord, my lord.
The judgment debtor has filed an affidavit stating that out of the total decretal amount along with the interest of rupees नहीं क्या बोला stating that नहीं stating that out of the total decretal amount of rupees 36 lakhs comma 10 comma 000 within bracket along with interest comma the judgment debtor has paid 5 lakhs to the decree holder and the judgment debtor shall pay the balance decretal amount of rupees 31,10,000 within 10 monthly installment full stop. Counsel for the decree holder submits that it should be submit that instead of 10 installment it should be 5 installment so that the decretal amount can be realized as early as possible. At the learned counsel for the parties, this court find that the decree judgment debtor has already filed 5 lakhs to the 4 lakhs, na? 5 lakhs.
5 lakhs.
5 lakhs to the decree holder and is ready to pay the balance amount of rupees 31 lakh 10,000. Accordingly, the judgment debtor is directed to pay the remaining amount of rupees 31 lakh 10,000 within 10 installment of each in equal 10 installment on each month. The first installment shall be paid by when the last payment was made.
Last payment in July. No, my lord, 22nd July.
क्या बोला? First installment when it shall be paid by 22nd of July, August 2025. Lease the matter on 22nd of June, August 2025. Lease the matter on 26th of August 2025. It is made clear that if any of the installment the judgment debtor failed to pay the amount, the necessary order will be passed with regard to further interest on the said amount.
Grateful.
Affidavit filed by the judgment debtor be kept in the record.
25, Your Lordship, this is my execution application. Lordship had indicated by Your Lordship's last order that we serve upon them, although the decree is within the period of 2 years. Your Lordship, we have effected service. Your Lordship, however, the service has been effected on the learned advocate on record who was conducting the appeal before the appeal bench before this honorable court. In any event, Your Lordship, the appeal has been dismissed. I'll just file the affidavit of service to such effect. Your Lordship, now they are not appearing. Lordship, now it's time that a
Where is
warrant.
the order of dismissal of the appeal?
Your Lordship, that I will just. Your Lordship, I'll just indicate. I apologize, Your Lordship. I do not have a separate copy. We'll file it through the court. So 19th of June 2025. In any event, Your Lordship, there was no stay.
It is same address each.
Yes.
The same address had been enumerated in the cost title in both the appeal and. Your Lordship will also appreciate in any event that the conduct is nothing but vociferous of prevarication.
Notice was served upon the judgment debtor.
Yes, Your Lordship. 11th of June 2025. Notice was served by terms of Your Lordship's order. Anyways, within 2 years, but by abundant caution, we've served them.
First left হয়ে চলে এসেছিল তখন I
Yes.
made a prayer.
Your Lordship, in fact, my learned senior had appeared on the last occasion. On the first occasion, the the service was returned on account of the with the note that they had left. Your Lordship, subsequently, the advocate on record who was conducting the appeal before the appellate court of this honorable court, she was served upon. She's accepted service. Your Lordship, they are not appearing. Your Lordship.
What can be done?
Your Lordship will kindly issue the warrant of arrest. Your Lordship, in the any event, the inceptive occasion, I had prayed that an injunction in terms of prayers G and F be granted. Your Lordship was pleased to direct me that I cause service upon them. Your Lordship, I have caused service of the notice upon them. Despite that, Your Lordship, they do not appear. So, Your Lordship, this is apt that not only the injunction but the warrant of arrest be issued, Your Lordship.
The decree holder has filed the present execution case for execution of the decree passed by this court dated 10th September 2024. 10 September 2024 for realization an amount of rupees 25,20,606 along with interest, total amounting to rupees 43,24,255. Counsel for the decree holder submit that initially the notice was served upon the sent to the judgment debtor, but it was returned unserved with the endorsement left. Subsequently, in terms of the as per the direction passed by this court, the copy of the notice of the execution case has been served upon the advocate on record of the judgment debtor who was appearing in the appeal on behalf of the judgment debtor. Counsel for the decree holder brought to the notice of this court that the appeal preferred by the judgment debtor is also dismissed. But today none appears on behalf of the judgment debtor. Counsel for the plaintiff submit that as the appeal is also been dismissed and that the judgment debtor is not appearing in the matter and trade for interim order in terms of prayer.
Your Lordship, prayers F and G.
Prayer F and G. In view of the submission made by the counsel for the decree holder, the judgment debtor is restrained from withdrawing any amount from the bank accounts of the judgment debtor connected with PAN number AA FTG 1144 capital D without keeping aside the amount of rupees 43,24,255. The judgment debtor is also restrained from alienating / encumbering or creating any third party interest with regard to the assets and properties of the judgment debtor till the disposal of the instant case and till the disposal of the present execution case. The decree holder is directed to again serve the notice upon the judgment debtor by speed post and to file the affidavit of service on the next day.
Your Lordship will also kindly give us the liberty to serve upon their advocate on record.
They are not appearing.
Your Lordship, they have left the premises concerned. Your Lordship. That's what they are saying. So this is nothing but a deliberate action of evading service.
You file the affidavit of service on next. If the same report will come, then I'll pass appropriate order.
Your Lordship, I will not press for it. And even Your Lordship, if I may just pray for Your Lordship's indulgence that a warrant of arrest be issued. Your Lordship, because this judgment letter, Your Lordship, this is not the and beyond the records, probably I'm saying this, Your Lordship. This is not the first time this event is occurring. They've been evading service at the decree stage.
Decree holder is directed to serve the notice upon the judgment debtor by speed post through the what is the address?
Your Lordship, the address as adduced in the cost title is
the officer in
Ganesh.
charge. Which police station?
Your Lordship, perhaps this would be the police station.
You persons are not writing the PS.
Your Lordship, I apologize. I should have. Your Lordship will just give me a moment. I'll just check.
Durgadas Mukherjee Street, Kolkata. Which PS?
Lordship, perhaps subject to correction from my learned senior, Your Lordship, this would be the Hay Street Police Station, Your Lordship. Your Lordship, in any event, I'll just check up and I'll inform Your Lordship's officers.
To the officer in charge, Dash Police Station.
I'll inform Your Lordship's
Dash Police
officers.
Station. And to file affidavit of service, Dash Police Station. And to file the report on the next, and the officer in charge is directed to file the report with regard to the service of notice upon the judgment after on the next date fix. Leave the matter on 19th August. 19th August.
Your Lordship, my instructions are, Your Lordship, would it be Your Lordship's pleasure to direct that the learned advocate on record who was conducting the appeal be present on that?
Why the advocate should be a party to
No,
take
of
decision?
course, Your Lordship.
Yes.
Your Lordship, just on a personal note, beyond this brief, Your Lordship, I apologize. On Friday, Your Lordship had called on a matter. My colleague was here to take her time on my ground. Your Lordship, it's not apt at my stage. I was on a professional commitment outside, Your Lordship.
What matters over?
Of course, Your Lordship. I'm grateful to Your Lordship.
My lord, I am for the decree holder, my lord, identical matter Senko. Here, my lord, I am claiming 66,17,500, my lord. Execution has been filed, my lord, and my learned friend has to take instruction, my lord, from his client.
Yes,
My
where is
lord,
the affidavit?
I have filed affidavit of assets so far the judgment debtor is concerned, my lord.
Huh?
So far the judgment debtor is concerned, only one judgment debtor. I have already filed affidavit of assets, my lord. Now, by last order, your lordship, 8th May 2025, also directed the
all directors
to file.
my lord,
Yes.
to file the affidavit of assets. I have filed 3 GAs in respect of them. Those 3 GAs are pending before your lordships.
Yes.
My lord, the 3 directors, none of them are the plaintiff, not judgment debtor, and so far,
Where is the
directors
affidavit?
are
Where is
concerned.
the affidavit of the judgment debtor?
Judgment debtor affidavit of assets is there, my lord.
What you have stated? No money.
My lord.
What you have stated in the affidavit? No money.
No money, my lord.
No,
Kindly
not
see,
no money.
kindly see, my lord.
No, no.
Achha, okay.
Okay.
Yes, yes. What is the affidavit of asset says?
Affidavit of assets says that whatever that is in paragraph number, I have stated in paragraph number 8, A, 1, 2, A, B, C, D, all are my assets, my lord, and properties that I have stated there. But so far the bank account is concerned, my lord. But so far, my lord, first of all, let me clear it I am very candid to say that. So far the assets of the judgment debtor is concerned, that is maybe redundant or immaterial, because my lord, so far judgment debtor is concerned, my instruction is that by gradual repayment they will clear it. If the interest part is withdrawn and some time is given, then
how many? What is the principal amount?
My lord, principal amount is, my lord, 53,65,000, and interest thereon, my lord, 11,52,000.
Correct.
And cost your lordship awarded 1 lakh rupees.
Correct.
66,17,500.
Yes. How much your client is ready to pay?
My lord, at the first instance, I will advise my client to pay as much as possible. I don't know how much. I have to take instruction, but I will advise so that then after, my lord, in to some extent lenient approach, they can pay back at least 15 months. Maybe if granted, it will be grateful. It will be very much. I will be very much grateful for that. so far the judgment data is concerned.
When you take the instruction.
I will send message
Last
today.
occasion they asked time, my lord.
Correct.
No, I did not ask time.
Yes, when you take instruction, when I can self-fix the matter, or I will pass an order, let the judgment debtor be examined in the
My lord,
court.
they have appeared in the another matter. They all the directors appeared before your lordship and undertaking.
That's why I will not hear the other application. which
Well, my lord, I have to submission, my lord, on their report, my lord. Kindly see for once for their affidavit of assets, my lord.
Yes,
Kindly
tell me.
once.
Yes, tell me.
From paragraph 4, my lord, they have said, my lord,
Paragraph.
the affidavit of assets with regard to the company's functioning, my lord. What they have given, my lord, the following employees are dependent upon the judgment debtor. Manager 1, accountant 1, cashier 1. And the permanent monthly income of the judgment debtor after paying tax is 3,42,430. It cannot be believed, my lord. Senco Jewelers is only of paying tax is 3,42,000. Then, my lord, further sources nil. Judgment debtor paying rent annual sum 49. I do not comment, my lord. Kindly see the paragraph 8, my lord. Bank account, they have only 10,000 rupees.
That is the amount.
My lord,
yes.
Then only 10,000 rupees in the current account, my lord. And 2 also. A2, my lord. 10,000 minimum balance they are keeping. And then stock and shares, my lord. This is very important. Stock is nil. It cannot be, my lord. In a Senco gold jewelers, in a showroom, stock cannot be nil. There must be a stock of gold.
Okay, you examine that judgment debtor.
But, my lord, if they want to pay, my lord, I am ready because my client is a small jeweler.
You have a two option. If he want he given the option, I am
I'm
fixing
only-
after a week. Let he take instruction how much amount, how many
My lord.
installment he will pay.
My lord.
If you are not ready, then I will direct you examine the judgment debtor on doc.
But, my lord, I want to submit, my lord, one thing. Let them produce the audited balance sheet. This balance sheet is of no use, my lord, because they have just given a audited balance sheet filed last 2 years. Let them produce on the next date.
When the witness will examine, you ask for that.
My lord. In
My lord, I
You
have
ask for that.
Yes, my lord.
Then he will say, I will not.
Now,
Then
my
he
lord,
will say that
they
he
have
will say,
filed
I
a
will.
GA application
there.
taking the point of corporate will. The directors are not.
Okay,
My
I will
lord, I'm
decide
sorry,
that.
I'm sorry.
I will decide that
My lord.
whether it is a corporate will, whether they can be added or they can be summoned, and then this court will decide. When the court has passed an order for issuance of the notice upon the director, then the court has to decide whether it is a corporate will or whether that what is to be done. Correct. Now, if he is telling that when you will take the instruction,
By today itself, I pass the message, my lord. At least 1 or 2 days may be required for taking
then
instruction.
I am fixing on 31st.
31st, my lord.
31st?
31st. My affidavit of assets is exactly in terms of Order 21, Rule 41, 2, my lord, and read with Appendix E of first schedule.
Leonard
So
Counsel
therefore,
for the judgment debtor press for time to take instruction. Accordingly, case is adjourned. Let the matter appear on 31st of July 2025.
Grateful.
And so far the application, G application.
Let it be on record. Let me see. If it is settled, then automatically that will go over. If it is not settled, then I will decide that also.
Yes, my lord, because those
Yes,
those
call the
sections
other
should
matter.
not be there, my lord, as per my prayer, my lord.
I'm grateful.
Fix matter.
I just keep that in here. I tell them on 9 below the fix.
Yes.
Appear for the plaintiff, my lord. My lord, today is fixed for witness action by the plaintiff. My witness is present, my lord. My lord, as per the commercial courts, the process, we are preferred to file a written affidavit in opposition, my lord. So we'll just tender that, my lord. So out of just to get the roadmap clear, my lord, there are certain admitted documents, so we are tendering it. Remaining documents, we can put it specifically and we can tender them separately. Yeah, copy we have served it. We have served a copy on your advocate on record. Give the original. My lord, we are kindly, can the witness be present?
Yes.
একটা কপি দিও না।
मैं राकेश कुमार फ्रॉम स्टार
मैं
राकेश कुमार ऑफिसर स्टार पेपर मिल्स
जो कुछ बयान दूंगा वो सच होगा
वो सच होगा
मेरे बयान में
कुछ
भी झूठ नहीं होगा
झूठ नहीं होगा।
ईश्वर मेरी सहायता
ईश्वर मेरी सहायता करे।
आपका नाम बताइए।
राकेश कुमार
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 जी का नाम
श्री फत्ते सिंह FATTE फत्ते सिंह TTE
There's one thing that we'd like to indicate, Malad, some of the originals of the documents that we referred to in the affidavit of evidence were destroyed in a fire at the office, at the factory office of the plaintiff. So what we have annexed with the affidavit of evidence and what we referred to are scanned copy, as in photocopies, printouts of scanned copies of photocopies of the originals.
Have you obtained that certificate?
No, Malad, we haven't referred to that. We will need to. We can file it
And
by way of.
regard to the fire, if it is lost in the fire, have you got the report?
Yes, police report is there, the complaint is there, but certificate is not there, Malad. So we could.
But you have to give the affidavit under 65B.
65B. So, Malad, we can give that as a supplementary affidavit.
65B is not the issue, my lord. Only thing, my lord, this will then go as a secondary evidence.
Secondary evidence. That's why because if it is not, then it has to be covered with the report of the police station
Yes.
or the fire authority, whatever they are relying upon, and this affidavit. That has to be.
Affidavit hai?
I just for the perusal right now. You can.
I'm showing you this document dated 11th March 2025. What is this document?
एविडेंस ऑफ एफिडेविट है।
Whose evidence on affidavit is it?
इसका affidavit है।
ये स्टार पेपर मिल की तरफ से फाइल किया गया है।
This affidavit on evidence have been filed on behalf of Star Paper Mills Limited.
Please look at page 30 of this document. Whose signatures are appearing at this page of this document?
This is my signature.
This is my signature.
Can you encircle?
Not necessary.
Not necessary. Okay. What do you have to say about the contents of this document?
लिखा है वो सत्य है, सही है?
बिल्कुल सही है।
True and correct.
The contents of this document, not true and correct ones.
What about the contents of the document? You have put the answer to the mouth of the witness.
I'll just rephrase. Are the contents of this document true and correct?
Correct.
Yes.
हाँ correct.
Yes.
आप हिंदी में बोल सकते हैं, नो प्रॉब्लम।
सही है। हाँ जो भी डॉक्यूमेंट्स हैं वो बिल्कुल सही है।
नहीं, वो जो लिखा वाला है,
हाँ जो भी लिखा हुआ है वो भी बिल्कुल सही है।
आप इंग्लिश नहीं बोल सकते, हिंदी में बोलिए, कोई प्रॉब्लम नहीं है।
Who has prepared this document?
ये हमारे वकील साहब ने, और जो ये वकील साहब ने बनाया और हमारे उसमें बना है, ये नहीं हमारे कहने पे बना है।
This affidavit has been prepared by my advocate on my instruction.
Well, I'm tendering this affidavit of evidence.
Not necessary. It will affidavit.
As far as the annexures are
That's a
concerned,
yes.
ma'am.
Out of the document, if the admitted document, you said that will taken into concern. If it is not admitted, then you have to confront the original to the witness along with this JVD. What is the number? Then it will be accepted.
So we don't have the original. We
What
have
about the document?
very well, madam. Please come to page 31. This is admitted, not exhibit A, which we have marked. This is admitted. So, Malad, that can be marked as exhibit A. Page 31,
Page
which
30,
is the power of attorney.
Page 31 to
32.
Page 31 and 32 of
the evidence of the evidence.
তাই তো বলছি। Of the affidavit of
see देख ये दिए affidavit वो तो
এটা
admission
it's
denied
not admitted না
ওটা তো পরে ওটা automatic, that is
আচ্ছা exhibit B থেকে স্টার্ট করছি সরি হ্যাঁ copy of the page 33 to 52 please look at page 33 to 52 exhibit B. This is an admitted document. This can be marked as exhibit
page 33 page
33 to
52
of the affidavit of evidence are marked as exhibit
A থেকে হবে না
A होगा
A
one होगा
A
B one क्या A क्या है
ये तो plaintiff से तो
no you have written in the examination sheet B have mentioned
yes in the
Because
evidence because power of attorney is exhibit A and then B is agreement.
so you will not produce the power of attorney
Original has to এখন we don't not having the original right now my lord. We'll produce it.
okay exhibit B okay ये तो उसका बस है न्यूज़ लोग लिखा हुआ है
I may have some questions on the power of attorney.
your affidavit of examination you have mentioned the exhibits in the examination
Yes.
that's why I am not I am telling you only mention the document not to mark because sometimes this happens
Right.
exhibit only this is the original copy this is a copy of the agreement that's all
In the affidavit that is the way it would
that's
be
the
better.
exhibiting at the time of evidence
Okay.
because what is happened the same thing now
It's changing.
change
Right my lord. We'll keep that.
exhibit A कर दो
আচ্ছা এবার
exhibit A
Page 33 to
हाँ 30
সিটা তো
exhibit A
এনে কেন অ্যাডমিটেড তো তাহলে তো এগুলো এখানে অ্যাডমিটেড লিখে নিব Exhibit C is the document appearing at page 53 to 79 that is also admitted
53 to 79 exhibit
marked
B
as exhibit B. Next I'm showing you page 80 of your affidavit of evidence. What is this document?
ये कंप्लेंट है हमारे को जो कोल की क्वालिटी सप्लाई की गई थी वो खराब थी और उसके लिए हमने कंप्लेंट करी थी ईसीएल को ये हमारा लेटर हेड है और जो नीचे सिग्नेचर किए गए हैं वो हमारे ऑथराइज सिग्नेटरी हैं कंपनी के
this is the complaint letter issued by the plaintiff company to the defendant ECL informing that the material supplied by them is low quality. This said letter contains the signature of authorized signatory of the plaintiff.
Where is the original of where is the original to who has signed this document?
हमारे कंपनी के डिप्टी जनरल मैनेजर आर.के. शर्मा जी के साइन है
our company's deputy general manager R.K.
शर्मा जी
Sharma has signed this document.
Are the contents of this document true and correct?
ये बिल्कुल सही है
Yes, true and correct. Not objection, my lord. The receipt of this document is not appearing at this.
You want to exhibit?
Yes.
Exhibit D, B, C, na? Exhibit C with objection on the ground that the said document does not contain the receipt by the defendant.
Would my lord like me to put some question as far the original is concerned when what happened?
Yes.
What happened to the original of this document?
Original का है.
ये ओरिजिनल हमारा यहाँ हेडक्वार्टर में रहता था कलकत्ता हेडक्वार्टर में तो यहाँ हमारे सितंबर 2016 में आग लग गई थी इसलिए वो ओरिजिनल डॉक्यूमेंट हमारा डिस्ट्रॉय हो गया था
This document was lying in the
हमारे
headquarter office at Kolkata, and in the year 2016 there was a fire incident in the head office, and in the said incident the document was destroyed.
With regard to the fire, is there any police report filed on behalf of the plaintiff?
हमने दी है एक कॉपी इसकी इसके एफिडेविट के साथ लगाई है
Yes,
एक पुलिस कंप्लेंट की कॉपी।
yes, we have attached the police complaint, a copy of the police complaint with this affidavit.
This can be marked as exhibits. Oh, that's all.
Also, my lord, since this is a photocopy, my lord, whether the signature at all can be proved in this is my lord.
Signature not marked, no? That's why you objected
That is
to.
that is
Objected
something
to.
I wanted to point out. my lord.
Objected to. Then they have to prove that.
have to
The total document is objected to.
Whose signature is appearing at page 80? Authorized signature.
Already stated.
Even next page. Please look at page 81. What is this document?
कंपनी के द्वारा ईसीएल के सीएमडी को एक लेटर लिखा गया था जिसमें कहा गया था कि उन्होंने जो ग्रेड्स वगैरह चेंज किए कोल की क्वालिटी के लिए जो हमारे लिए सूटेबल है और हमने अपने जो अच्छी क्वालिटी के कोल की डिमांड की थी इसमें।
This letter was written by the plaintiff company to the CMD of the defendant company regarding the supplies अच्छी grade का ना?
हाँ मतलब जो एबीसी ग्रेड का वो
Regarding the supply of
कोल ग्रेड
ABC grade coal, and there was no problem in running the boilers and using the coal. और कुछ?
नहीं।
Whose signature is appearing on this document?
ये एसएल नथानी जी है हमारे।
This signature is of SL Nathani,
ये हमारे सेल्स ऑफिसर थे।
he was our sales officer.
What do you have to say about the contents of this document? Are the contents of this document true and correct?
ये बिल्कुल सही है।
Yes, true and correct.
Objected to.
What is it? So as far as the original is concerned, do we ask the same question after every document, or because he's already stated that?
No, you have to ask
For
every. But but first you have to see whether in the complaint all the document is mentioned or not. Okay, let it. Okay.
Where is the original of this document?
ये ओरिजिनल डॉक्यूमेंट भी हेडक्वार्टर में आग लगने के कारण डिस्ट्रॉय हो गया।
This original of this document had been destroyed due to fire in the office headquarters.
In the fire incident. This document has also destroyed in the fire incident of our head office.
Exhibit mark होएगा?
Exhibit क्या है? D with objection. What is our objection?
This is not the original.
Objection as the document is not the original one.
Please look at page 82 to 83. No, 82 वाला था 80. 83 is a typed copy. Page 82 of your affidavit of evidence. What is this document?
ये ईसीएल ने हमें स्टार पेपर मिल को लेटर लिखा था कि जो हमने कंप्लेंट करी थी उसके रिगार्डिंग कि जो
This is the letter issued by the ECL to our company in connection with the communication made by our company.
In 19th and 17th. Who has sent this document?
ये ईस्टर्न कोलफील्ड ने भेजा था डिप्टी चीफ सेल्स मैनेजर ने स्टार पेपर मिल को।
Letter was written by Deputy Sales Manager of Eastern Coalfield.
Yes, next.
No, this may be exhibited as this is their document, Malad.
Yes, exhibit E.
E. Please look at page 84 of your affidavit of evidence. What is this document?
ये हमारे द्वारा सीएमडी को एक लेटर लिखा गया था क्वालिटी के लिए, जो पहले हमें क्वालिटी कॉल देते थे वही चाहिए।
This letter was written by us to the CMD of Eastern Coalfields
जी
Limited
जी
regarding the quality,
कोल सप्लाइंग
regarding the good quality of coal that they used to supply to us.
Who has signed this document?
ये मिस्टर आर के शर्मा जी हैं,
This is signed
ये
by
our authorized signatory।
Mr. R.K. Sharma, our authorized signatory.
Are the contents of this document true and correct?
ये बिल्कुल सही है।
Yes, true and correct.
Objected.
Where is the original of this document?
हेड ऑफिस में आग लग जाने के कारण डिस्ट्रॉय हो।
This document is also destroyed in the fire incident of our head office at Kolkata. Marked as exhibit
E.
F with
F.
objection as the original is not produced.
Please look at page 85 of your document, of your affidavit of evidence. What is this document?
ये हमने ईस्टर्न कोलफील्ड जीएम ईस्टर्न कोलफील्ड को लिखा था क्वालिटी के रिगार्डिंग, जो पहले भी हमारे को क्वालिटी खराब आई उसके बारे में बताया था।
This letter was written by us to GM Eastern Coalfields regarding the inferior quality of coal supplied to us.
Whose signature is appearing on this document?
मिस्टर एसएल नथानी जी।
This is signed by Mr. SL
एसएल
Nathani.
Are the contents of this document true and correct?
सही, बिल्कुल सही है।
Yes, true and correct.
Where is the original of this document?
अभी हेड क्वार्टर में आग लगने के कारण डिस्ट्रॉय हुआ है।
Same. Repeat करिए।
এখন না পরে একসাথে দেব together যেগুলো
Exhibit
Exhibit G.
E with objection, original is not produced.
Well, the next document at page 86, the existence is admitted, but they have denied the contents of this document. What? Please look at page 86 of your affidavit of evidence. What is this document?
ये हमने ईस्टर्न कोलफील्ड के चेयरमैन कम मैनेजिंग डायरेक्टर को लिखा था कोल सप्लाई के लिए, अच्छी क्वालिटी का कोल सप्लाई करने के लिए।
This letter was written by us to the chairman cum managing director Eastern Coalfields regarding the supply of good quality of coal to us.
Who has prepared this document?
मिस्टर एसएल नथानी जी।
Mr. SL Nathani has prepared this document.
Are the contents of this document true and correct?
ये सही है।
Yes. True.
Where is the original of this document?
तो फायर इंसिडेंट
Similar operations.
The fire in the head of this Kolkata, this document was destroyed.
The existence is admitted by them, but
Exhibit H objection with regard to the contents of the document.
next would be an admitted document, page 87 to 88.
Page 87 to 88 is marked exhibit I as the same is admitted by the defendant.
Please come to page 87 to 88 of your affidavit of evidence. What is this document?
ये वो अमेंडमेंट है, हमारा जो एग्रीमेंट हुआ था ईसीएल के साथ में, उसमें बीच में हमने जो क्वालिटी की कंप्लेंट करी थी तो इन्होंने फिर हमको ग्रेड चेंज करके कोल अमेंडमेंट किया था कि अब आपको दूसरी क्वालिटी का कोल देंगे जो पहले हमने खराब दिया था उसकी जगह।
This is an amendment to the agreement that we had with ECL, and this agreement, and in this agreement, they had agreed to supply us good quality of coal.
Please come to page 89 of your affidavit of evidence. What is this document?
ये कंपनी द्वारा जो हम कोल प्रोग्राम लगाते थे सप्लाई के लिए, उसका इंफॉर्मेशन देते थे इनको कि टैक्स से रिलेटेड।
Through this letter, we had given them information about the availability of different grades and sizes of coal from time to time.
Who has prepared this document?
मिस्टर S.L. नथानी जी।
Are the contents of this document true and correct?
True and correct.
Yes, true and correct.
Where is the original of this document?
ये भी फायर इंसिडेंट में हो गया।
Due to the fire incident in the head office, Kolkata, this document was destroyed.
Original document is destroyed. Original is destroyed.
Original document.
Yellow blue.
Exhibit J with objection as with objection as original is not produced.
Please come to page 100 to 102 of your affidavit of evidence. What is this document?
कंपनी द्वारा हमारे को जो कोयले की रैक सप्लाई की गई थी, उसकी खराब क्वालिटी के लिए जो हमें नुकसान हुआ था, उसका हमने कंप्लेंट किया था इनको कंपनसेशन के लिए।
This is a letter of complaint regarding the inferior quality of coal supplied by the defendant company.
Who has prepared this document?
ये मिस्टर P.K. गर्ग जी।
Prepared by Mr. P.K. Garg.
Who is Mr. P.K. Garg?
P.K. Garg is Senior General Manager Commercial of the company.
Senior General Manager
Of the plaintiff company.
Commercial of the plaintiff.
Are the contents of this document true and correct?
Yes, true and correct.
Where is the original of this document?
ये इसकी ओरिजिनल कॉपी फायर इंसिडेंट में ही।
In the public sector. It was destroyed.
Not objection, because firstly, my lord, it's a photocopy. Secondly, my lord, the receiving stamp, my lord, does not appear from here. As your lordship will see certain other documents before this, there is a
With objection, as the original is not available and is also not having the receipt signature of the defendant.
This may be marked 100 to 102.
And my lord, the signature is not proven in this.
That already. Objection is objection.
Please come to page 103 to 104 of your affidavit of evidence. What is this document?
ये डॉक्यूमेंट्स हमने ECL में हमें प्रॉब्लम आ रही थी कि क्वालिटी कुछ और दे रहे थे और बिलिंग हमें किसी और ग्रेड से किया जा रहा, तो हमने चेयरमैन से जो कमेटी है लिंकेज ऑप्शन की, उनसे रिक्वेस्ट किया है कि ECL से हमें किसी दूसरी सब्सिडरी में भेज दें ताकि हमें अच्छी क्वालिटी का कोल मिल सके।
This is a letter written by us to the chairman, standing linkage committee, requesting for change of coal linkage from ECL to NCL/CCL.
For the purpose of getting
changing
good quality of coal.
Who has prepared this document?
ये मिस्टर P.K. गर्ग जी।
Are the contents of this document true and correct?
Yes, true and correct.
And what has happened to the original of this document?
ये भी हमारा हेडक्वार्टर में आग लगने के कारण।
Due to the fire incident, original of this document was destroyed.
Exhibit
Same objection, no received, my lord, no receiving seal. And
Exhibit
L.
L with objection, as the document is not original one and no signature of receipt by the defendant.
The next document is an admitted document. Exhibit M, page 105.
Page 105 is marked as exhibit M as admitted document.
Please come to page 105. What is this document?
ये परफॉर्मा इनवॉइस है ये, जो हमने कॉल उठाया था उसके लिए
This is the performer invoice.
कंपनसेशन के लिए
Invoice
ईसीएल ने रेज किया था ये
compensation. This is the performer invoice for compensation that ECL had raised for the supply of coal to us.
शॉर्ट सप्लाई होता है.
Please come to page 105A of your affidavit of evidence.
Exhibited.
That is admitted. What is this document?
ये कंपनी द्वारा जो सीनियर मैनेजर को लिखा गया था, जो इन्होंने हमारे ऊपर कंपनसेशन किया था, उसकी इंफॉर्मेशन के लिए.
This is the letter written by our company to the senior manager of Eastern Coalfields.
कंपनसेशन बिल
For compensation, compensation bills for cash sales.
Who has prepared this document?
ये पीके कर
Are the contents of this document true and correct?
Correct. Yes.
Where is the original of this document?
ये भी हेड ऑफिस में आग लगने के कारण डिस्ट्रॉय हो.
Exhibit N.
With objection.
With objection, as the original is not available.
Please come to page 106 of your affidavit of evidence. What is this document?
ECL ने एक वो इंफॉर्मेशन के लिए एक लेटर दिया गया था, जो कंपनसेशन बिल दिया था 11/12 का, उसका लेटर है. ECL ने कंपनी को दिया था.
This is the letter written by ECL to our company enclosing the compensation bill for the year 2011-12.
Do you have access to the original of this document?
हेडक्वार्टर में ही रखा जाता था, वो वहीं डिस्ट्रॉय हो गया आग लगने के कारण.
Due to fire.
This may be marked as Exhibit O.
Similar.
This is their document issued by Eastern Coalfields Limited.
Let there be an objection, my lord, because this is not the original anyway. My lord, they have to cross that threshold of proving this document.
With objection, as this is not, as original is not produced.
Please come to page 107 to 108 of your affidavit of evidence. What is this document?
ये कंपनी द्वारा असिस्टेंट ऑफिसर मैनेजर ईस्टर्न कोलफील्ड को लिखा गया था, जो इन्होंने कंपनसेशन बिल रेज किया था, उसके लिए हमने इनसे डॉक्यूमेंट्स और उसका वो मांगा था कि क्यों हमारे ऊपर कंपनसेशन सेस लगाया गया, लेकिन उसका कोई जवाब नहीं दिया था इस ECL द्वारा. हाँ.
This letter was written by our company to the Assistant Manager Finance, Eastern Coalfields Limited, regarding asking them about the details why the compensation was raised against us, or kuch compensation bill was raised against us.
Calculation of
And the calculations thereof.
Who has prepared this document?
ये मिस्टर SL नथानी जी.
Are the contents of this document
Yes, true and
true and
correct.
correct?
Yes.
Where is the original of this document?
ये हेडक्वार्टर में जो हमारा आग लग गई थी उसी में था ये, क्योंकि यहाँ रिकॉर्ड सभी एक जगह ही होता है.
Both the objections, my lord, no received. And
Exhibit P with the objection on the ground that the original is not produced and is not having the receipt from the side of the defendant.
Next is page 109. That is an admitted document.
Page 109 is marked as exhibit Q as admitted document.
Please come to page 109. What is this document?
एक मिनिस्ट्री ऑफ कोल द्वारा हमने उनको रिक्वेस्ट किया था कि हमारा सोर्स चेंज कर दिया जाए ECL टू अदर सब्सिडरी के लिए, ताकि हमें अच्छी क्वालिटी का कोल मिल सके.
This is the letter written by us to.
नहीं.
Issued by government.
The Ministry of Coal had written this letter to us
to
regarding change of source.
To us.
to CIL को लिखा था.
CIL regarding the change of source.
This is the letter issued by the ministry to Eastern Coal Company Limited.
Coal India Limited. To Coal India Limited.
Coal India Limited for changing of source from ECL to NCL and /CCL.
Please come to page 110 of your affidavit of evidence. What is this document?
ये भी मिनिस्ट्री ऑफ कोल ने कोल इंडिया लिमिटेड को लिखा था, जो हमारा कैपेसिटी के हिसाब से हमको कोल दिया जाए. हाँ, और उसका वो जो दे रहे हैं उसको चेंज किया जाए सोर्स हमारा, उसके लिए.
This is the letter written by Coal India Limited regarding change of source from ECL to CL/NCL in respect of the quantity of coal supplied to Star Paper Mills Limited.
This may be marked as exhibit.
with the usual objection.
Exhibit R.
This is the document issued by Government of India.
But no original.
Original with regard to.
R with objection and the same is not original one.
Lord, may I continue on the next day? And we'll finish the remaining documents on the next.
Come with the affidavit.
Yes, yes. बोलो दीजिए. Lord, any time may be fixed.
He's coming from outside.
He's coming from outside. Saharanpur. Right?
Then you will get the September.
Nothing in August. Continuity থাকে হবে না.
My diary is back.
প্রথম দিকে দাও সেপ্টেম্বরে.
The plaintiff is present. Plus examination chief started. During his examination, documents were marked as exhibit A to R, and many of the documents have been marked as exhibit and marked as objection. Full stop. Due to paucity of time, examination chief could not be completed. Accordingly, case is adjourned. Full stop. Let the matter appear on. Give the date. पहले कोई डेट नहीं. 12:30 देखो.
যদি টাইম না ফিক্স হয় তাহলে
3rd September 12:30.
that's ঠিক আছে.
3rd September 12:30.
So grateful.
Further examination of the plaintiff witness number 1.
কি টাইম ফিক্স? Great.
Copy it. Then they try to.
Yes. क्या जाया नहीं?
Execution
alternative नहीं थी. कौन कंपनी वाला?
Yeah, Millard, what had happened was, Millard,
Yes, Your Lordship,
Miller.
on behalf of the judgment debtor,
Ah.
today I'm handing over a draft of rupees 2 lakhs to the DP holder.
Millard, total claim is around 40 lakhs, Millard.
Yes, Your Lordship, kindly peruse the judgment and
Millard,
decree.
may I, before my learned friend says, Millard, sir.
नहीं से अच्छा कुछ मिल जाए वही अच्छा.
Yes, Millard, something better than Millard.
We are trying
Millard,
very
on
hard to
Yes.
Millard, on their submission, Millard, at the trial stage, Millard, they had submitted, they had consented, Millard. That's why, Millard, your lordship was pleased to reduce the interest rate from 18% to 10%. We agreed to it only on their verbal assurance that they would pay it in 10 installments. Nothing came, Millard, on our way. Nothing at all. Now, after so much of time, she's giving 2 lakhs. I mean,
That's why their name is Paramount.
Paramount. Well, though I'm accepting this, Millard, otherwise I'm only
Yes,
paying
when
the
the next
warrant of
payment will
arrest.
be made?
Your
Let
Lordship,
them appear, let them file their affidavit of
What
assets.
is the total decree?
Your Lordship, kindly pay
Decretal
the
amount,
judgment and decree. Decretal amount is
31 lakhs
19
13,337 as per
No.
decretal amount is 31 lakhs 13,000.
Judgment debtor is directing the defendant to pay rupees 19 lakh 5,720
With
by
interest.
installment at the rate of 1 lakh
But your lordship's
per
Millard,
installment, as well as at the rate of 10% per annum. Thereafter, it was notified that first installment will be commenced on and from December, and the last payment, entire payment, if the judgment debtor failed, in that case, he will pay interest at the rate of 18%, and the last of such payment has to be made within 27 September 2025. So this execution application itself is a premature application because I have the liberty to pay with 18% interest up to 27.
So you are ready to pay the 18%
Yes,
interest.
we are trying very hard, Your Lordship. We are
premature,
trying
Millard. She did not pay the first installment.
Yes,
She's saying it is a premature application. Millard.
because we
Okay,
could
what
not start
amount
up
are you
with the
paid?
business.
Millard, it is Joshua.
When the next payment will be made?
Your Lordship, within our time frame,
Then-
we are trying to make the payment.
Within
The
an
time
hour?
frame is already gone, Millard.
No,
They
no,
were
it
supposed
is
to pay
within
the first installment long back.
27 September, you have to clear all.
All, yes, Your Lordship.
So before that, how much, when you will pay?
Your Lordship, I need to seek instruction. We are,
These are 2 lakh only.
yes, Your Lordship.
2 lakhs.
Millard,
19
it's
lakh the
almost
main-
35 lakhs now, Millard, almost. The date of filing, it was 31 lakhs 13,000.
The judgment debtor has handed over a check of Indian Overseas Bank being number
Your Lordship,
49. Huh?
bank
Acha, being has handed over demand draft number 1497 4601 1497 4601 dated 18th June 2025 of rupees 2 lakhs to the decree holder. Police counsel for the judgment debtor submitted. The judgment debtor will clear all the dues in terms of the decree passed by this court by September 2025. Police in view of the above, let the matter appear on 20 August 2025. Come on 20th August some payment.
20th August.
एक काम करो इसका जेरॉक्स कॉपी करके उसमें रखो.
Please understood that Millard, possibly she'll get me some more money.
We are trying hard. This is a decree. We need to comply with the order.
Grateful.
Well, I appear for the decree holder in this matter, my lord.
Yes.
My lord, I am appealing for the judgment letter number 6 and
No,
7.
but that on the last occasion, there was a direction
remain
upon the
here.
judge.
You have received the total amount.
No, not even a farthing, my lord.
Huh?
US dollars 4,28,000 odd, which upon conversion, my lord, comes up to around 9 crore 81 lakhs.
Huh.
Nothing has been paid. On the last occasion, my lord, on 20th of January, your lordship was pleased to direct the decree.
Appeal.
My lord,
That has been dismissed.
Has been dismissed, my lord. My lord, I am appealing for the judgment letter number 6 and 7. I am humbly seeking for some more time to file my affidavit of assets, my lord.
I thought you some more time to make the payment.
My lord,
I am for defendant number 1, judgment number 123. We are foreign nationals. As against us, this decree cannot be executed in India. they have to approach the proper course of law. That is my submission. Whereas the decree is that decree says every defendant is liable to pay that sum. So decree has not segregated any between the defendants.
It has to be jointly and severally paid, my lord. That is what the decree say.
Defendants have preferred nothing.
The affidavit of assets may always come in, my lord. There is no bar insofar as the filing of the affidavit.
How many judgment debtors?
There are
Eight, my lord.
eight, my lord, in total.
That for 1,
You are 1, 2, and 3.
Against them, the decree can be executed in.
No, but affidavit of
File objection.
The affidavit of assets can always be filed, my lord.
File affidavit of assets.
I file affidavit, I have to submit to the jurisdiction. I'm saying this court cannot execute a
File application, it will be decided.
for removal of
File application. Yes. And what we are appearing for?
My lord, judgment data number 6 and 7, my lord.
What about the 4, 5? 4,
My
5,
lord,
8?
they have not been appearing, my lord, even during the suit. Your lordship recalls it was your lordship's decree only that they have chosen not to appear despite having filed their written statement.
So you are the truck owner.
My lord, I am the transporter. And
Indian custom agent.
And the custom agent, my lord. My lord, I am.
Your lordship seems to have remembered the matter pretty well.
My lord, kindly grants me 3 weeks time to file my affidavit.
Their appeal has already been dismissed, my lord.
Unfortunately, my appeal has been dismissed, my lord.
And the defendant number 1, 2, and 3, my lord, choose to appear very erratically.
Chapter number 1, 2, and 1, 2?
1, 2, and 3.
1, 2, and 3. Praise for time for taking appropriate steps. Full stop. Counsel for the judgment debtor number
6 and 7.
6 and 7. Praise for time to file affidavit of assets. Full stop. And appears on behalf of the judgment debtor number 4, 5,
and 8.
And 8. Full stop. In view of the submission made by the counsel for the judgment debtors, let affidavit of asset be filed by the judgment debtor number 4 and 5, 6 and 7 by 2 weeks.
3 weeks, my lord.
By 2 weeks. This is the matter on 18th August 2025. Please.
Grateful, my lord. Deeply pleased.
Your lordship kindly record my submission that since we are foreign citizens,
Counsel for the
against us cannot be
judgment debtor
executed in
number 6 and 7. Na?
1, 2, and 3.
1, 2, and 3. Submit that the judgment debtor number 1, 2, and 3 are the foreign national and the decree cannot be executed before this court, and as such he prays for time to take appropriate steps.
Now, my lord, there's also one more thing. There's no embargo insofar as, my lord, filing of the affidavit of assets is concerned. That can always be filed.
Okay, let them come. Let them come. The
Very well. Very well. Very well. Very well. Grateful, my lord.
Yes.
The plaintiffs had finished their arguments, the defendants were.
Yes. Insurance. Insurance.
Your Lordship, as the case is undefended, this is my only chance to bring something in front of the Honorable Court to throw some light on the fact that this claim should not be allowed to the petitioner, the plaintiff, Your Lordship. On the last date, Your Lordship, I started my arguments, my submissions with 8 questions that I had raised. And I'm going to base my arguments on those 8 questions, Your Lordship. But before that, there are 3 essential points that I would like to bring to the fore, Your Lordship. First of all, the present suit suffers from misjoinder. And why do I say this, Your Lordship? The dispute is actually between the plaintiff and the surveyor, because the surveyor has recommended that no payment should be made. And if the surveyor has recommended that no payment should be made as per the claim, then the insurance company cannot go ahead and make a payment, Your Lordship. So in my humble opinion, Your Lordship, the surveyor was supposed to be made a party. He should have been examined and cross-examined, which has not happened in this case, Your Lordship.
Yes.
My second point, Your Lordship, is it's a very technical point, Your Lordship. There are so many exhibits, out of which 3030 exhibits are derived from computers or based on information technology. But unfortunately, the plaintiff has failed to file any 65B certificate for those exhibits. I have
Whether it
raised-
was exhibited with objection or without objection.
I had raised the objection within the court premises. I am not able to recall whether it was recorded or not, Your Lordship. But there are no. But at the same time, Your Lordship, I will also mention that there was one declaration under 65B with the plaint. But that does not dispense with the need of 65B certificate when the evidence is filed. The third point that I want to mention, Your Lordship, is about it's something related to the maintainability of this suit, which I say it's quasi-maintainability. There is one, this suit is based, the claim amount is based on the price of the potatoes, Your Lordship. The plaintiff has already filed a writ petition, which is still pending, being WPA number 12441 of 2022, where the plaintiff is challenging the rate of the same potatoes, and they are saying that the rate of the potato should be fixed. Lordship, I find it little confusing that one hand, I'm saying that the potatoes rate to be fixed. I'm challenging the rate what the government has fixed. On the other hand, on the same potato, for the same rates, I'm saying this is what I want. Unless the writ petition is disposed, my humble submission and my understanding, Your Lordship, is that this suit cannot be decided because the claim amount cannot be fixed.
Yes.
Your Lordship, I start with my first question that I had raised, the number of 8 questions that I have raised on the last occasion. Is the suit speculative? Your Lordship, why I'm asking this question to myself through the Honorable Court, because the way this suit has been planned, the suit has been made, given a shape and presented to the court. Lordship, when we go to the page number 113 of the plaint, sorry, Your Lordship, with the judge's brief, the amount claimed initially was around 8 crores. It is on page number 113, Your Lordship. The judge's brief. Initially, the claim amount was around 8 crores. Gradually, over the period, it has rose to 12.63 crores, Your Lordship, which is there on para 58 of the plaint, Your Lordship, on page number 25. There is a table where the total amount, the claim amount, has been written as 12 crores 63 lakhs.
Page?
Page number 25 of the plaint, para 58, Your Lordship.
Para 58.
Para 58, page number 25 of the plaint, Your Lordship. There is a table wherein the amount has been given as 12 crores 63 lakhs. So from 8 crores initially, it comes to 12 crores 63 lakhs. I will also add here that during the course of argument, my learned senior did mention that there has to be a tone down.
Yes.
In the same table, Your Lordship, when we look at item number 4, 6, and 7, 2 crores 27 lakhs and 98 lakhs are presented without any supporting document. Later on, through an affidavit and an application, 98 lakh was withdrawn by the plaintiff, which is on the record.
That is not pressed.
The speculative part, it's coming to my mind, Your Lordship, because when we look at the prayer on page number 27 of the plaint, there is one prayer where the plaintiff is praying to the Honorable Court to alternatively to inquire on the loss and damage suffered to the plaintiff in regards to its claims in paragraph 58. At one hand, I am saying this is what the loss I have suffered, I must be paid. On the other hand, I am requesting the court and praying to the Honorable Court, please finalize what should be my amount. This gives me a sense of understanding that I do not know what I want. I'm just filing a case to get something. So that's the reason I'm saying it appears to be speculative, Your Lordship. Your Lordship, there are 3 questions which I'm clubbing them together. and I'm going to put forward my arguments on those three questions. Those three questions are, was there an accident? Number two question, what was the cause of damage to the potatoes? And number three, was contamination of stock as a peril or risk covered under the DOS policy?
Was there an accident? Number
Was
two?
there an accident? Number two, what was the cause of damage to the potatoes? And number three, was contamination of stock as a peril or risk covered under the DOS policy?
Yes.
Your Lordship, I kindly request you to come to page number 112 of the judge's brief. There are on 112 page, there are boxes. The fourth box on the right side, Your Lordship. The plaintiff has on record said that it found that the nut bolt of the flange was unthreaded. The last sentence, Your Lordship. Not the last, sorry, Your Lordship. The flange was unthreaded and the main valve of liquid line of chamber number 3 on the ground floor inside the machine room was also found.
Where from you already?
Fourth table, Your Lordship.
Yes.
There is a box.
Yes.
1, 2, 3. The fifth line, Your Lordship.
Yes. They found that.
The flange was unthreaded.
Yes.
And it is their statement, the plaintiff's statement, that the flange was unthreaded, Your Lordship. I just want to put some stress on the word unthreaded, Your Lordship. Lordship, unthreading of a nut bolt cannot happen on accident. Threads, on the bolt, we have these threads, Your Lordship, to tighten it or to loosen it up. Unthreading of a nut or bolt occurs due to change in temperature or due to continuous vibration over the period.
Yes. Unthreaded cannot be?
Cannot be an accident. Over the period, it happens, unthreading happens because of change in the temperature or due to the continuous vibration on the bolt, nut bolt. Your Lordship, this means that unthreading was not sudden and was a gradual process, and therefore it was a result of wear and tear. Your Lordship, in the same box, the last line, it mentions that the fault was immediately repaired within 1.5 hours. When an accident happens, Your Lordship, the damage would be such that there would be cutting, grinding, welding would be required if there is an accident. Since accident causes something to burst, crack, melt, so there has to be some more activities to be done to bring it back to normalcy. They just replace the nut and bolt, which was a result of wear and tear, Your Lordship. Your Lordship, if there was an accident, I ask one question to myself through the Honorable Court. Was there an FIR lodged by the plaintiff? There are no records, no statement, no whisper about the FIR on accident.
Fire report? The incident report? It was informed to the authority?
To the authority, but no FIR. If it an accident, no FIR was lodged, Your Lordship.
No, it is not the fire incident was occurred. It is only with regard to leakage.
Leakage, Your Lordship.
Occurred in the godown or what with the cold storage. And subsequently it was some damage. So it is what the criminal act will come in the FIR. It is not that the mischief has been done. It is not the case made by the plaintiff. It is mischief has been done.
Your Lordship.
It is there was an incident of gas leakage or whatever it may be, due to which he has sustained loss, and it was informed. It was covered under the insurance policy. Initially, the inspection was done. A report was in favor. Subsequently, it was found that the report was changed, and the insurance company has not inclined to give the. This is the simple. So what would be the effect of the FIR or non-FIR?
Lordship, very general notion that we have, common people have, that when there is an injury, a personal injury or a bodily injury, regardless of whatever happens to be the reason, FIR or a GD is lodged. But here there was no personal injury or bodily injury, but there was property injury. Your Lordship.
Property, correct. But it is not that there are suspected that somebody has done the mistake.
No, it was not, Your Lordship. I bow down to
If that, because if you go to the police station, the first question the police will go against whom you are having suspicion.
Who is the accused person? Your Lordship. But that would have added to the
Okay,
whole
I
case.
will take
Lordship. Your Lordship, it is the admitted fact that the cause of damage to the potatoes was that potatoes came in contact with ammonia. We have agreed to that. We don't deny that fact, Your Lordship. Neither the plaintiff nor the defendant denies that fact, the admitted fact, Your Lordship. The damage to the potatoes due to contamination by ammonia took place due to leakage of ammonia, which was not an accident. That is the question mark that we have. A very important and pertinent question that we raise here: was contamination of stock covered as a peril or risk under the DOS policy? Your Lordship, kindly come to the page number 77 of the judge's brief. This has been shown many a times, Your Lordship. I am not repeating the sentence, but the clause, as per this clause, the answer is yes, that contamination was covered as a peril. We don't deny that fact. But it is to be noted that contamination, putrefaction, or deterioration that happens solely due to rise in temperature. That is our contention, that if there is contamination because of rise in temperature, we cover that risk and we are ready to pay the claim amount for that. During the argument and during the examination, cross-examination, Lordship, my learned friends have argued that contamination can only happen when a foreign particle enters the chamber. Otherwise, there cannot be contamination. I think, my Lordship, my very humble submission, I'm very junior to my senior friend, but very humble submission, that there is a fallacy. If we keep the fridge switched on for longer time, my food will not get contaminated even for 5 days, 1 week. But if I switch off for 1 day, my food will get deteriorated. My food will
okay,
get
if you not switch off, but if there is a technical defects inside the fridge or your refrigerator, what would happen?
Then also it will. So my point here is, Your Lordship, that it is not necessary that contamination has to be done by a foreign particle, because microbes, bacteria, all the microorganisms, they're everywhere, even inside the cold storage and fridge.
Foreign particles, what? You are keeping something in your refrigerator or you take the cold storage to make the fruits or whatever it may be intact so that it cannot be lost.
Gotcha.
Correct. So, and if your refrigerator or cold storage is not functioning, automatically the foreign particle, what the foreign particles? Automatically the foreign particles enter into the fruits and the whatever it is, it will get damaged. So that is the case they have made out. So if you say no, this the cold storage was properly functioning, then the case would be different. It is not your case. There was no damage. There was
damage.
Some defect. There was some defect. There was some defect.
Lordship.
So there are two questions only. The defect caused due to the negligence of the plaintiff, or there was a defect in the machine. These are the two things. I don't think there is any specific has been given by that it is a defect negligence on the plaintiff. Only you are thinking that it is high temperature. So
nitrogen leakage.
Nitrogen leakage.
Ammonia. Sorry, ammonia.
Ammonia leakage. Sorry, ammonia leakage. So ammonia leakage, how it has happened? If it is ammonia leakage, so how it is happened?
There was an event. I'm not telling it as an accident, but there was an event. But why I raise this point to Your Lordship? Because during the course of argument, the plaintiff has put forward that contamination cannot happen from within. but that's not a fact. Scientifically, contamination can happen even within the fact. I will just give one more example, Your Lordship, with your kind permission. Lately, the medical science has discovered that ICU contamination. ICU is a very segregated place, but within the ICU contamination, lot of morbidity, lot of deaths are happening because of the ICU contamination, which is not supposed to be. It's a highly
because why?
sanitary-
Why?
Because microbes are there, Your Lordship.
Because why? That's why the ICU has this keeping us isolated, but instead, you persons, we, including us, we are entering into the ICU to see the patient.
Yes, yes, Your Lordship.
And all the things has happened.
Agree with Your Lordship, but this scientific research say that the microbes which are residing within the ICU, they have developed some kind of resistance to. So my point here, Your Lordship, is that the argument put forward that contamination cannot happen from within, it has to happen through a foreign particle, does not hold ground, Your Lordship. That's my. I'm not saying the word whether contamination happened. We are saying it did happen by ammonia, but this argument that it cannot happen from within, if the temperature rises, it will the potatoes will automatically get rotten. That's my point, Your Lordship. Your Lordship, the clause very clearly mentions that if the contamination happens due to rise in temperature, which did not happen, it is on record. It has.
Have you brought an evidence? If the temperature is raised, so how many hours is required to be contaminated?
That is there, Your Lordship. I will have to look into that. There is some time gap. Within this time, it has to go up.
Correct.
Because the temperature will remain like that way.
What would be the time? Because if leave aside the cold storage, if the small shopkeepers,
Lordship,
they are keeping the potato without the cold storage, it is not necessary that immediately it goes or it will be wasted or something else.
But the question, Your Lordship, here is that was contamination by ammonia or by that kind of incidents covered in the insurance policy or not? The answer is no, Your Lordship. That is our
That is you have to prove. That you have to prove. It is not covered, and this is that. Yes, continue, no problem.
Lordship, I'm taking little deviation from the other questions, and the two questions that I'm raising here, we talks a little bit about the, I'm sorry, but a bit of a malafide intention on behalf of the plaintiff.
Yes, no
So
problem.
there are two questions that I'm raising here, and then I'm going to put forward my argument on those questions. Is this suit a pre-planned misadventure by the plaintiff? And number two, is the plaintiff trying to cover its operational expenses and or loan payment through the insurance claim? Your Lordship, the plaintiff started his business in 1970s, very long, 4 decades of history they have. And this was the first incident which has occurred on 19th May 2022. And this has been corroborated by the plaintiff in question number 304 by PW2, Your Lordship. Lordship, there are some chain of events I would like to bring forward to the court, to the Honorable Court. The plaintiff gets a loan sanctioned from Punjab National Bank for rupees 7 crore 28 lakhs on 11th of March 2022.
11 March?
11th of March 2022, Your Lordship, just 2 months, 8 days before the accident.
crore?
7 crore 28 lakhs on
Yeah.
11th of March 2022. 2 months, 8 days just before the event, the incident, Your Lordship. And it is there on page number 183 of Judge's Brief, Volume 2, Your Lordship. The sanction letter is exhibited.
Page?
Page number 183, Judge's Brief, Volume 2. The sanction letter by the bank.
Yes.
A mere coincidence, Your Lordship, that the compensation or claimed amount under DOS policy is 7 crores 92 lakhs, very close to the loan amount.
Yes.
Another coincidence, Your Lordship, the DOS policy is effective from 17th May 2022, and MBD policy, which covers the accident, is effective from midnight of 18th May 2022, and the incident, I'm sorry, Your Lordship, the incident takes place within 24 hours on 19th May 2022. This is mentioned on page number 64, the insurance policies.
Have you lodged an FIR against him?
No, Your Lordship. The defendant could not even think of that, Your Lordship.
Yes.
Your Lordship, between 31st March 2019 to 30th March 2022, for last 3 years, both MBD and DOS policies were renewed without any gaps, except once when there was COVID, there was a gap of 9 days. They used to renew the DOS policy and the MBD policy before it is expiring or on the date of expiring, except once in 2022 when there was a gap of 9 days because of COVID peak time, the March time, Your Lordship. Surprisingly, Your Lordship, for this year when the incident took place, the plaintiff was without any insurance coverage for 47 days for MBD and 46 days for DOS. First time in the history of 4 decades. They were without insurance for 46 and 47 days.
From which date to which date? What would be effect of this? Because the incident was covered under the insurance policy.
But during that time there was no that time? Yes, Your Lordship.
So this is not the insurance on the he's not claiming any part on when the.
I am just trying to bring some facts which
Okay,
my
no
story, Your Lord. The year, just if I have made a table for easy visualization, Your Lordship. Just if just during the incidents here, there was no coverage for 46 and 47 days. Very unusual that we have found out, Your Lordship. So, Your Lordship, loan of rupees 7.28 crores sanctioned on 11th March of 2022. Policies expires on 30th of March 2022. Coverage taken after 47 days on 18th May 2022, and incident occurs within 24 hours on 19th May 2022, Your Lordship. Your Lordship, when PW1 was cross-examined, when examination was done for PW1, question number 207 to 209, these are some of the facts which have been brought to the fore, Your Lordship. The average expenses for the financial year 1920, 2021, and 21-22 is around 2 crores 36 lakhs. Question number 207 to 209 of the examination in chief of PW. 2 crores 36 lakhs, Your Lords. Average expenses for 3 years.
Yes.
And in question number 210, when the PW1 was asked, what would be your net expenses for financial year ending March 23, the incidence year, the answer was approximately 2.5 crores.
Yes.
Annual expenses before incidents average is 2.36 crores. Annual expense during the incidence year is around 2.5 crores. What was the need of 7.28 crores of loan? Where did the money go? No answer to that question, Your Lordship.
Yes.
The plaintiff has filed the audited financials for the years before the incident, but has not filed the audited financials for the year 20 to 23 when the incidents took place. It is not exhibited, Your Lordship.
Yes.
Lordship, this present suit was filed on 5th of July 2023 and incidents occurred in 19th May 2022. There was 1 year, full 1 year. Still, the balance sheet and profit and loss account were not exhibited. This is a small question, humble question. Is it something which is not, they are not trying to reflect to the court, Your Lordship? Lordship, in question number 309 of affidavit in chief, PW2 was asked, what was the outstanding loan balance with Punjab National Bank on 17th May 2022, just 1 day, 2 days before the incidents? The witness did not disclose.
Question number?
309, Your Lordship. That was a cross-examination question, Your Lordship. The answer was, I will have to refer to bank ledger for accounts.
Yes.
Furthermore, Your Lordship, the plaintiff has filed bank statement of the current account number 04570500156440, which is there in the volume 2 judge's brief, volume 2, page number 226 to 231, which does not disclose the exact position of the date. They have not filed the bank statement of the loan account. Neither the court nor us are aware that how the loan amount of 7.28 crores was utilized.
But this is not the case with regard to the bank has made any allegation that obtain the loan for one purpose and utilize the same for the other purpose. What benefit you will get from that? If suppose he had obtained 7 crore and after 3 days the incident was occurred, whatever it may be. So now his NPA, whatever it is, due to the loss and all this. It is not the bank case that he has obtained the 7 crore and utilized for some other purpose. That is not the case, no doubt.
This will be generally a bank's case, Your Lordship. But my argument point is that is the plaintiff trying to cover the bank expenses, the repayment of the loan through the claim amount? I'm trying to correlate both of them.
Correct.
Your Lordship, I had made a table, but I have already made the submission that the average expenses, but there are certain points that I would like to bring forward to Your Lordship. Page number 299 of the Judge's Brief, Volume 3. This helps in making a lot of sense what I'm trying to bring forward, Your Lordship. Page number 299. These numbers and figures I'm bringing forward, Your Lordship, because I'm still, Your Lordship, I just one small thing, if I can say. Before coming to practice, I was a banker. I used to work for State Bank of India. So because of that, it's coming to my mind that I'm not able to correlate the fund, the claim. That's the reason I'm bringing this forward. And it gives me a sense something might not be okay, Your Lordship. Your Lordship, for financial year ending on 31st March 2020, current liabilities are 3 crores 18 lakhs. Revenue 2 crores 25 lakhs. Expenses 2 crore 33 lakhs. When you talk about current liabilities, mostly they are working capital liabilities, the cash credit that we take from the loan. So it was 3.18 crores, Your Lordship, for the financial year 2021. current liabilities come down to 2.22 crores. It has come down. Revenue is more or less to the same extent, 2.34 crores, and expenses 2.37 crores. Financial year 2022, Your Lordship, the current liabilities have gone to 4.40 crores. It has gone up. Revenues are same, almost to the same level. Expenses are almost to the same level. Lordship, my submission is that 45 days before the incidents, the loan outstanding, they have not given me the statement. I am trying to figure this out from the audited financials. That 45 days before the incidents, the loan outstanding is 4.4 crores, current liabilities.
Page.
Page number 299, Your Lordship.
Yeah.
4.4 crores, which is just 2 crores 18 lakhs more than the last year outstanding on the same date, 31st March 2021. Although the revenue and expenses remains the same, why did the plaintiff go for a loan enhancement of 5 crores? And where did that money go? No answer, no whisper to that question. Should I continue, Rash?
Yes, 10 minutes is there. Up to you. If you want time, no problem.
Maybe 15 to 20 more minutes. It might take around 20 more minutes.
More minutes.
So
next date.
It will be better if I do it next day. Because during the flow now I'm going into some different deviations as well, Your Lordship.
All these questions cannot now be raised because there is no defense statement here. If the case is not made out, he can only cross-examine, argue on the basis of the documents on record.
What can be done?
Apprehension of arson, apprehension of some wrongdoing.
Counsel for the defendant has argued at length, but due to paucity of hearing could not be completed. Upon case let the matter appear on tomorrow. Already fixed. Let the matter appear tomorrow at 3:45.
Wait for Your Lordship.
Yes.
Malad Palantar decree holder. Malad, I have sent the copy of the tabular statement with the affidavit to the judgment data twice, my lord. Both the times it was returned with the remark left out of station. My lord, the judgment was passed, my lord, at page 73, my lord. Relevant portion, my lord, page 75.
Yes.
My lord, it was directed to principal amount is 25 lakhs plus 18%
Notice not
interest.
served.
Notice was not served, but I have a prayer of injunction, my lord. If lordship allows me to, that asset I have gathered from the searching at page 10 of my affidavit, my lord. Paragraph number 21. These are the assets of the judgment debtors.
Page number?
10, my lord.
10 of?
10 of the affidavit in support of the tabular statement. Affidavit, my lord.
10?
10. Page 10, paragraph 21, my lord.
Yes.
These are the assets we have gathered from the searching that lying in the name of the judgment debtors. My lord, the claim is almost 25 lakhs. And we have sent, my lord, it was not served because it is out of station and it was envelope was written with remark out of station, my lord.
The decree holder has filed the present execution petition. Execution case for execution of the decree passed by this court dated 12th August 2014.
14, my lord.
14 and you come in 25.
Yes, my lord. There is a
2014. 2014. Full counsel for the defendant submitted. Twice the defendant had and counsel for the decree holder submitted. Twice the notice have been sent to the judgment debtor, but the same was returned with the endorsement. Addressee left.
Out of station.
Addressee left / out of station. Full stop. Counsel for the plaintiff submitted. Counsel for the decree holder submitted that the decree holder mentioned the properties of the judgment debtor in paragraph 21 of the instant application and prayed for interim order. He submitted that if interim order is not passed, he submitted that judgment debtor is avoiding the service of the notice and there is every chance that he will alienate the property to frustrate the decree obtained by the plaintiff, obtained by the decree holder. At the learned counsel for the decree holder perused the affidavit of service, which find that the notice has not yet been served upon the judgment debtor. Considering the above, this court find that judgment debtor is avoiding the notice. Accordingly, the fit case where an injunction can be granted, accordingly, prayer A and prayer C of the tabular statement is allowed. Full stop. The plaintiff, the decree holder, is directed to file requisite number of is directed to take appropriate steps for submission of requisite for filing requisites in the department, and the department is directed to serve the notice upon the judgment debtor to the learned district judge of the concerned district. Full stop. The decree holder is directed to take appropriate within a week. Full stop. Let the matter appear on 26th of August 2020. Yes. Okay.
I was required to serve, my lord. I have served. A, B, C, and Lordship has already granted in terms of tabular statement.
I appear on behalf of the respondents, Lordship.
They were required to file affidavit of assets.
You filed the affidavit?
Lordship, my client's nearest relative has been hospitalized. We have been not able to contact with my client. I'm praying for 2 weeks time to file affidavit in assets.
I don't even expect of getting anything, my lord, but affidavit of assets is required.
Counsel for the judgment debtor prays for extension of time to file affidavit of assets. Let affidavit of assets be filed within 2 weeks. Please the matter on 19th August 2020.
Well, only one more prayer, if I may ask for, my lord. Kindly takes, my lord, the tabular statement, my lord. Prayer D, my lord, if Lordship today passes, because I know they would be, my lord, absconding.
Prayer D.
Prayer D. This was not passed. Lordship had passed A, B, and C on the first day.
Let they come with on that.
If assets in the meantime, if there's, it's more than, my lord, it's crores, my lord.
Though this court has given an opportunity to the judgment debtor to file affidavit of assets, but has not filed the affidavit of assets till date. Police to counsel for the decree holder submitted. There is every chance that the defendant will alienate the property as mentioned in paragraph 12 of the tabular statement. 12 of the
affidavit in support of the
tabular
tabular statement.
consider the submission made by the counsel for the decree holder. The judgment debtor is restrained from dealing with the property as mentioned in paragraph 12 of the affidavit of us.
My prayer says and or any other assets of the judgment debtor.
Well, of the affidavit in support of developer statement or any of the property of the judgment debtor till the filing of
Very
the
good.
affidavit of assets.
It's only a satisfaction of a decree holder, nothing more. my lord.
Yes.
Next matter, my lord. It's 4:29. Perhaps I'll take not more than 1 or 2 minutes. My lord, I've already served, my lord. The decree passed by your lordship, my lord, on
Item number?
31, my lord, the next item.
Yes.
The decree passed by your lordship, my lord, on 5th of October 2023, my lord.
So only you filed the execution?
Execution, my lord, we were unable to initially we were not able to trace the address.
37
Thereafter,
lakh.
my lord, now the principal amount pursuant to the decree has decree retail amount has gone up to 1,86,92,646 pursuant to your lordship's decree, my lord. My lord, here what happened, my lord, perhaps, my lord, we will able to get some money out of this right away, my lord. In the when the interlocutory application was being moved, my lord, by an order dated May 2023, my lord, 8th May 2014, my lord, I'm sorry. My lord, rent was directed to be paid by the decree to the decree holder, my lord. Thereafter, the defendant, my lord, assailed the order, my lord. Then, my lord, the Honorable Division Bench passed an order, my lord, on 16th of May 2014, directing that the rent amount should be deposited with the registrar origin side. My lord, thereafter, I wrote to the registrar, my lord, the money is there, my lord. My lord, I'll cut short my argument, my lord. Submissions, my lord. If I'll take your lordship directly to, my lord, page 74, my lord. Annexure K.
Yes.
My lord, the registrar has confirmed, my lord, as on 2nd July 2025, my lord, an amount of 20 lakhs, my lord. If your lordship turns to, my lord, page 75. Initially, 9 lakhs odd was deposited, my lord. That was 13 years back. Now it has, my lord, accumulated to, my lord, 20 lakhs 39,173. Well, I am only, my lord, praying, my lord, the direction be given to the registrar, my lord, that this money be, my lord, given to me, my lord. And then, my lord.
What is the notice? Notice served? No.
Notice served, my lord. This is the affidavit of service. Now, I've got 3 addresses, my lord. In all the 3 addresses I've served, in one they have received it, my lord. That is the, my lord, the registered address of the company, my lord, of the judgment debtor.
Where is the service?
Well, affidavit, it's there, my lord.
No, track report is not here. Yes, it's address delivered. Item delivered.
Item delivered, address, my lord.
12 July.
I have served, my lord. That is the, you know, today, my lord, I am only praying, my lord, let this, my lord, let a direction be given.
726. Maturity will be 1726.
No, let them close prematurely, my lord. At least some money will come to me, you know, almost 2 crores.
When they
Today,
deposited?
My lord, it was deposited, my lord, long back, my lord. It was deposited in 20. My lord, I'll give your lordship the date, my lord.
No, here the principal amount, 30th June, it was again extended.
Yes, my lord.
So you will get the 19 lakhs.
Whatever, as on date, whatever minus the, my lord, charges, as also, my lord.
The plaintiff has filed the present execution case for execution of the judgment and decree passed by this court dated 5th October 2023. By a judgment and decree dated 5th October 2023, this court has passed a decree directing the defendant to pay
37 lakhs 48,824 together with 15% interest. That was the decree, my lord.
No, monthly rent maintenance. Plaintiff is entitled to get 20 lakh, itna, electricity, itna. Plaintiff is entitled to get 37 lakh. And क्या बोला? Pay an amount of rupees
My lord, may I say the amount, my lord?
Yes.
The decretal amount was 37,48,824 plus interest at the rate of 15% from 4th January 2014 to 30th June 2025.
37,48,824 along with interest at the rate of 15% per annum from the date of filing of the suit till the realization of the said amount.
I've calculated it till 30th of June, my lord, when I filed this.
At the time of filing of this execution case, the plaintiff has calculated the interest at the rate of 15% per annum from 4th January 2014 till 30th June 2025, total amounting to rupees
1 crore 49 lakhs
49, 43, 822, and the total decretal amount would be rupees 1, 86, 92, 646. Full stop. Counsel for the decree holder submitted. The notice have been served upon the decree holder judgment debtor, which was duly received on 12th of July 2025. But in spite of receipt of the notice, none appears on behalf of the judgment debtor. You are appearing? No. Police. So counsel for the plaintiff, counsel for the decree holder, draw the attention of this court to the report, to the communication made by the registrar, communication made by the assistant general manager to the assistant registrar cash department of this court, dated 2nd July 2025, wherein it reveals that the defendant and the judgment debtor has deposited an amount of rupees 9,25,210, which was invested in the interest-bearing fixed deposit receipt, and as on 30th June 2025, the total amount is lying in the said account was rupees 1 crore 19 lakh 16,552, and as on maturity date, that is on 1st July 2026, 20,39, 173. Counsel for the decree holder submit that prays for a direction upon the registrar for release of the said amount, whatever as on said amount in favor of the decree holder. Consider the submission made by the counsel for the judgment decree holder. This court find that in spite of the decree passed by this court and in spite of the notice issued by this court, the judgment debtor failed to pay the decretal amount along with the interest to the decree holder, nor has appeared before this court. Accordingly, registrar original site is directed to release the amount lying, the
maturity amount as on date, my lord, whatever the amount.
Release the amount as on date lying in the STDR number 33929835421421 in favor of the plaintiff, in favor of the decree holder, after being duly identified and after being duly identified by the learned advocate on record within a period of 2 weeks from the date of receipt of this order, and to submit the report before this court on the next date.
I'm also praying for, my lord, that order, my lord, of directing them to file the affidavit of assets, my lord, on the returnable date.
Let the matter appear on 27th of August 2025. In the meantime, the judgment debtor is also given liberty to file the affidavit of assets after serving the copy to the learned counsel for the decree holder. Release the matter on 27th of August.
One more indulgence, my lord. If your lordship takes, my lord, the cost title, my lord, the defendant, the decree holder number 1 and 2, my lord, were appearing as trustees of Prabha Khaitan Foundation Trust. So, my lord, the money should be paid to Prabha Khaitan Foundation.
Decree holder, who is the decree holder?
My lord,
all are decree holders.
All are decree holders, my lord. The first two, my lord, are the basically, my lord, the trustees of Prabha Khaitan Foundation, my lord. So, my lord, ideally, my lord, Prabha Khaitan Foundation, through their trustees have sued, my lord.
Because the plaintiffs have filed.
Plaintiffs, they are in the capacity of trustees, my lord, because Prabha Khaitan itself.
No, plaintiff trustee of Prabha. So in whose favor it
In
will
Prabha Khaitan, my lord, Prabha Khaitan Foundation, it's written, my lord, all trustees.
release the said amount in favor of
Prabha Khaitan Foundation.
in favor of Prabha Khaitan Foundation is not a party here.
Not a party, my lord, but they are the, my lord, Prabha Khaitan Foundation has sued, my lord, through the trustees, my lord.
But this is not a party.
My lord,
To the क्या बोला release in favor of Prabha Khaitan Foundation through the trustees named in the decree.
Lordship, may I be permitted to mention the matter, Lordship, item number 36, Lordship.
I'm extremely grateful, my lord.
Lordship, the erstwhile advocate on record has withdrawn from the matter, Lordship.
Huh?
The erstwhile advocate on record has withdrawn from the matter, Lordship. I've received the brief yesterday, Lordship.
For the plaintiff?
For the plaintiff, Lordship.
So what you want?
Lordship, not this week, if possible, Lordship. Because, Lordship,
What
I'll
you
take
want
some
now?
time.
You file the wakalatnama?
Lordship, I have sent the wakalatnama to the erstwhile advocate for obtaining the NOC, Lordship. Lordship, that matter can be
Record
kept
and
after a
order
week, Lordship.
36. What is the good name?
Lordship, Abhishek Jain.
Mr. So submits that he has instruction to appear on behalf of the plaintiff. Accordingly, he has sent the wakalatnama to obtain no objection from the erstwhile advocate on record. And after getting the no objection, he will file wakalatnama on behalf of the plaintiff. And accordingly, press for time. Press for adjournment and press for adjourn the case to some other date. In view of the submission made by Mr. So, the case is adjourned. Let the matter appear on 21st of August 2023.
I'm so grateful.